25th July. All these matters.
Mal.
This 30, 31, 33, 34, 35.
25th.
My lord. 25th.
The request of the parties release these matters on 25th of July as part of matters.
My lord.
No, deep level. Not before, above deep. Any other hearing should be under. These are part of.
Highly.
May please, Your Lordship. I beg to mention of the listing of an interrogatory application. So it's the intervention of the court is necessary. So we get the matter.
Application, what is the urgency?
So actually, what happened, Your Lordship, that there is a PIL is pending. So during the pendency of the PIL, the forest department has pursuing the construction. So that is the
Construction of what?
of the pillars of the post gate, I think, tower.
When they started this construction business?
Recently, Your Lordship.
Recently on what day?
The last week or the before week. So the intervention of this was necessary.
After summer vacation. Just after opening of the summer vacation. Yes.
A submission will late. It will be too late, Your Lordship.
In 3 days, we have already fixed the matters. Yes, after summer vacation.
May I please, Your Lordship? I beg to mention item number 8, Your Lordship. The matter may be kindly taken up after vacation.
Item number 8, delay.
Condonation.
Delay 121 days.
Yes, Your Lordship.
Yes, what do you want?
The matter may kindly be passed or may be taken up after vacation. Your Lordship.
Why?
Because the brief is not me, I am the petitioner in person.
Fine.
I am the petitioner in person. The brief is with Mr. Das. He's in Delhi.
We'll
So-
consider this application and we'll pass an order. We'll consider this application.
Obliged, Your Lordship.
May it please Your Lordship, I beg to mention item number 21 for adjournment. I have taken the
21.
yes, Your Lordship.
Delay condonation 93. Amended cost letter have been filed. Let the number come. We'll see whether any cases make out for condonation or not.
Please, Your Lordship, I beg to mention item number 25. Conducting council has some difficulty.
Office know when they're ready.
And-
We'll pass an order, let the number come.
Deeply.
May please, Your Lordship. I beg to mention item number 32, my lord. Because of personal inconvenience of Mr. Saiwala, that he could not come today for the appeal.
And both these matters will go. Adjourn. After
Exactly.
summer vacation. August, month of August.
Much obliged.
Daily list for orders item 1.
May I please, Your Lordship? I beg to mention item number 12.
12, yes.
Lordship may kindly fix the matter after vacation.
Your Lordship, I appear for the respondent.
Yes. We have it after the
No.
vacation?
No objection at all.
Okay. On a prayer made on behalf of the appellant, matter is adjourned to be listed immediately after the summer vacation.
Okay.
Okay.
Obliged.
Your Lordship, item 24 of court number 7.
Yes.
Your Lordship, here we have filed one IA for injunction and the RSA is also pending. So kindly the matter may be taken up.
You have prayed for injunction.
Yes,
Is there any urgency?
yes, Lordship. They have started construction.
Okay, have you informed the other side?
I will inform.
You inform the other side, we'll have it. Because these only urgent matters are to be taken up of 17. Okay, we'll have it. Who is for the other side?
My senior will
Okay.
contact it. Oblate.
Yes. My lord, the basic point which has been raised for adjudication is, my lord, whether a decree, my lord, which has been, my lord, given for execution can be executed in parts, because, my lord, a decree is always considered to be a composite decree, my lord. Lordship will find the impugned order at page 219, my lord.
You are the defendant.
My lord, I am the defendant. No, my lord, I am the plaintiff, my lord. He is the counterclaimant, my lord. Whose
Counterclaim has been
counterclaim
decreed.
was allowed. It was dismissed,
Okay.
counterclaim was allowed,
Petitioner is the plaintiff
my lord.
and respondent is the defendant counterclaimant.
Counterclaimant. Suit was dismissed, my lord. Counterclaim was allowed.
Now, in the counterclaim, you are alleging that it contains several parts
Yes, my lord.
and one part is sought to be executed.
Yes, no, my lord. The counterclaim, my lord, in the counterclaim, they have sought a composite decree on the counterclaim as per the schedule given in the counterclaim. Now, what happened, my lord, when that decree was sought to be, my lord, executed, then they realized that the schedule originally given in the counterclaim was wrong. Then they sought for, my lord, to amend the schedule. The schedule was amended, my lord. Thereafter, again, my lord, when the process server went there and Nazir went there and reported that lands could not be identified, they again came to the court saying that no, that this schedule was wrong, the schedule ought to be like this. And ultimately, twice or thrice, the schedule was amended, and ultimately in the year 2022, my lord, the schedule was amended, my lord.
Yes.
While amending the schedule, my lord, and my lord, if your lordship, my lord, kindly sees, my lord, in the counterclaim, the counterclaim was made on the basis of a sale deed, my lord. The sale deed reflected the schedule of the land to be old, my lord, 31 Patna number.
Have you
old
filed
31,
any appeal against the decree?
against the, my lord?
His decree.
No, my lord. That was not done somehow, my lord. We had come by way of a, my lord, revision earlier, my lord. Initially, this court, my lord, took consideration of that and stayed the order, but subsequently, that CRP was dismissed, my lord. And when that CRP was dismissed, my lord, liberty was given with a direction, my lord, that you execute the decree. Thereafter, my lord, on the basis of that order which was passed, my lord, a petition had been filed before the court below. And by the impugned order, the court said, my lord, to the Nazir, and go and you execute whatever is found. As for the rest of the portion of the decretal land, we will see later on, my lord. In my respectful submission, my lord, that cannot be done, my lord. That
Yes,
cannot be
any
fragmented.
any
my
case law?
lord. My
Any
lord.
case law?
Yes, my lord.
Yes.
My lord, there are some old cases, my lord. Very good. Welcome. Very good.
Please give the citation.
That is, my lord, very AIR 1935 Calcutta, my lord. 1935 Calcutta, page 118, my lord. In para short judgment, my lord, in
Yes.
para 2, section 39 of the CPC lays down that the court which passed a decree may or on the application of the decree holder send it for execution to another court. Evidently, the section contemplates that the entire decree and not a part of it is to be sent for execution to the other court or court. There is no provision in the Code of Civil Procedure under which a decree holder who has obtained a decree can divide a decree into several parts and execute them piecemeal in different court or in the same court.
But here the ratio is that a decree holder cannot divide the decree into several parts
My lord.
and execute them in piecemeal in different courts or in the same court.
Yes.
It is not he has not chosen to divide the decree.
So he had not chosen to divide the decree, but the learned court below the executing court
No,
says,
court
my lord,
on
because
the
the power of the court, my lord, for fragmentation, my lord, if your lordship kindly turns to, my lord, section 52 of the CPC.
Sir, don't have your seat, we'll hear you. 52,
52, my lord,
yes,
52.
yes, please.
Section 52,
Yes.
enforcement of decree against legal representative.
Hmm.
Where a decree is passed against a party as the legal representative of a deceased person, and the decree is for the payment of money out of the property of the deceased, it may be executed by the attachment and sale of any such property. Where no such property remains in the possession of the judgment debtor, and he fails to satisfy the court that he has duly applied such property of the deceased as is proved to have come into his possession, the decree may be executed against the judgment debtor to the extent of the property in respect of which he has failed to satisfy the court in the same manner as if the decree has been held against him personally. So only when it is for the recovery of money, my lord, and then, my lord, for the purpose of recovery of money, some land is thought to be attached or, my lord, executed, then only, my lord, in the case, whatever is found, my lord, could be taken for the purpose of satisfaction,
No, is it a bar for other purpose?
my lord,
This is only clarified that when you are enforcing a decree against a legal
my
representative,
lord.
what procedure will you adopt?
That
It will
is
have
my-
the same force.
My lord.
And if it's a money decree, then you can part. But where is the bar for other parts? Your main contention is
My
that
main contention is that, my lord, because now, my lord, lordship has to see, my lord, why I am telling the background of the case, my lord. My lord, if your lordship kindly comes to the sale deed, my lord, in that sale deed, my lord, that land which is purchased is given under a schedule, my lord.
Sir, Chaudhary, you know our limitation in revision.
No, my lord, we are not that much. I am just bringing it to
No
notice of the
revision.
court.
Had it been an appeal, we would have gone whole hog.
No, I am not on that, my lord.
We are only at the prima
No, my
facie
lord.
satisfaction
Yes,
whether
yes,
the
my lord.
impugned order
I know, my
has
lord.
been passed within, as per jurisdiction, as per powers conferred by the court. That
Yes,
is
my
all.
lord.
Yes. Your
And
main
if-
contention is the degree has been sought to be fragmented and one part has been sought to be executed.
That is
So,
what.
case law, this Calcutta perhaps will not help you.
My lord.
Any other?
Page number 1. If your lordship kindly turns to page number 213, my lord. That is that segment.
213.
213, my lord.
Yes, please.
At page 215, if your lordship kindly turns, my lord, to page 215 in the prayer,
215.
my lord. The decree holders have sought for fragmented, my lord, execution of the case. 215, my lord.
Just a minute. Two 115.
My lord.
Yes.
It is therefore prayed that your honor may be pleased to pass order in issue writ for execution of decree with specific direction to the civil Nazir, whatever land is found under DAG number 182 of PP number 43 within the boundary of the decreted land should be delivered to the decree holders and to submit report details regarding the remaining land, if any, cannot be delivered for the reason on the viewpoint of the ground reality. And this was the exact direction that was reflected, my lord, in the order which is impugned herein. My lord, that is why I am drawing your lordship's attention, my lord. My lord, throughout, my lord, there is a contradiction, my lord. That had not been pointed out and neither had been seen by the court, my lord.
Contradiction
lands,
where?
my lord, contradiction in respect to the lands which had actually been purchased, my lord. The lands were purchased, my lord, under Patta number 31. At page number 124, my lord.
Patta?
Patta number 31.
Okay.
Page number.
They claim, the defendant claim to have purchased this.
Yes, my lord.
Okay.
The
Then?
predecessors of the defendant claim to have purchased this land. The vernacular portion at page 124,
Okay,
my lord,
but doesn't matter. Then?
Patta number 31. If your lordship kindly comes to the, my lord, the schedule in the counter claim at page 110,
Yes.
it is in respect of lands covered by Patta number 34. And there are
Patta 34 or 43?
34, my lord. They say that old Patta 34 is now converted to new 43. And in respect of 43, they seek execution, whereas the lands which they have purchased was in Patta number 31. And that is why, my lord, there are reports today which says, my lord, by the revenue officers, my lord, that these Patna number 34, that particular revenue village is non-existent, my lord. At page number 245, my lord.
But these matters are on the merits of the decree. You
Merits of-
challenge the decree.
My lord, that decree was challenged at some point of time. It was in a first appeal here before this honorable court. That first appeal was decreed. But these, my lord, things were not pointed out.
No, what,
at any
then
point. Today,
now
my lord,
in
because
a
that is why-
revision, in a
No,
revision,
that is
can
why
we
the
go
lands,
through,
my
can we
lord,
go
could not-
back to
My
those
lord.
aspects?
My lord.
Or rather, can an executing court go behind the
We
decree?
cannot, my lord. That is why I'm saying, my lord. If
So
the
whatever is
executing
there
court
in the
cannot
decree,
go,
whatever is there in the decree, they'll execute.
yes, my lord. So decree is Patna number 34, old Patna number 34, and new, my lord, this they have said,
43,
my lord,
43.
43. So, my lord, that old Patna number, my lord, 31, which they have purchased, does not connect to this new land. That is why
You
there are no
cannot raise
lands.
this question. They had purchased 31, they had written 34 in the schedule.
My lord.
These are matters on merits.
Yes, I understand that. My lord, I have to point out to the
No,
court, my lord, I have
that
got this
is okay.
pointing
No,
out,
no,
my lord.
this perhaps would have been good point.
My lord,
If you challenge it on merits, the
My
decree
lord.
as such, the
My-
decree is not under challenge.
it's not under.
You are challenging a process adopted by the executing
Yes,
court
ma'am.
while executing the
Yes,
decree.
yes.
And we appreciate a submission that they has sought to fragment the decree and
Yes,
gone for. Okay,
Yes.
Mr. Dhar.
First of all, my learned senior friend has said that and talked about the amendment of the schedule of the decree. There was no amendment of the schedule of the decree. Your lordship, I will take your lordship to the schedule of my counterclaim. With your,
Now, how do you react? Though we may not go into the respect, but how do you react? This
there
may
is
go to
no
the root.
amendment. There is no
No, no, this
amendment.
may go to the root. What Mr. Chaudhary is trying to
Yes,
urge,
they have not
that-
preferred any appeal against the decree.
that you had purchased the different
No, my
lot.
lord. No, my lord. We even this honorable court on
Yes.
earlier occasion, my lord, page 210.
Yes.
It starts from page 211.
What is 210?
This is the order dated 22nd of May 2024.
Of this court?
This court has very much clearly stated. This is a 2-page order. This same petitioners have filed this under 227, another order of this execution proceeding.
Yes.
And paragraph 4 is my submission, ma'am. That has been recorded.
This was for what cause of action?
The earlier order that was stayed by your lordship.
No, no, what order?
This order was against the first in another mistake.
Yes, let us see the final
My lord,
directions.
Yes.
Taken to
may I just read? This is an application under 227 of the Constitution challenging the order dated 11/8/2023 passed
Okay.
by title application 3 of 2015, whereby the learned executing court, that is the learned court of the district of Dhemadi, taking into account on the non-compliance of the various earlier orders passed to the circle officer as well as the lot mandal, had directed the Deputy Commissioner of Dhemadi to look into the matter and take a necessary action. In addition to that, the SP Dhemaji was also up to a 221 section of armed force, including male and female, on payment of required cost by the decree holder as the site of the suit land. The circle officer Dhemaji Revenue Circle was also directed to depute that funded to be present and assist the civil nadir for proper execution of the decree on the date fixed. Mr. Chaudhary, learned counsel appearing on behalf of the petitioner, submitted that the learned executing court, while passing the order, had changed the schedule of the land, and as such, the said order is not at all tenable. On the other hand, so the learned counsel appearing on behalf of the decree holder, who is the respondent in the instant petition, submitted that the decree was being sought to be executed in respect of the same schedule which have been decreed by the learned trial court. In that regard, during the course of hearing, the learned counsel has placed before this court the original decree which has been passed by the learned trial court, which has been affirmed by this court, and further the amended
Affirmed
title.
means affirmed where?
My lord, affirmed, Mr. My lord, this is the corrected one under 152. Earlier, the decree was passed, but the counterclaims schedule was not given.
No, no, affirmed by this court. Was there any appeal earlier? The language employed at 212.
I can understand, my lord. The trial court. That could be that court, trial court.
Or maybe affirmed by that court.
That
perhaps.
court.
Mr.
And
Chaudhary, there was no appeal, I think. Was there any appeal in this
no
court?
amendment. We are
There
not
was a-
seeking any
There was a
amendment.
regular first appeal in this court, my lord,
Okay.
against the decree which was passed, my lord, and that was dismissed. Thereafter, the execution
Oh.
process started, my lord.
He
There
had
was no second appeal.
preferred the appeal.
No, my lord, we had preferred the.
You
appeal,
had
my lord.
preferred the appeal?
Yes, my lord. And my lord, there was, because my lord.
No, the appeal was again dismissal of your suit or declaring the counterclaim.
My lord, I am not aware, my lord.
Okay.
At that point of time. Perhaps it was against the, my lord, this not dismissal of my suit, but against the, my lord.
Counterclaim, declaring of the counterclaim.
Decree of the counterclaim. It was against that and it was dismissed. But the basic thing, if your lordship just please for 1 second, my lord, that schedule, my lord. That is why, my lord, this schedule, my lord, 2 or 3 times this schedule was amended. On the last occasion, if your lordship recollect, my lord, there was a draft decree which was given for, my lord, the rewriting of the court, my lord.
Wait, how can we recollect? We have never heard this method.
My lord, initially at some point in the earlier stage, my lord, the first time, my lord, it came up before your lordship, there was a stay,
How
my
can
lord.
you remember one case?
181 page, Lordship.
You can remember as a counsel. I remember as a counsel even now what case I had done.
I understand, my lord.
But now sitting in the chair, I don't remember any case.
My lord.
Moment I rise, I forget everything. Delete button.
My lord. Only then the memory will remain clean, my lord.
Well,
My
the
lord,
correction was
if your
made by
lordship,
the,
if your lordship kindly sees, my lord, page 170. It starts from, my lord, page 168. And the petition to that is again in the earlier pages, my lord,
We may not
163.
be able to grant relief, Mr. Chaudhary.
They had even, my lord, prayed for changing the decree as a whole, my lord, because the schedule, my lord, was wrong throughout, my lord. And even now, my lord, the officers who of the court, my lord, who go to, my lord, for the purpose of executing, they cannot reconcile the schedules, my lord. And that is how, my lord, time and again the schedules have been changed to, my lord, suit their requirements, my lord.
wrong type, my lord. I could prove from the record.
Page
Okay.
number.
Heard.
At page 174,
Yes,
lordship to see even the circle officers report, my lord. That, my lord, it is.
That is why this honorable court has ordered
On 31/8/2019, my lord.
on last occasion.
Heard. Sri G. Chaudhary, learned counsel for the petitioners who has presented this petition under Article 227 of the Constitution of India, challenging an order dated 10/6/2024 passed by the learned District Judge Dhemaji in title execution number 3 of 2015. Full stop. Also heard Sri A. Dhar, learned counsel for
Of the
the respondents. Full stop. Para. By the impugned order, comma, the learned district judge Dhemaji has directed the civil nazir to deliver whatever land is found in DAG number 182 of PP number 43 within the boundary of the decretal land of the decree holder, and to submit report on the remaining lands, if any, which could not be delivered, along with the reasons. Full stop. Para. Sri Chaudhary, the learned counsel for the petitioners, has submitted that the impugned order suffers from perversity, as the learned executing court had failed to appreciate that there was a discrepancy in the description of the land. Full stop. He has specifically pointed out that while the land claimed to have been purchased by the defendants was stated to
By the predecessor of the defendant.
by the predecessor of the defendants. He was the defendant.
No, my lord. Their father,
Okay.
grandfather.
By the predecessor of the defendants was said to be under Patna number 31, comma, the schedule in the counterclaim was stated to be and can be put to execution. full stop. He submits that the execution of a decree has to be done as a whole and not in a piecemeal manner, full stop. In this regard, comma, the learned counsel for the petitioner has relied upon a decision of the Honorable Calcutta High Court reported in AIR 1935, Calcutta 118, full stop. The learned counsel accordingly submits that there being error in exercise of jurisdiction by the executing court, comma, interference is liable to be made by this court under the supervisory powers of Article 227 of the Constitution of India. Full stop para. Per contra, comma, Sri Dhar, the learned counsel for the respondents, has disputed the factual proposition advanced on behalf of the petitioners. Full stop. It is submitted that there was no discrepancy in the description of the suit land, which was correctly reflected in the decree. Full stop.
We have no objection if the decree is as a whole is executed.
Full stop. He, while submitting, he has also submitted that the decree as such was not interfered. But are you aware of any appeal
Yes,
file?
No,
No, are you aware that there was an appeal?
no, that I don't.
Also submits that as per his knowledge, comma, the decree had attained finality as there was no appeal preferred against the same. And therefore, at this stage, comma, the respondents cannot raise any issue on the correctness of a decree in an application filed under Article 227, that too against an order passed by the executing court while executing the decree. Full stop. The Sri Dhar has also drawn the attention of this court to an earlier proceeding before this court in CRPIO 314 of 2023, instituted by the present petitioners against an order dated 11/8/2023 of the executing court. Full stop. This court vide an order dated 22/5/2024 had held that no infirmity was found in the order dated 11/8/2023 of the learned executing court in title execution case number 3 of 2015, and accordingly the petition was dismissed. Full stop. While dismissing, comma, this court had made the following observations, paragraph 7, page 212, full stop para. The rival submissions have been duly considered, full stop. The though Sri Chaudhary, the learned, though it is submitted on behalf of the petitioners that there was a discrepancy in the description of the land in question, qua the Patna number, comma, this court is of the opinion that such discrepancy, comma, if any, has to be raised in an appropriate manner and not at the time of execution, and not by an application under Article 227 of the Constitution of India against an order of the executing court while executing the decree. Full stop. So far as the citation, on the other leg of the submission, that a decree cannot be fragmented, wherein reliance has been made on the decision of Kusum Kamini Devi Supra, this court is of the view that the context under which the observations were made on section 39 of the CPC was on a different aspect altogether, wherein decrees could be executed by another court. Full stop. Para. What this court has also noted that while dismissing the earlier TRP IO 314/2023 by this court by order dated 22/5/2024, the observation was made for executing the decree in accordance with law, in which the assistance of the Superintendent of Police Dhemaji was also to be taken. Full stop. The said order admittedly has not been put to further challenge. Full stop. This court is of the concerned opinion that the powers which are required to be exercised under Article 227 of the Constitution of India, being a supervisory power wherein this court is to examine the aspect whether the subordinate court had acted within its jurisdiction and is a limited power, the instant case does not appear to be such wherein such powers may be exercised. In the considered opinion of this court, the impugned order dated 10/6/2024 does not suffer from any jurisdictional errors or calls for interference by this court. Petition is accordingly dismissed.
Obliged.
May I make a small prayer, ma'am? My lord, the next date is fixed by the trial court, my lord, on 4/7/2024 for the hearing on the execution, my lord. Now, as your lordship is aware, my lord, under section 47 or under my lord order 21, rule 97 and 100, my lord, there is a provision for filing an appeal against an order, and that executing court is taken into consideration all the aspects of the matter which was just placed before your lordship, my lord. Till my lord, if 7 days or 10 days time be given to me so that my lord I can at least agitate that point.
Order
That my lands which are actually not.
No, you are not a third party. You are the judgment debtor.
Judgment debtor, my lord.
How will those provisions of law come into operation?
Because it is
Those are
between-
only
it is
for
between
persons
the
who are
parties.
dispossessed
My lord.
by a decree where they are not a party.
My lord. Between the parties also, my
No,
lord.
will not-
Obliged.
My lord.
Okay.
We can only try.
You have done your job.
We
We
can
have
only
done our
try.
job. Huh?
I'm
17
deeply obliged.
control. Motion আছে নি? এই বাকি motion নহয় নেকি? ঠিক আছে। There is one motion of court number 17. If the council is ready. Court number 17 নেকি?
I prefer time being first of all, my lord. Item number 7, my lord.
No, 17,
Item number 7.
8.
Item number এইটো কোনটো মাতিছে?
8.
Item number?
Item number 8.
Item number 7.
Sorry.
Mohammed Das.
Yes, my lord.
Yes.
For time being, my lord, it will be first of all.
What timing? You said urgent, we are taking
Yes,
this
my
out
lord,
of
right.
turn and you are seeking timing.
My lord.
Have it tomorrow then.
My lord, my tenure.
We are accommodating you out of turn. Only urgent matter you said. We have a whole list. You have seen our list. Still then you said urgent.
Then tomorrow, my lord.
Tomorrow. Okay. List for on the no, 3 M.H. Chalukdar
Yes,
submits there is urgency. Full stop. List for motion tomorrow.
Yes.
My lord, this revision petition has been filed against the order dated 25/24 passed by the learned
Civil Judge Hamaji in Miss Case number 524, whereby the learned court in exercise of the power under section 30 TPC allowed to adduce additional evidence, that too after advancement of the argument of defendant side. Hence, we have approached the honorable court about the legality and in exercise of the jurisdiction not vested by law.
Petitioner, how many petitioners are there?
Yes, at page 85.
One petitioner. One petitioner is the plaintiff.
Petitioner is the defendant.
Defendant.
Petitioner is defendant.
Suit for? Suit for?
Declaration of right.
Declaration of right title and interest, and also recovery of possession. That was the
Right
plaintiff
title,
side.
interest and recovery of possession.
And we being defendant, we have filed a counter claim against that.
Okay, counterclaim.
Yes, yes, counter claim. we have-
And what is your counterclaim? What is the prayer in your counterclaim? Relief
Yes,
seeking?
we categorically stated that we are the owner of the land. want
No,
to
what
the-
is the relief you are seeking in counterclaim?
Yes, sir, that declaration of the right title.
You are also seeking declaration.
Yes, yes.
Okay. Then what happened?
What happened after due trial, argument was, date was fixed for argument, and plaintiff side took adjournment for 2 or 3 days. Thereafter, defendant has took adjournment. On that day, the landed court has imposed cost 2,000.
Okay.
Next day, the defendant advance, court has allowed to advance our argument. On that time, the plaintiff side took another adjournment, which court has allowed. Thereafter, the plaintiff side has filed an application under section 30,
Under section?
30 of CPC,
Yes.
which provides for exercise of the
Yes.
section 30 says, subject to such condition and limitation
Hmm.
as may be prescribed. The court may at any time either its own motion or on an application of any party.
Hmm.
There are certain conditions and limitations. The Honorable Guwahati High Court has decided.
Please read this. Please read the entire section.
Yes, sir. Make such order as may be necessary or reasonable in all matter relating to the delivery and answering of injuries, the admission of document and fact and discovery, inspection, production, impounding, and return of document or other material object producible as evidence. Issue summons to persons whose attendance is required either to give evidence or to produce document or such other object as aforesaid. And number C, under section 3, order any fact to be proved by affidavit. And this was cited by the Honorable Guwahati High Court by Justice Torana in his decision. The above quoted provision of law shows that power accessible under section 30 of PPC is subject to such conditions and limitation as may be prescribed. Moreover, subsection A of section 30 appears to be relatable to the provision of order 13 of PPC, which is for production, impounding, and return of document. Next question, sir. The provision of subsection B of section 30 of the code appears to be relatable to the provision of order 16 of the code, which is for summoning and attendance of witness. That is the contents of the Honorable Guwahati High Court. The petitioner side has not able to show that court has power to take recourse of the provision of section 30 of the code to overcome the requirement of leave of the court to admit a document in evidence as prescribed in subsection 3 of Rule 14 of Order 7 of CPC. In the present case in hand, I find.
No, we are aware of that case. That case was decided that in that case, the conditions precedent were not able to be demonstrated. Now here, you kindly show us whether the application under section 30 filed by the plaintiffs were not meeting the preconditions necessary and laid down in section 30. Kindly show us from the order.
No, sir. There is no any statement in the pleading also.
Now let us read the order.
Order.
Order it is 8590.
Order is dated 25/2024.
Yes.
Yes, please read.
What it is. Today is fixed for order. The missed case as arising out of the petition number 57/24 dated 13/3/24 filed by the advocate petitioner for plaintiff on instruction of the plaintiff under section 30 A, B and order 16 rule 6 and 7 of the CPC, hearing of CPC, did with section 151 along with copy of Jamamandi praying to call for Jamamandi book relating to the suit plan from the circle officer Dhamaji, Revenue Circle Dhamaji, to produce and exhibit the same by concerned Lakmandal. Peruse the case record at plan. The petitioner has submitted that the plaintiff has submitted an old copy of Jamabandi of the suit plan instead of recent copy is due to oversight, and the same was unintentional on his part. He has further submitted that the said document is required to be called for to review the issue whether the suit plan is bad for non-tender of necessary party framed by this court. He has further submitted that the said document is highly required to be.
Yes, yes, okay, we have read. Can we know your name? You are Mr. Mazumdar?
Right. My lord.
Dr. Mazumdar?
Dr. P.C. Mazumdar.
Okay, heard. Dr. P.C. Mazumdar, learned counsel for the petitioner, who by means of this petition under Article 227 of the Constitution of India has put to challenge an order dated 25/2024 passed by the learned, please have your seat, passed by the learned civil judge, Junior Division number 1, Hemaji, full stop. The petitioner is the defendant in title suit.
16 of it.
Title suit number 16.
16, my lord. 16 of 20.
16 of 2020, wherein they had also filed a counterclaim. Full stop. It is submitted that at the argument stage, the respondents as the respondent as plaintiff had filed an application under section 30 of the Code of Civil Procedure. Full stop. It is submitted that without going into the aspect as to whether the conditions precedent have been met by the party approaching the court, the application has been allowed, which is not the purpose and intent of section 30 of the CPC. Full stop. Para. That notice be issued returnable on 26th of July 2024. Para. Let steps be taken for service of notice upon the sole respondent by registered post to AD, steps within 2 days. Para. Dr. Mazumdar, no? Learned counsel for the petitioner prays for an interim order. Para. Considering the facts and circumstances, this court, in the interest of justice, directs that till the next returnable date, further proceeding in title suit number 16 of 2020, pending before the learned civil judge, Junior Division number 1, Hemaji, shall remain suspended. Para. The interim order, however, would be reconsidered on the returnable date on appearance of the parties. কেইবেটটো মই লিখাই দিম বাৰু কোন আছিল বা আদা চাইডত এই ধৰ আছিল ন আচ্ছা এইটো কোনে লিখিছিল এইটো বিনয় এটা ৰিচাৰ্জ কৰি দিব কেইবেট কেইবেটখন আছে এটা ঠিক আছে সেপাৰেট অৰ্ডাৰটো মাৰি দিব দিব Item number?
Item number 2, if your lordship please to take it to part.
My lord, in the second appeal, my lord, my preliminary objection is this, my lord. The substantial question law framed, my lord, in this appeal is not involved in that.
Your lordship please to see the order dated.
Mr. Das, you want us to take Ila Borthakur first?
Okay. Second. Kitari could order it. Kitari could order.
Yes, please.
The question of law that was framed here is whether the suit of the plaintiff for declaration of right and interest. The suit was for declaration of right and interest.
No,
and for recovery of position.
you are the appellant is the
It's the defendant. The defendant.
one appellant, more appellants.
More appellant.
Appellants were the defendants.
Dependent.
Suit for
Suit for declaration of right and interest and for recovery of position.
right title, interest, and
And recovery of position. Right and interest in respect of 1 bigha of land.
okay. Recovery of position. Thereafter,
Recovery. Thereafter, the trial court decreed the suit and the appellate court also decreed.
you're in concurrent findings.
Concurrent time.
Suit decreed, appeal dismissed.
Appeal dismissed.
First appeal dismissed. Second appeal also dismissed.
No, second appeal yes. It is your lordship's hands. But this is a case for remand, I see. The question of law that was framed, I have not it here.
Yes, it was framed on 2/8/2013.
Whether the suit of the plaintiff.
2nd of August 2013, the substantial question of law was framed.
Yes.
Yes,
Whether the suit of the question of law was framed
yes.
in this way.
Whether the suit,
of the plaintiff for declaration of right and interest in respect of 1 bigha of land can be decreed to the exclusion of other heirs of Ramananda in view of the pleadings in paragraph 7 of the plaint that Girijananda, the father of the plaintiff, out of 1 bigha purchased 2 kathas of land and 3 kathas of land, 3 kathas, 1 letters of land was purchased for the father of Girijananda, namely Ramananda. 3 katha, 2 katha was purchased by the plaintiff number 1.
right?
Predecessor of the plaintiff.
Other legal.
And 3 katha, 1 letter was purchased by the father of Girijananda.
Ramananda was the grandfather.
Father.
Ramananda was the grandfather.
Grandfather of the.
Ramananda. Then his son is Girijananda.
His son is Girijananda.
And Girijananda's son is the plaintiff.
Yes.
Plaintiff's name is Pranavananda.
Yes. Wife, son, and all.
Okay. Pranavananda and others. Okay. They are the legal heirs of Girijananda.
Yeah, Girijananda.
Okay. Then you say that Ramananda had other legal heirs.
Yes.
And out of this 1 bigha, 1 bigha consists of
3 katha plus 2 katha.
2 katha
Plus 3 katha.
plus 3 katha.
Hmm.
2 katha was purchased
By Girijananda.
Girijananda. Okay.
Yes.
So far as 2 katha is concerned, no problem.
No problem.
Girija. And 3 katha is by Ramananda.
Ramananda.
And you are the legal heirs of Ramananda.
Yes,
You are the legal heirs of Ramananda.
yes.
But can you exclude the plaintiffs also from the three kathas?
Mother?
If suppose assuming we accept your case, 1 bigha, there are two parts,
Yes,
2 katha and 3 katha.
yes,
2 katha is purchased by Girijananda.
yes.
His legal heirs has got this 2
Yes.
katha. And so first, as assuming what you were saying will be accepted, 3 katha was purchased by the grandfather,
Yes, ma'am.
Ramananda. So grandfather's purchase 3 katha. The present Pranabananda and other plaintiffs will also have a part of the share.
Part of the share.
Okay.
But entire one
Not,
bigha,
not 3 katha, immediate, not entire 3 katha.
not entire bigha. In that way, the plaintiff cannot get a decree for entire 1 bigha.
1 bigha. Okay.
That is the my case.
Okay.
Your Lordship, please to see the paragraph 7 of the plaint.
What
That way-
was the finding of the learned courts?
Learned Courts Bureau has not given any finding. This is a new point raised for the first time in the appeal,
In second appeal.
second appeal. But the new point can be stayed, can be raised, my lord, in respect of the pleadings and the evidences on record. In view of the pleadings and the evidences on record.
A new substantial question of law can be framed as per law. It's a part of section 100. But whether a new point, which was not even the matter of adjudication by the courts, can you raise that point in a second appeal?
Yes, that can be raised.
In the victim statement,
If-
no
if-
present age, then they are not a legal heir. They are not a legal heir.
Okay, we'll come. Nothing to be agitated, we'll come to you. We are trying to interact with Mr. Das. If Mr. Das 100, section 100,
Yes. If you sit down.
five proviso. Proviso to subsection
Nothing
5.
in the server shall be deemed to take.
No,
into
no,
a breach.
section 100, so proviso to 5,
Yes,
provided.
provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear for reasons to be recorded and appeal on any other.
On any
subsection
other substantial questions of
not
law.
formulated by it, if it is satisfied that the case involves such question.
So this is only on a new substantial question of law which we can frame at the time of hearing. So that will not, may not include a point which was not even the matter of adjudication by the courts.
No, your lordship of subsection 1, if your lordship
Yes.
please to see it. An appeal shall lie to the High Court from every decree or order caused in appeal by any court subordinate to the High Court, if the High Court is satisfied that the case involves a substantial question of law.
Correct.
So if the court is satisfied, whether that a substantial question of law is involved in the case, may not be that it was agitated, may not be there is a finding in it. But if it appears from the records of the case, the such question can be raised and was framed by at the time of admission of the appeal. Can it not be heard?
No, it can be heard if it can be inferred from the pleadings.
Yes.
But we are here to only to see the correctness, prima facie, of the findings arrived at by both the courts. We will not go back. If an issue was not specifically formulated, but there are pleadings and there are findings, we can go to the extent of correctness of the findings. But
Yes.
other than the correctness, we cannot again take the role of a first appellate court, again go back to the evidence.
My lord,
Our limitations are there.
that is correct. But my lord, a new point arising from the pleadings of the parties
In a second appeal,
in a second appeal can be taken.
Yes, kindly
Even in
show.
the Supreme Court.
Kindly
can
show.
take. My lord, 71. Good. More. AR 71 Supreme Court 2018. I am giving a copy to you.
please, AIR
71 Supreme Court
1971 Supreme Court,
2018.
2018. Name?
Name to কি আছে মুখের কপিতে কোর্ট দিয়া
Sir Kaushik, what is the name?
name is
My lord, it's State of Rajasthan versus Rao Raja Kalyan Singh.
State of Rajasthan versus Rao Raja Kalyan Singh.
Okay. Maintainability. Paragraph?
3, 6 and 9. Yeah, 17 court. 17 court.
No, where is it in the second appeal?
3, 6 and 9. So, 6 says those issue is not very specific. Ultimately, it covers the plea taken by the respondent in paragraph 1 of his written
No, is it in the second appeal? Number 1. Number 2?
Yes.
Number 2, where do you get? Number 2, the point is of maintainability.
That is, of course.
It's a purely legal point.
This is also a legal point that whether he can get
It's
a
a-
plaintiff can get a decree for the entire.
No, this point, all points are legal, but this will require adducing of evidence that this land.
No, it will not require any evidence.
No. If you cannot say that the land, 3 katha of land was initially purchased by Ramananda, and you are the legal heirs, these are matters of evidence.
No, this is an evidence fact because in the paragraph 1 of 7 of the plain, he has stated it.
The plaintiff.
Yes, plaintiff himself.
What has he stated? Let us
Paragraph 7 of the plain.
page.
Page কত? Page 11 better.
11.
11.
Yes. Yes.
And it has come out on evidence of
Let's
the
read,
plaintiffs and the defendant.
1 bigger. Hospital 2 kathas
The only question is that his name was mutated. Girijanda's name was mutated in respect of 3 kathas of land.
But we haven't heard Mr. Sahiwala. What had fallen from him that you are not even legal heirs? That is what you are contending.
No, I am a legal heir of one of the daughters of Ramananda. He had only one son, 3 daughters. We are the legal heirs from one of the daughters. This has come out in evidence. In fact, in the pleadings in para 4, if you please to see, page 10, para 4.
Based on para 4.
Our own nephew of late Girijananda purchased.
Was there a counterclaim?
No, there was no counterclaim.
So how do you assert your right?
Actually, the WS was filed contesting that they had taken on lease, but claimed adverse possession. That was negated. But it also came from the pleadings and the evidences on record, particularly PW 1-2 and DW 1-2, that the defendants were one of the legal heirs through one daughter of Ramanand.
So was there a claim, specific claim that as a legal heir, you have a right to the portion? That was not there. Not to talk about counterclaim, even in the written statement is not there.
Counterclaim is not.
But you say in paragraph 4 and paragraph 11.
Yes, paragraph 4
11 has
7.
categorically stated that one portion belonged to Ramananda.
Yes.
It's a different matter that Girijananda's name was mutated.
Yes.
On the strength of it, he's seeing a declaration.
Yes.
And secondly, in paragraph 4, you say that your relationship has been accepted.
Yes.
And that's a different matter. The explanation was given as a permissive possessor.
Yes.
You are allowed to possess that land. And when he was in need of the land, he had asked you to vacate. That is the pleaded case. Okay.
But I want to place before your lordship another judgment of this honorable court.
Please, please.
79 AR 79 Guwahati. Yes. Page
No, first in the case we
71.
get first cited 71.
71.
Where is it that it was a decision in a second appeal?
Good. So, no, it was not a second appeal.
There is no, you cannot decipher.
No.
This from it might have been, we do not know, but it's not net.
But the first appeal was before the High Court.
Maybe.
Paragraph 3 states.
Yes.
Paragraph 3.
Yes.
Trial court partly decreased the suit. It was
Yes.
held that the district
Yes.
court was not entitled to claim transfer. In appeal, the High Court dismissed the
Yes.
answer.
Okay, next decision.
Photo 79 Guwahati, AR 79 Guwahati, page 10. Paragraph 19 and 20. This is a second appeal.
Golaknath Kakoti.
Yes,
Paragraph
19 and 20. 18 and 19. 19 and 20. Judgment by B.N. Sharma, it should be J.N. Sharma.
No. It
Huh?
was B.N. Sharma only. Honorable J.N. Sharma was the counsel. 79, Justice J.N. Sharma was not a judge.
Yes,
B.N. Sharma, Bholanath Sharma.
B.N. Sharma.
Okay. Please read.
Paragraph 19, Mr. Sharma, learned counsel for the appellant, challenged the decree of the lower appellate court on yet another ground, namely that the suit filed by the Registrar of Calcutta University is not maintainable. Mr. Sharma further submits that although this plea was not earlier taken on behalf of the appellant before any of the courts below, he is entitled to take this plea for the first time in the second appeal, as it is a legal plea. In support of his contention, he relied on the decision of the Supreme Court in state of Rajasthan, so and so. One thing. This paragraph 20, that being the legal position, the appellant cannot be debarred from taking the plea.
Non-maintainability.
That is.
Non-maintainability.
Of course, it is on the ground of non-maintainability.
Non-maintainability.
Supreme Court की बात है हाँ Supreme Court ना तुम्हारी जीती थी 2014 और हाँ what did you do? My next case is 2014 2 SCC 269. 2014 2 SCC 269. This is party's name is Union of India and others versus Vasavi Cooperative Housing Society. Paragraph 15.
This is on the aspect that Jamamandi or records of right will not confer any title.
Yes.
These are settled.
Otherwise also, the plaintiff is to prove his own case.
Own case.
And cannot
Depend on the weakness of the defendant.
weakness of the defendant. Here, Madam, something is there that
Yes.
paragraph 17 says the revenue record does not confer title.
Yes.
Here, it was part of the mutation record was placed by plaintiff, show that mutation situation. Girijan, I'm sorry, I forget sometimes.
No, doesn't matter. What is it?
The Girijan's name was mutated in respect of Tikathalona.
Okay, Girijananda.
Girijananda. That was his claim, and because of that, he 3 kata plus 2 kata, all purchased land, it was declared in his name. He got the decree. In paragraph 17 of this judgment, it says that revenue records do not confer any title.
Yes, that's it. Okay.
No. And my celebrated case of Santosh Hajari, 2001, 2001, volume 3, SCC 179.
Again on the same aspect.
No, it is something else. That justice is to be done. What paragraph? Paragraph 14. I more correct. Figure 14.
Paragraph?
Yes, 14.
Paragraph 14.
Right. Huh? Okay. Okay.
Okay. What does it say? Santosh Azadi? Which paragraph?
No, no. Paragraph 14, madam.
1-4.
1-4. This is about the question of law that is to be required to be framed.
Yes.
But the last line says, it will therefore depend on the facts and circumstances of each case, whether a question of law is a substantial one and involved in the case or not. The paramount overall consideration being the need for striking a judicious balance between the indispensable obligation to do justice at all stages and impelling necessity of avoiding prolongation of the life of any dispute. The first few lines, it says about the question of law that is to be framed. And what is the question of law in section 100? Definitely it is not of general importance. But the last line says, the paramount overall consideration being the need for striking a judicious balance between the indispensable obligation to do justice at all stages. Therefore, the question of law that has been to be framed, whether it requires to be framed in the facts and circumstances of the case. That takes in within its fold a new point also. That is my submission. And my lord, while all the courts below, both the courts below, while deciding the issues of right and interest of the plaintiff, had considered the pleadings of the parties and the evidences on record, which says, my lord, that the defendants are also the legal heirs of Ramananda through one daughter. They are the nephews. Okay. If you will also please to see what are the evidences part.
Okay.
Evidence part, my lord. Copy has not.
You want to read the evidence?
Only some portion.
Record. Dekha. Dekha. Record.
PW2.
Record. Record.
Of the records, my lord.
Yes.
Your lordship has taken. I have taken a copy. Copy has not. I have a copy has not.
You can read slowly. We are recording it. No problem.
PW2 is Vivekananda. Okay. Paragraph 2. It says about that Ramananda purchased 3 kathas and Girijananda purchased 2 kathas. 3 kathas and 2 kathas. In cross examination,
Yes.
Oh, yeah. PW2. In cross-examination, last part, it says that truth land consists of 1 bigha, 1 lecha. Koni, Nipen, Ganen, and Noren. They are 5, 6, 7, and 8, 8 and 9. Dependent number 5, 6, 8, and 9 are my cousin brothers, and they are the nephews of my father, that is Girijananda. Then DW2 and DW1. DW1 to be up. Elaborate. There are two evidences of dependent number 1, because in the title appeal also evidence was taken. Additional evidence was taken.
By the first appellate court.
Was the first appellate. প্রতিবাদী পক্ষ প্যারাগ্রাফ 2 প্রতিবাদী পক্ষগণের পূর্বাধিকারী গিরিজানন্দ ভট্টাচার্য এই শপথকারীর মামা শ্বশুর হয়। This is in chief. In paragraph 5, in one place it says, এই শপথকারিণী হাহু আই ভারতী দেবীর সহি জাল করি প্রদর্শক ঘ পৌর কর্তৃপক্ষের ওসরত দাখিল করি ভুল তথ্য দাগি রয়েছে। I am not on the other part. এই শপথকারিণী হাহু আই ভারতী দেবী। হাহু আই is Bharati Devi. Bharati Devi is one of the daughters of Ramananda. And Mama Huri is Girijananda. These are the things, madam. Therefore, the plaint and the pleadings and the evidences on record justify that there were other legal heirs also Ramananda. Therefore, when you are claiming right to interest in respect of the suit property, therefore you must have a clear title on the property, not based on any revenue record. This aspect was not gone into. Therefore, I would humbly submit that this matter relates to remand before the appellate court, so that the appellate court can look into this and give a finding whether he is entitled to the entire decree for the entire 1 bigha of land. That is the question.
The title having devolved upon him by inheritance, that was proved.
By inheritance, but a certain share, not the entire land.
No, that's a different context. Whether he becomes the absolute owner or one part, he will also have a right. But can you go back to the aspect that whether he could able to prove his title in interest? Because it was not by any deed. His title has flowed to him by way of inheritance.
Yes.
That was
but
proved.
in respect of not the entire land.
And that is okay. That we have appreciated.
That is my issue, madam.
Okay.
That is my not
No,
the entire land.
No, if you are since you are taking up the issue that it's the Jamabandi which was the basis of declaration of title. Jamabandi was not for declaration of title. Jamabandi is only to ascertain the possession.
Yes.
On the basis of Jamabandi, title cannot be declared.
No, no.
He is
Even
seeking-
mutation cannot be did.
He's seeking declaration on the basis, on the strength of inheriting the land from his predecessor.
Inheritance. But if there are other legal heirs,
Whether
he
it could
can
have to
claim,
be shared. Yes, yes,
that is the whole question.
yes.
he
Yes,
can-
Mr. Sayola.
My lord, what the treated case of the parties, my lord. If your lordship see, my lord, the defendant case is based in para 17, 16, page after the year. That's the only case.
Page.
Page 16, para 16.
Yes, please read.
The answering defendant had to submit that left Nathan Chaudhary, who was the father of defendant number 8 and 9 and father-in-law of defendant number 1. Left Nathan Chaudhary took total 1 bigha, 1 lecha on lease for 12 years from the partner. Nathan Chaudhary expired before the term lease is over. Let Nathan Chaudhary and his elder brother, let Upen Chaudhary used to live and manage the Moja office therefrom, and let Nathan Chaudhary obtain holding and was paying minister taxes. But later, Girendra Bhattaji fraudulently cancelled the holding of late Nathan Chaudhary. Nathan Chaudhary died in the year 1943. After his death, Bharati Devi, wife of Nathan Chaudhary, whose minor sons used to live in the Scotland till today without any break. He submitted that Pani Chaudhary, the eldest son of Nathan Chaudhary and husband of defendant number 1, celebrated his marriage from the residential house over the Scotland in the month of 30th April 1977. And from the following day, let Pani Chaudhary was living in the Scotland with his family. Pani Chaudhary expired in the year 1998. After his death, his wife and children, the defendant number 2, 3, 4, are living there on the suit, constructing the houses there on 2008 break. The defendant number 8 got married on 27 March 1990 and defendant number 9 got married in the month of August 1982. And since then, they have been living there on a suit with their family members. The dancing defendants are paying the land revenue of the Scotland. The signature of late Bharati, wife of late Nathan Chaudhary, sister of Girendra Chaudhary, was obtained fraudulently to cancel the holding of the house, where defendant number 1 is living with family members. The plaintiff does not disclose this position, discontinuation of the position, or any break in position of the defendant. Defendants have perfected their title to adverse position about the Sultan. This is their case, my lord. And that is a case decided by both the courts below. They found, my lord, that the adverse position has not been proved. They never, my lord, claim anything, my lord. A new case cannot be made out. Even 61 Supreme Court stage, my lord, appellate courts could not make out a new case which was not treated by the party, my lord. AR 1961, Supreme Court 1097. There are many other cases also. This is a very old case.
Paragraph.
That's now one copy, my lord. My lord, yeah. Mother in envelope 2008-17 at 491. There are 10 11. 10 11.
10 and 11.
10 and 11, my lord. Your lordship, I'm
Just a minute, please.
at page 490. High Court in this case, in Stockholm, they are also got
Please
to
read.
cut the delay hardship may ensue by delegating the plaintiff to one or more grounds of litigation has entered a judgment which violates the several fundamental rules of civil procedure. The rules pleaded are no amount of evidence can be looked into upon a plea which was never put forward in the plea. A question which did not arise from the pleading and which was not the subject matter of an issue cannot be decided by the court. This is clear, man. A court cannot make out a case not pleaded. The court should confine its decision to the question raised in the pleading, nor can it grant relief which is not claimed and which does not flow from the facts and cause of action alleged in the claim. A factual issue cannot be raised and considered for the first time in second. 11. Civil procedure code is elaborate codification of the principle of natural justice to be applied to civil litigation. The provisions are so elaborate that many a time fulfillment of the procedural requirement of the code may itself contribute to delay. But anxiety to further delay and to further litigation should not be a ground to cloud the affair. My humble submission.
The one that page is missing.
Hello?
Second page is missing.
Oh, I'm giving it.
Can you give your copy?
Next side, my lord, I think. Your lordship may just my single side not there. I'm just giving the paper. I'm sorry, my lord.
Just check. I did not find. Just
Yes,
check.
yes, my lord. Maybe, my lord. Yes. My lord, my peon has wrongly
That
done.
doesn't matter.
Yes.
Respondent.
That your lordship has compared. They have admitted our title, my lord. They say plaintiff's title is extinguished by adverse words. This is their case. Humble submission, my lord, the successor person law, my lord, not involved in this case. And both the courts below have found, my lord, they failed to prove any adverse. There is no pleading at all for adverse person, except writing the adverse.
Okay.
Well, in reply, I may say, my lord, that whatever my learned friend has cited is not applicable in this case because it is not a new case. My lord, I have omitted to cite one case law which appears 2010 to STC 407. I am giving a copy to your lordship. 2010 to STC 407, paragraph 17 and 18. Here in the second appeal, a new issue was raised, and that was the point of challenge before the Supreme Court. Paragraph 17, madam. As to the issue raised by the appellant that the High Court was not justified in permitting the respondent to raise a new plea for the first time in second appeal, we may at the outset note that would not find any substance in the contention raised by the learned counsel for the appellant. They contended that the High Court committed an error in considering the new ground of challenge without any plea or factual background, neither before the trial court nor the first appellate court. The new plea, which was already raised before the High Court for the first time was that all assets and farm, including the land and buildings, shall be dealt with under Section 48 of the Act. That is with regard to the factual matters of that case. Paragraph 18. That apart, when the question of law is raised on the basis of the pleadings and evidence on record, which might not have been raised before the court below, it is difficult to hold that such a question of law cannot be permitted for the first time before the High Court. That question was raised because it arose out of the pleadings and the evidences on the record, but the High Court had dismissed the plea, dismissed the Perfect. Oh, perfect. Right. Well,
My lord, one thing I must complete, my lord. It must come up from pleadings. No evidence which is beyond the pleadings can be looked into, my lord. Pleadings, my lord, your lordship, my lord, their pleadings is only a draft, my lord. Nothing more.
Okay. এটা দিদিও না কি করব? The instant appeal has been preferred under Section 100 of the Code of Civil Procedure, challenging a judgment and decree dated 26/2/2013, passed by the learned district judge, Nalbari, the entitled appeal 8 of 2007. Full stop. The first appellate court, Vide, the impugned judgment, has affirmed the judgment and decree dated 30/3/2007, passed by the learned civil judge, Nalbari. Not in title appeal, it should be title suit, I think. In title suit. Suit was 8 of, what was the suit number?
8 of 2000, sorry, my lord. It is 8 of 2005.
8 of.
Oh, sorry. I'm
In
sorry.
the cost title, you have written
No,
title
no.
appeal, Mr.
That is not
Kaushik.
there. That is not there. My lord,
Title
it
suit,
is 8 of 2005.
title suit number 8 of 2005. No, in the cost title is written
What
title
title they
appeal.
have wrongly mentioned as appeal.
Appeal. Full stop. The appellants were the defendants, and the suit was instituted for declaration of right, title, interest, and recovery of possession. Full stop. Para. No, para. This court, Wide order dated 2/8/2013, had framed the following substantial question of law. Order dated 2/8, substantial question of law to report. Para. I have heard 3. B.C. Das, learned senior counsel for the appellants, assisted by Sri B. Kaushik. Full stop. I have also heard 3. G. N. Sahewala, learned senior counsel, assisted by
Yep.
Miss K. Bhattacharya for the respondents. Full stop. Para. Sri Das, the learned senior counsel, has submitted that the impugned judgment of the first appellate court, which has affirmed the judgment of the trial court, has not taken into consideration the materials which were discernible from the pleadings. Full stop. it is submitted that the suit land was suit property was a plot of land measuring 1 bigha, out of which 2 katha was purchased by the predecessor in interest by the predecessor in interest of the plaintiffs, and 3 katha was was purchased by one Ramananda, who was the father of the predecessors in interest of the plaintiffs. Full stop. It is submitted that the defendants are also the legal heirs of Ramananda, and therefore both the trial court and the first appellate court had erred in decreeing the entire suit land in favor of the plaintiffs without going into the aspect of the share of the defendants, at least on the portion of 3 katha which was purchased by Ramananda. Full stop. The learned senior counsel has taken has drawn the attention of this court to the pleadings made in paragraph 11 of the plaint to contend that the aforesaid aspect was admitted by the plaintiff that Ramananda had owned 3 kathas of land, which is a part of the suit land. Full stop. The senior counsel has also submitted that though the learned trial court as well as the first appellate court had decreed the suit, the aspect that the defendants were the legal heirs of Ramananda and therefore had a right at least over 3 kathas, which was a portion of the suit land. Line 2 qua. Aspect has been overlooked. Full stop. It is submitted that when a clear case is made out by the pleadings, it was incumbent upon the learned courts to formulate an issue and decide the same. Full stop. He submits that by the said inaction, the plaintiffs cannot be precluded, the appellants cannot be precluded from raising this point, which should clearly form one of the issues between the parties. Full stop. It is submitted that it is only when there is a dispute on certain factual position, an issue is required to be framed, and in the interest of justice, this court, being an appellate court, can go into that aspect. Full stop. The senior counsel has submitted that even otherwise, the issue being apparently available from the reading of the pleadings, the matter can be remanded back to either the first appellate court or to the first appellate court to decide the same on the aspect as to whether the decree could have been passed in spite of the fact that the defendants were the legal heirs of Ramananda. Full stop. Para. The learned senior counsel for the appellants has relied upon the following case laws. Case law more kori, Para. Per contra, comma, SHRI Sahewala, the learned senior counsel for the respondents, has submitted that issues are formulated based on the pleadings of the respective parties. Full stop. By drawing the attention of the court to the written statement, comma, more specifically, the pleadings made in paragraph 16 and 17 thereof, comma, the learned senior counsel has submitted that 16, not 17. 16 only, 17 is 16, 17, 9, 16 thereof. The learned senior counsel has submitted that the plea of defense of the defendants was of adverse possession. Full stop. It is submitted that the specific pleading was that the plaintiff had not disclosed dispossession or discontinuation of possession or any break of possession by the defendants, and they had perfected their title through adverse possession. Full stop. It is submitted that the plea of adverse possession was one of the specific issues which was formulated, namely issue number.
That directly, my lord, that is not the same, but it has been considered.
While considering number 7 and 8 was that.
7 and 8, my lord, plaintiffs were attacked in the
Pleading of defense of adverse possession was taken into account, and accordingly, issue numbers 7 and 8 were formulated and answered in favor of the plaintiffs and against the defendants. Full stop. Para. The senior counsel for the respondent has submitted that though it is correct that in the plaint, more particularly in paragraph 11 thereof.
Paragraph
7.
No, plaint 11.
7.
7.
Page 11.
Paragraph 7 thereof. Correct. 7 thereof. There is an admission of the relationship, comma. That admission has nothing to do with the claim of the plaintiff vis-a-vis the defense taken by the defendants in the written statement. Full stop. Para. The senior counsel for the respondent has submitted that a second appellate court cannot go into the aspect of a new case altogether, and there cannot be any reappreciation of evidence. Full stop. It is also submitted that this court, in exercise of jurisdiction under section 100, cannot go beyond the pleaded case of the parties. Full stop. He further submits that in fact, no substantial question of law is involved in this appeal and the appeal in this appeal which ought to be dismissed. Full stop. Para. In support of his submission, comma, the learned senior counsel for the respondent has relied upon the following decisions. Huh? 96 to para. In his reply, in his rejoinder, comma, Sri Das, the learned senior counsel, has submitted that if the facts and circumstances require, comma, in the interest of justice, a new question of law can be raised and adjudicated even at a second appellate stage. Full stop. In support, comma, he has cited the decision of the Honorable Supreme Court reported in so-and-so. Full stop. Para. The rival submissions have been duly considered and the materials before this court, including the LCR, have been carefully perused. Full stop. Para. The learned trial court had formulated 10 numbers of issues, and the issues which are relevant for the purpose of this appeal are issue numbers 7 and 8, which are extracted herein below. Full stop. Para. The primary contention of the advance on behalf of the appellants is that so far as a portion of the suit land is concerned, namely 3 katha, comma, they also claim to be the legal heirs of Ramananda and therefore entitled to a part thereof. Full stop. The aforesaid submission is also sought to be supported. No, the appellants has also sought the support of the pleadings made in paragraph 7 of the plaint, wherein the relationship has been admitted. Full stop. The claim made in this appeal is that the aforesaid aspect was not even gone into by both the courts, and therefore it is a fit case wherein remand may be made in the interest of justice. Full stop. The pleadings which are relied upon by the appellants, namely those made in paragraph 7 of the plaint, discloses that the plaintiffs had indeed admitted the relationship, admitted that the defendants are the relatives and legal heirs of Ramananda. Full stop. However, comma, it is to be seen whether such a statement would amount to an admission to the point involved in the lease. Full stop. The suit was instituted for declaration of right, title and interest and recovery of possession. Full stop. It is specifically pleaded that while 2 katha of the suit land was purchased by the father Girijananda, which the plaintiffs has inherited, comma, the rest 3 katha was a doe purchased by Ramananda, had devolved on Girijananda, and thereafter upon the plaintiffs, full stop. It is submitted that nowhere in the written statement any plea was taken by the defendants that they are entitled to a share of the shootland on the basis of being relatives of Ramananda, full stop. Rather, comma, as noted above in paragraph 16 of the written statement, there is a clear claim that the defendant had taken the defense of adverse possession, full stop. The courts below had answered the aforesaid point through issue numbers 7 and 8, and had come to a finding that the defense projected by the defendants of adverse possession could not be proved, and therefore the suit was decreed in favor of the appellants, full stop, in favor of the plaintiffs, plaintiffs, full stop. Para. This court, in exercise of the powers conferred under Section 100 of the Code of Civil Procedure, would not make a roving inquiry into the aspect of reappreciation of evidence, and it is only on availability of a substantial question of law which would be answered, full stop. In the case of so-and-so, I don't pass the PG board case to DD, so-and-so, para. Under the aforesaid settled principle, comma, let this court examine the application of the case laws presented by the parties, full stop. The case of Rao Raja is, itself states that the question which was raised was purely a legal point of maintainability, full stop. It is further not discernible as to whether such observation was made qua the exercise of powers under Section 100 of the CPC, full stop. In the case of Golaknath Kakoti, comma, the point was similarly on the aspect of maintainability, and that plea was allowed to be taken, full stop. The case of Basabi Cooperative Supra is on the aspect that the plaintiff is to prove his own case and not depend on the weakness of the defendant, and further that a Jamabandi or any records of right would not confer any title, full stop. There is absolutely no dispute with the aforesaid proposition, full stop. However, in the instant case, comma, it is seen that it is not on the weakness of the defendant that the suit was projected or argued, but the pleaded case of the defendant that a defense of adverse possession was taken, full stop. The issue of Jamabandi was only to demonstrate the aspect of possession, and the title had devolved upon the plaintiff by inheritance, full stop. In the case of Muhammad Liaquat, Supra, the Honorable Supreme Court had made an observation that a new question of law can be raised in a second appeal. Full stop. However, in paragraph 18, it has been clarified that the issue involved has to be one which is a pure question of law. Full stop. In the instant case, the issues framed and answered are based on the rival pleadings, and the decision arrived at appears to be on the basis of the materials before the courts, including the evidence. Full stop. In the considered opinion of this court, the present is not a fit case for exercising jurisdiction under section 100 of the CPC. Full stop. Appeal is accordingly dismissed. The substantial question of law framed is answered in favor of the respondent and against the appellants. Send back the records. Okay.
Well, there is a revision, my lord, also.
Revision for?
Revision, my lord, against the order of the executive court, my lord. Here.
Who had filed?
Same case.
Who is the petitioner?
I'm the petitioner.
Regarding?
I'm the petitioner. Because before the executive court, my lord, here what happened, my lord? In the schedule of the property, they will also see.
No, is there anything to be decided now in the revision?
Yes.
No.
Yes. Yes. My lord, here what happened?
In view of the dismissal of the appeal?
No, dismissal of the appeal in spite of that, my lord.
You still have a problem in execution?
Yes, yes.
Okay, what is your problem?
That
Because this revision arises out of the stay order of this honorable court in second repeat.
Where is the impugned order?
Yes. Page 11, my lord. In the certificate copy of the order of the Gujarat High Court, High Court directed the
No. What High Court report? High Court report.
directed the executive High Court to remain in Kolkata plan in view of the state order of the Gujarat High Court decree holders file instant petition for execution of the recorded cast.
No, we'll vacate this order of 6/12/2013 and ask the executing court to go ahead with the decree.
Yes.
Because the court has rightly observed, when his appeal was admitted and there was a stay, because his claim is on one portion of the suit land, and that was taken into consideration.
Yes.
Heard Sri G.N. Sahewala, Learned Senior Counsel, assisted by Ms. So-and-so, for the petitioner. Also heard Sri B.C. Das, Learned Senior Counsel, assisted by so-and-so, for the respondents. Full stop. The instant application is filed under Article 227 of the Constitution of India, challenging inter alia, an order dated 6/12/2013, passed by the learned civil judge Nolbari in title execution 3 of 2013, full stop. By the impugned order, the execution petition was dismissed by taking into consideration an order dated 2/8/2013, passed by this court in Miss Case 1461 of 2013, arising out of RSA number so-and-so. Connected, huh? Para? The aforesaid RSA number so-and-so has been dismissed today by this court. Full stop. This court is therefore of the opinion that there would be no impediment for the executing court to execute the decree in question in accordance with law. Full stop. The provision accordingly stands allowed, and the impugned order dated 6/12/2013, passed by the learned civil judge so-and-so in title execution so-and-so, is satisfied.
Much. Like,
মই কেছ লগ এটা দি দিম হা এইখিনি তাতে দিব লাগিব
Wait, please, Your Lordship.
Please.
Your Lordship, we have filed this appeal basically on the ground that the driver was holding a private driving license, Your Lordship, that was issued for 12 years, and he was not authorized to drive any commercial vehicle.
Why did it have it come for admission? There was delay condemnation.
Yes, Your Lordship, delay has
Delay has
been
been
condoned.
condoned.
Yes, Your
Okay.
Lordship.
Come for admission first time.
Yes, Your Lordship, has come up for the first time.
P. Borthakur
Yes, Your Lordship.
heard Ms. P. Borthakur learned counsel for the appellant who has preferred this appeal under Section 173 of the Motor Vehicles Act, challenging judgment in order dated so and so. What are your grounds?
Lordship, basically, we have filed this appeal basically on the ground that the driver was holding a private driving license, Your Lordship, issued for 12 years, and he was not authorized to drive any commercial vehicle.
Policy conditions violation.
Yes, Your Lordship, there was violation of
The
policy
learned
conditions.
counsel has submitted that there was violation of the policy conditions with regard to the in as much as the driver involved had a license for private vehicle,
Yes, yes.
whereas the vehicle involved was a commercial vehicle.
Commercial.
Put the para, admit, call for the records. Did they appear in the delay condemnation stage?
Lordship.
Did the other party appear in the
Yes,
delay
Your Lordship,
condemnation stage?
respondent number, in this case, Your Lordship, respondent number 1 has expired. And in his case, respondent number 4 was already a party. He was the son, Your Lordship,
No,
so
no.
he was implicated. And
In the
respondent,
delay condemnation stage, did they appear? Any counsel appear?
respondent number 2 has filed your wakalatama but did not appear, Your Lordship.
So you have to take steps.
Yes, Your Lordship.
Steps, usual process within two days. List of the 6 weeks along with report on the receipt of records.
Lordship, there is an I for sale.
How much amount?
Your Lordship, we will, the award was 22 lakhs 4,000, Your Lordship, and we will deposit the entire amount, Your Lordship, subject to certain corrections, Your Lordship, regarding the conventional head part, Your Lordship. Under the conventional head, 1,80,000 has been awarded, Your Lordship.
We'll not make deduction at this stage. You deposit 50%, let them come. Okay.
Yes, Your
50% of state. Stake subject to deposit in the registry. Or the prayer for release of the amount by the claimant would be considered as and when such deposit is made. Highest is disposed of.
Obliged.
No, when you admit appeal. Appeal admit I dispose of. We see a new counsel in the court, Mr. Chandok. No? We see a new counsel in the court.
Yeah.
You have some matter?
Yes.
Which one?
19.
19?
Yes.
Let us hope it reaches. Yes.
I'm the applicant in this case.
For enhancement?
Enhancement.
Okay. How much has been granted?
Court has granted 7,37,000.
How much is your claim? How much is your claim, madam?
35 lakhs.
35 lakhs, yes. Oh, your name, madam?
AG Chaudhary.
Heard Miss A.G. Chaudhary, learned counsel for the appellant. Injury case,
Injury case, your lordship.
who has preferred this appeal under section 173 of the Motor Vehicles Act with regard to the judgment and so and so, full stop. The appellant has prayed for and is aggrieved by the adequacy of the award, full stop, para, admit, call for, Yes, Mr. Saikya?
Time for respondent number one. My name is not shown.
Okay, is this Saikya for respondent number one? You have got copy?
Yes, today.
Okay. Steps for service of notice upon the other respondents be taken by usual process. Steps within 2 days, second. A list of the 6 weeks along with a report on LCR. So, name of Sri A.J. Saikya, learned counsel for the respondent number one, be reflected in the court list. Okay.
This is an appeal filed by the insurance company on interest. Standard member calculate the interest on wrongly, lordship. Therefore, lordship, we have filed this appeal. They have claimed the interest of rupees 4,04,160, lord.
Just a minute, please.
And as per calculation, lordship, they are entitled for 90,312.66.
Just a minute, please.
Yes.
I go to this. I go to the action. Who is the I go filter. I think there is some problem here. Put ki mari se to. Put it to. This is not your case. Yeah, it would really good to say to it. It would double easily. Kyo is it? A.J. Chaudhary de matter kori le.
Item number 7, MSC appeal number 248 of 2020. Lordship, this is award. We have filed this appeal, Lordship, mainly on wrong calculation of interest purpose. Award was passed and we have satisfied the award, Lordship. Against that, the claimant filed an application and that this amount of rupees 4,04,160 they are required to get. So accordingly, we have filed an objection to that, and learned member directed us to pay the interest, which is not tenable in law, Lordship, because interest is calculated at the compound rate of interest, Lordship. Yes, Lord. Yes, Lordship. 9,52,000. Lordship.
You are aggrieved by the order
Yes, Lord.
passed. Okay.
Lordship.
We'll admit this. You'll be appearing for the claimant.
Yes.
Heard Miss M. Chaudhary, learned counsel for the appellant, who Are you required to file an appeal?
Lordship, because we have filed and reviewed their lordship, that was dismissed.
Thereafter,
Thereafter, we filed an appeal along with challenging both the orders.
initial order also?
Yes.
Okay.
We are not on main quantum lordship, we are on interest calculation of it.
Will appeal lie?
Because lordship review that was not our, is not entertained lord, that was this.
Yeah, appeal
Along with the-
under 173, what is the language employed? Motor vehicle section. Motor vehicle section. It is only against an award. We don't
Award is
think-
also interest part is there lordship, along with the,
No, see, interest was enhanced in an application filed by them. You are aggrieved, you file a review dismissed.
lordship.
Then where is the provision of appeal? I think you have to either file 227 or 27 is the only remedy, I think. We wanted to check whether it's against any award or any order. Order is not written here. It's against an award, has to be against an award.
It is, yeah. We have challenged both lordships.
No,
Award-
initial award, you have said that you are not aggrieved.
No.
You had honored, but only on the
Yes, part of
on the
interest.
aspect of interest.
Yes.
They had filed an application for enhancement. It was done.
Not enhancement lordship, because they have given 6+ interest, but while calculating the interest, we have given the entire awarded amount, including the interest, 6% as simple interest lordship. But they have calculated, claimant has filed an application that award,
is it, yeah.
total awarded amount, that is including
Understood.
6%.
They had filed an application for, according to them, the interest is not properly calculated.
Properly, they have not given.
And that
proper-
plea has been accepted by the tribunal.
Yes, lordship,
You
without
had-
considering our point, lordship.
Exactly, you had gone for review dismissed.
Yes, lord.
Now, where is the appeal?
Is the entire award lordship.
Entire award is not under challenge. It is only on the aspect how
Quantum
you
plus interest.
how you calculate the interest. You said that you have satisfied the award otherwise.
Yes, lordship.
What have you challenged here? Which order?
This is lordship, we have challenged this award judgment. And this judgment was passed this page, lordship will find.
Let us see your cost title. Appeal under against
This
the
is a-
order.
Yes.
No, it's against the order 11/12 wins and order dated 10/12/21 review, not against the award.
Then lordship, I.
You take instructions.
Lordship, lordship, can allow something.
We can convert this appeal can be converted into a revision because no issue is that. I have some instructions, okay?
Sure.
On the prayer of very good. Indication. Do this appeal has been preferred under section 173 of the Motor Vehicles Act, comma, the same is against an order dated 11/2/2017 passed by the and a subsequent order dated 10/12/2021 passed by the learned M.A.C.T. Tinsukia in MSC case number 76 of 2001, full stop, by the initial order dated 11/12/2017, comma, the tribunal has accepted the plea of the claimants towards which they had raised on the aspect of calculating interest. And by the subsequent order dated 10/12/2021, the review petition filed by the claimant, filed by the appellant insurance company has been rejected, full stop. Whether an appeal will lie under section 173 of the Motor Vehicles Act would be an issue, full stop. Para. Ms. Chaudhary, the learned counsel, accordingly prays for and is granted a week's time to obtain instructions. We'll come after the vacation, let's see. Please try to get some case laws. If case laws are there, otherwise we may convert it.
Okay.
Yes.
Also, in this accident, 3 vehicles were involved, Lordship, and SHRI was filed against other 2 vehicles. But we are held liable to pay 50% of the awarded amount, and other vehicle is also given. But our vehicle was not offending as per SHRI.
How much amount?
7,91,000.
That case.
Yes, sir. We are challenging our 50% liability.
50% has been settled upon you.
Settled with us, Lordship. But
Yes, you are for the claimant.
For the claim.
Have you received any amount? Till now, nothing.
No, no.
Have you gone for execution?
Copy of memo.
Oh?
Copy of memo.
No, that's not the question. Have you got any amount till now? Have you gone for execution? No.
I'm appearing on behalf of the
Oh?
Barua.
No, that is okay. You should have the instructions whether you have got. See what. Have you understood what is their challenge? You have not understood. What have you understood? Tell us. No, you don't need to go to a senior. You have heard what the senior brother has said, has submitted. What has he submitted?
As for my instruction from my senior.
You leave aside the instructions. What have you understood from his submission? It's nothing to get nervous. He has said something. Have you understood something? Anything?
As per my instruction from my senior
Yes.
lordship, I have the submission to direct to deposit 50% of their claim. 50% of it.
That is what we are asking. Have you got anything till now?
No.
Even if we direct 50%, it will be 50% of 50%. So ultimately it will be 25%.
Yeah. 50% of their share. Their share is 25%.
You know about that. How many vehicles were there? You don't know. This is so difficult to study the brief. How many pages brief? Young counsel find it difficult to study a brief.
I go to file.
You should grab the opportunity, got the file, read it. At least have a cursory glance what is there. Know how to read a file, not the entire file. Read the impugned order, read the grounds of appeal. Okay, but your if you deposit, it will be only 50% of your share. They can execute for the others.
Yes.
Okay. Heard 3 AJ Saikya, learned counsel. For the appellant who has preferred the appeal under section 173 of the Motor Vehicles Act against the judgment and award dated so and so, it is submitted that 3 vehicles were involved and charge sheet has been filed against 2 other vehicles. And in spite of the fact that the vehicle of which the appellant is the insurer was not the offending vehicle, 50% of the award has been settled upon the appellant insurance company. Full stop. Para. Admit. Call for the LCR. Mr. Borwa will be appearing.
For respondent 1, my lord, and we have not received any copy.
Sri B. Borwa, learned counsel. has entered appearance and accepted notice on behalf of the respondent number 1, claimant. Let extra copy. And Mr. Bhatta, semicolon, Sri KK 4. P. Bhattakur, Miss P. Bhattakur, learned counsel for respondent number 4, and KK Bhatta for respondent number 8. Let extra copies. Okay. Let steps be taken for service of notice upon the respondent numbers 2, 3, 5, and 6, 7 be taken by usual process. Steps within 2 days. List of 6 for service report. Service report as well as report on LCR. Heard. Free ages Aikya, learned counsel, who by means of this application has prayed for stay of the impugned judgment and awarded it so and so, passed by so and so, in so and so. Full stop. It is submitted that the vehicle of which the applicant was the insurer was not the offending vehicle, and in spite of that, 50% of the liability has been saddled with the applicant. Full stop. Para. The connected appeal has been admitted today. Full stop. Para. Considering the above, pending disposal of the appeal, the part of the award by which 50% has been settled with the applicant shall remain suspended, subject to deposit of 50% of the share settled on the applicant within the registry of this court. Full stop. The respondent number 1 claimant would be at liberty to pray for release of the amount as and when it is deposited. Highest can disposed of.
May I please, Your Lordship? This is an appeal, Lordship, on the point of negligence, Lordship.
Oh, that was it, no? On the point of
Negligence, Lordship.
in case the copy is not available, I have a spare copy.
Where is affidavit?
Madam, can you just fly to the bench?
Padi adu.
My lord, at page 2, paragraph 3
No,
of
I
the affidavit.
take your lordship to page 1 first. Para 2. Pursuant to which the complainant respondent number 1 has agreed to extend time.
My lord,
That is not correct.
Now,
my lord,
1 minute.
there is some.
Instead of being very smart, you prepare a proper affidavit where you will definitely agree to pay within a particular point in time.
My lord, that has been stated.
No, not going around everywhere and coming then. You be point blank in saying whatever you want to say.
My lord, paragraph 3, I have categorically stated that petitioner is ready and willing to pay the entire amount agreed under the settlement so and so. And rupees 10 lakh has already been given. Remaining amount, either the petitioner proposes to transfer this real property, the description of which is recorded, and the document of title is also enclosed. Otherwise, 6 months extension will be given. We'll sell it off and we'll pay.
No. You have narrated the entire story, making out a new case of your rights in this affidavit. I will not take this. You file a plain and simple affidavit with regard to when you will make the payment to them. And you will be bound by this by that undertaking, not narrating the entire story, saying so and so. Because you have gone up to the Supreme Court, things are over. I'm not going to overhear on merits of the matter.
My lord, it is not about the merit.
Don't narrate all this at all.
My lord,
Everything is already there. You file a
statement to that effect.
You file a different affidavit where you straight away say, on this day, you are going to pay this.
My lord,
Or you want to make it staggered payment, I will permit you. But payment you have to make.
my lord, payment, we are not saying that we will not make payment. We can fix.
No, it can't be a project of 2025. You should.
My lord, before that, it won't be possible because my lord, land has to be sold and petitioner cannot.
No. Your difficulties cannot now be, projected to be tolerated by him because you have lost everything. It is only last straw, I'm telling you. Yes.
But that's all right. But this failure is attributed to this conduct only, my lord.
Transaction is of the 2006.
My lord, the liability came in December 2022.
It's all right. It's okay.
It's only 1 year.
Liability came then, all proceedings are lost. Supreme Court has confirmed it.
My lord, it's an in limine order. My lord, there is no denial on the part of the petitioner to pay. However, my lord, petitioner should not be compelled to go for a distress sale, my lord. That is the only means whereby he can pay.
That's why instead of you protecting yourself from going for a distress sale, please be explicit in what you properly want to do. Not this kind of an affidavit.
My lord, I can state on oath.
Somewhere you have said out of coercion the check was paid and don't do all that.
My lord, the situation was there that he was not admitting it at all.
Now
and
that,
had that been
now
misused
that is over, you are admitting that you have to pay.
and we have stated on oath that we'll not pursue that complaint, we'll withdraw and everything.
So
we have-
that you state properly and say when you want to pay. I'll take it tomorrow.
Right.
Tomorrow. Yes.
My lord, but before 6 months, it's not possible, my lord.
You seek instructions and come.
It can take place. The sale can take place tomorrow.
6 months I am not going to give. So it is up to you to ask your client whether it is possible or not. I am not going to grant 6 months.
My lord, what is the maximum outer limit which can be granted? Then
That tomorrow I'll tell you. You put up your offer here. Yes.
My lord, interim order may kindly.
Interim protection shall continue. Protection. Interim protection shall continue till the next date of hearing. This day after tomorrow in the fresh
My
matter.
lord, if I may make a submission, my lord, there is an alternative sentence on the petitioner. And if this undertaking is recorded before a court of law, it will become enforceable under 431 CRPC. And in that scenario, my lord, I
That's what
consider
you-
Jimpex's authority, my lord.
You have that also. I know. They'll have to initiate those proceedings.
My lord, unnecessarily, they will be dragged into another round of litigation. It is.
That's why it is better to both of you to settle it.
My lord,
You bring in a time frame, I will answer.
my lord, I'll draft an affidavit and send it across. My lord, they may kindly.
Tomorrow or day after?
Tomorrow.
Tomorrow. You are here tomorrow?
Yes, ma'am.
Yes, tomorrow.
Great.
49.
Tomorrow in the fresh matters list.
Okay.
ಇದು Forest Act 155 applicable ilva?
Lordship has passed an order.
Will for the present state and answer it.
Please, my lord,
Impending application, ಇವ್ರು ಯಾರು sawmill ತಾನೇ ಇದು?
our complainant, they are not the
You are the
complainant.
complainant.
I am the complainant, my lord.
They
What's my
informed the
kindly-
police, the
My
forest
pleading
department, that's
application,
all.
my lord, kindly turn to
The
page number
complainant
9.
ಯಾರು forest officials ಅಲ್ವಾ?
ಹೌದು.
ಸರಿ ಬಿಡಿ,
Given
ಅವ್ರು
the complaint
ನೋಡ್ಕೊಳ್ತಾರೆ.
to the forest.
He will take care. Why are you worried?
No, my lord, there are 2-3 grounds, my lord. Illegally, they fell and cut the 68 trees, my lord. Out
I
of which
will
there are
see.
about 4 rosewood trees.
Well, where is that? Additional SPP said there is a judgment of the coordinate bench that this would not be applicable. ಕೊಟ್ಟಿದಾರ?
My lord, and moreover, my
That
lord,
is-
the forest officials are
That includes
hand
wildlife
in
act,
close
my
with
lord.
the
That is not applicable.
petitioners. They have not seized all the,
A lordship has
Please, my
passed
lord,
an
logs.
order so far as forest offense is concerned.
ಇದು MMDR ಇದು.
ಹೌದು.
Forest offenses ಕೊಡಿ.
I'll pass on that.
ಕೊಡಿ ಅದು.
lord, still the, all the.
And one more prayer is
Fine,
to
all the logs are
ತಗೊಳ್ಳಿ.
in the sawmill, my lord.
ನೀವ್ ಇನ್ನೂ ಸ್ಟೋರಿ ಒಳಗ್ ಬಂದಿಲ್ಲ. Wait.
ಅಲ್ಲ.
Yes.
and the maximum punishment is
Oh,
500.
this I have followed another order. See this. ಇದು ನೋಡಿದ್ದೀರಾ ತೊಗೊಳ್ಳಿ. You give it to the additional SPP.
And the closure of my sawmill, my lord.
ಏನೇನೋ ಕಟ್ ಮಾಡಿದ್ರೆ ಟ್ರೀಸ್ ಮತ್ತೆ ಕ್ಲೋಸ್ ಆಗೋದು.
There are about
Sawmill,
68 trees.
they already seized the
Forest
forest
officials.
producers.
ನಾಳೆ ಬರ್ತಾರಾ?
2:30 ಬರುತ್ತೆ.
2:30 ಬರ್ತಾರಾ? ಪಾಸ್ ಓವರ್. ಎಸ್.
Much.
ಏನ್ ಲಾರಿ ಮಾದೇವ್ರೆ?
40.
ಏನ್ ಲಾರಿ?
ಲೋಡ್ ಮಾಡ್ತಾ ಇದ್ರು, ಯೂರಿಯಾ ಲೋಡ್ ಮಾಡ್ತಾ ಇದ್ರು ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ.
ಎಸೆನ್ಷಿಯಲ್ ಕಮಾಡಿಟೀಸ್ ದಾ?
ಎಸ್ ಎಸ್, ಮೊನ್ನೆ ಒಂದು ಆರ್ಡರ್ ಆಯ್ತು ಅದೇ.
ಎಲ್ಲಿದೆ ಕೊಡಿ ಅದು.
11/214
ಕೊಡಿ.
11/214 of 23.
Will pass the same order.
My lord, they don't approach before the magistrate. Everything they want.
Really, it is
the
easier.
honorable court to step into.
482 is easier.
ಆಗ್ಲೇ 9 ತಿಂಗಳಾಗ್ಬಿಟ್ಟಿದೆ ಸರ್, ಏನು ಸಿಕ್ಕಲ್ಲ, ಮಾರಿದ್ರು ದುಡ್ಡು ಸಿಕ್ಕಲ್ಲ, ಹಂಗಾಗ್ಬಿಟ್ಟು. 11/214 of 24 ಇಲ್ಲ, ರಿಲೀಸ್ ಆಗಿಲ್ಲ ಸರ್.
ಬರ್ಕೊಡಿ ಅದು.
Number ಕೊಡಿ sir.
11
ಬರ್ಕೊಡಿ ಮಾದೇವ್. Yes, next. Disposed.
Orders 41.
ಮೊನ್ನೆ ಚೇಂಬರ್ ಬೇರೆ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್. ಕೊಡಿ ಕೇಳ್ಕೊಂಬ.
Order.
Hearing for petitioner, my lord.
Office objections raised in 1 of 24 permission. What additional
Letter
documents?
is served, my lord. While the memo
Learned
per
counsel for the petitioner submits office objections has been complied with. Office to verify. In the event complied, post the matter according to its date. Next.
42.
My lord, some urgency, my lord, the
ಯಾಕೆ?
hearing before charge on 28.
Entry ಮಾಡ್ರಿ ಇಲ್ವಾ?
ಇಲ್ಲ sir,
28th ಈಗ.
28 ಗೆ.
ಆಯ್ತು, ಲಿಸ್ಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಟುಮಾರೋ ಅಂತ ಮಾಡಿ.
Please.
In the fresh matters list. In the admission, sorry. Yes, next. Police report awaited.
In this case, I am a petitioner, my lord. In this case, I am a petitioner. ಅಲ್ಲಿ ಚಾರ್ಜ್ಗೆ ಅಂತ 1ನೇ ತಾರೀಕು ಇಟ್ಕೊಂಡಿದ್ದೆ ಸರ್, ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಅಲ್ಲಿ.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಸ್ಟೇ ಇಲ್ವಾ?
ಸ್ಟೇ ಇಲ್ಲ ಸರ್.
ಏನ್ ಅಫೆನ್ಸ್?
420/406. ನಾನು ಅಕ್ಯೂಸ್ ನಂಬರ್ 2ಗೆ. There is a 5 years delay in filing up the complaint. And moreover, my lord, in complaint, ನಾನು ಸೂರಿಟಿ ಅಂತ.
ಚಾರ್ಜ್ ಯಾವತ್ತು? 1ನೇ ತಾರೀಕು.
1ನೇ ತಾರೀಕು.
Place the matter on Friday in the for admission.
HON'BLE.
Police report awaited ಅಂತ ಇದೆ. ಇನ್ನು 2 ವರ್ಷದಿಂದ ಆಗಿಲ್ವಾ? ನೋಟಿಸ್ ಆಗಿದೆ ಯಾವತ್ತು?
Recently, my lord, notice has been there.
ಸರ್, ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ ಕೋರ್ಟ್ ಮುಂದೆ 27/5ಗೆ. 2 ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ನೋಸಿ ಬಂದ
List on Friday. Yes.
HON'BLE.
Next.
43. Which one?
In terms of memo.
For the
withdrawn.
petitioner, my lord.
4.
43.
43 withdrawn, sir. Yes.
34, my lord.
Ah.
Respondent 2 is food inspector, my lord. Maybe SHB made it.
Respondent 2 is
Food inspector, my lord.
all right. It's lunch hour anyway. Yes. 2 weeks time to do needful to be done, sir.
ಅಲ್ಲ process R2 ಅವರ ಇದ್ದಾರೆ. Maybe.
Learned HCGP is directed to accept notice for the second respondent. Interim order subsisting shall continue till the next date of hearing. Next.
Oh, please.
Today paid the PF.
Huh?
Today paid the PF.
Counsel for the petitioner submits that needful has been done. Interim order idea?
ಇದೆ.
Needful has been done. Office to verify. Interim order subsisting shall continue till the next date of hearing.
46.
Compared with the.
Has been same R2. R2 ಯಾರು?
R2 is the wife.
Wife, sir. Needful to be.
ಅಲ್ಲ, R2.
ಆಗಿದೆಯಾ?
Respondent ಒಬ್ಬರೇ
Counsel for
resolve
the
ಮಾಡಿದ್ದು.
petitioner submits needful has been done. Office to verify. Interim order subsisting shall continue till the next date of hearing.
47.
Much.
Lord, R2 is present before the court.
ಈ ಕಡೆ. ಏನು ಎಂಗೇಜ್ ಮಾಡ್ತಾರೆ ಅಂತ ಕೇಳಿ.
ಇಟ್ಕೋತೀರಾ?
ಇಟ್ಕೋತೀವಿ.
He wants to engage a counsel.
Yes. The respondent is present in person and seeks time to engage service of a counsel. List the matter after 2 weeks on date code. So and so. List the matter on 18th. Interim order subsisting shall continue to the next date of hearing. Ilva, illa. Yes. Illa.
48.
In this matter, not
Interim order idea.
interim order ಇಲ್ಲ ಸ್ವಾಮಿ ಈ ಡೇಟ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೇನೆ ಅಂತ.
ಈ ಡೇಟ್ಗೆ ಅವ್ರು ಬಂದಿಲ್ವಲ್ಲ ಮತ್ತೆ.
But the third respondent is the second respondent is a third party. Not dispute is not civil dispute.
That's
is
all
pending
right.
between me and not the other. Only not the other person set up this person to take help of the not the civil case.
Post immediately after service of notice upon the second respondent. Second respondent. Yes.
Date otherwise not the one.
Immediately, yes. Register to put up once the notice is served. Next, in terms of memo.
50 for settlement.
In settlement. Passover. Settlement.
My lord, appearing in serial, for the appellant in serial number 50, my lord. We've already filed the settlement has been done, the money has been paid, my lord.
Where are the parties, sir?
My lord, the respondent is actually now she's staying in the UK. She is immediately after settlement, she's.
Tomorrow in the fresh matters list.
My lord, in
Yes.
this matter, a mediation report is there, my lord, which she has undertaken to.
ಇಲ್ಲ ಅದಕ್ಕೆ ನಾಳೆ ಕ್ಲೋಸ್ ಮಾಡೋಣ. Tomorrow in the fresh matters list. Yes. Office objection. Yes, madam.
The petitioner, my lord.
What is serial number 5 office objection?
My lord, the CC number and page number 20.
Accepting the submission of the learned counsel, office objection stand overruled.
Much obliged, my lord.
First time I do.
Indeed, my lord.
First time.
First time.
List on Monday in the fresh matters.
NBW has been issued, my lord.
NBW.
for the-
Yake, who are you?
I'm for the petitioners accused 1 to 4, my lord.
1 to 4. What are you alleged of?
My lord, offenses under section 498A.
490?
498A
Not for 3 and 4 of DV.
DP.
Why NBW? Charge sheet ಆಗಿದೆಯಾ?
Page number 47, there is allegation against.
Charge sheet challenge ಮಾಡಿಲ್ವಾ?
That is why they have
We have
challenged.
challenged the charge sheet only, my lord. There's no allegations against the family members, and the allegation against the husband is that he has an extramarital affair, my lord. And this is the first time the.
Who is the husband accused number 1?
Indeed, my lord. Petitioner number 1 in this.
He is in Saudi.
He resides in Saudi, my lord.
How do you get him?
My lord, he visits once in 6 months, my lord.
So if these petitions are there, he'll come.
My lord, the
Who are
charge
the,
sheet-
who is the 4th petitioner? Anyway,
A sister of the.
list the matter on Monday in the fresh matters list. Till such time, warrant of any kind hanging on the head of these petitioners, except the accused number 1, shall remain stayed.
My lord, the proceedings against the family members.
That on Monday I will grant.
Much.
Now warrant ಇದೆ ಅಲ್ವಾ?
My lord, the charge sheet,
File it in the register.
much of this. 52.
Appearing for the petitioners, my lord. My lord, the objection was regarding the entire charge sheet not filed, my lord. The
No, no,
state-
sufficiency of service notice received respondent. What is this, madam?
My lord, it's been.
498.
Yeah, it's been.
Interim order ಇದೆಯಾ?
Been settled, my lord, and she's also
Settled ಆ?
the matter has been settled, my lord, before the family court.
Ah.
And the respondent is now out of country, my lord, after.
List tomorrow in the fresh matters list. Yes. Both of your cases tomorrow will close. Yes, next. Memo, in terms of the memo,
54.
post immediately after, madam, ಏನು?
There cannot be any police report. Only your lordship had directed the prosecution to produce a wound certificate. Last.
Police report for service of notice to second respondent, madam. Police report, not other police report. Post immediately after service of notice upon the second respondent, the learned HCGP shall on the next date produce the wound certificate that concerning the case. Next.
IA may be considered.
Huh?
IA may be considered.
You are-
323, 505, 506.
323, 504, 506.
506.
But allegation ಇದೆ, madam. I wanted to see the wounds, the wound certificate.
Lord, I have the answer.
ಇದೆಯಾ ಕೊಡಿ. Password. 54 password.
55.
Petitioner.
Post immediately after service of notice upon the second respondent. Interim order ಇದ್ರೆ continue ಮಾಡಿ.
56, my lord.
Withdrawal.
ಅಲ್ಲ ಅದರಲ್ಲಿ 125 proceedings, my lord, we challenged the interim order before this court, my lord. Office was raised the objections.
ಈಗ ವಿಡ್ರಾಯಲ್ ಹಾಕಿದಿರಲ್ಲ,
ಅಲ್ಲ ಮೆಮೊ ಇಲ್ಲ, ವಿತ್ಡ್ರಾಯಲ್ ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ.
ಮೆಮೋ ಮಾಡೋದು ವಿಡ್ರಾಯಲ್ಗ
ಇಲ್ಲ
ಆಗ ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ 2 weeks.
ಕೈಂಡ್ಲಿ ಅಲ್ಲ
ಮೆಮೋ ಮೂವ್ ಮಾಡೋದು ವಿಡ್ರಾಯಲ್ಗೆ.
with liberty.
ರಾಂಗ್ ಮೆಮೋ ಮೂವ್ ಮಾಡಿ ಕೇಸ್ ಲಿಸ್ಟ್
With liberties form, with liberty, we withdraw the petition with liberty for file first.
to challenge what?
125 proceedings.
Learned counsel seeks leave, files a memo seeking to withdraw the petition,
With liberty.
reserving liberty to call in question the proceedings before the appropriate fora. Yes, so liberty so sought is granted.
Kindly direct the office to give the.
The registry is directed to return all the originals, if any, appended to the petition.
Much obliged.
Yes, next. Forthwith.
57.
Commissioner, some office objection on statement of objections.
The counsel for the respondent is granted a week's time to comply with the office objections qua the statement of objections.
There is an interim.
Interim order subsisting shall continue till the next date of hearing.
58.
Yes, Venkatramana.
CC number, my lord, year has been changed.
Accepting the submission of the council, office objections overruled, list on Monday in the fresh matters list.
Tomorrow, my lord.
Yaka?
Because mentally, my lord,
Paralla, Monday tagon. Yes,
59.
next. Office objections,
I'm not telling on the order sheet, particularly I have order sheet regarding the,
council submission illa?
regarding this, it is a mental patient, he is in Central Jail, Bangalore. He is seeking
Office
the trial
objections
court.
overruled, list on Monday in the fresh matters list. Yes, next.
60 for settlement.
Battery support is
In
498.
offense.
498.
Now I'm filing the wakalat for R2, my lord.
One separate order sheet madi, learned counsel so and so undertakes to enter appearance for the respondent. Registry to print the name of so and so as appearing for the respondent. Atrocities Act ಇದೆ.
Atrocity.
ಎಲ್ಲಿ ರಾಮೋತಾರ್ ಜಡ್ಮೆಂಟ್ ಇದು ಮೇಡಮ್ ಸೆಟಲ್ಮೆಂಟ್ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ, ಎನ್ವಿಜೆ ಕೇಳಿ ಕೊಡ್ತಾರೆ. ಎಸ್ ಎಸ್, ಟೇಕ್ ದಿ ಸಿಗ್ನೇಚರ್ ಆಫ್ ದ ಪಾರ್ಟೀಸ್. ನೆಕ್ಸ್ಟ್.
61.
Office objections. A week's time is granted to comply with the office objections. 62.
62.
I appear for the petitioner.
Review petition.
Review petition was filed under wrong provision, so I had sought liberty to 205 other judgment kuda kottidini. I had sought permission to file under correct provision. Madidini. That has been done. Now there are two office objections.
Learned counsel submits that office objections ಏನು?
One month CRP writ petition ali the advocate he has not filed anta. In fact, in the previous review petition we have filed the wakalat of the previous advocate.
ಏನ್ ರಿವ್ಯೂ ಅದು?
ಅಲ್ಲ ಇದರಲ್ಲಿ father in law was left out, my lord. ಆ case.
That's it.
ಹೌದು.
You have everything against the father-in-law.
Yes. In fact, he was harassing more. That is our case. In fact, charge sheet was filed against the father-in-law also, but that was not brought to the notice of the court.
List the matter on Tuesday in the fresh matters list. Office objections stand overruled.
Much obliged.
63. 14%.
ಯಾಕೆ ಮತ್ತೆ ಬಂದಿದೆ ಇದು?
Oh, my lord, I have.
How many cases you have filed?
This is the same case I have come again. It was called today, sir, my lord.
Why
I
was
wanted
it
to
called
make a
today?
submission based on a judgment, my lord.
What judgment, sir?
There was a case and counter case where a partial quashing was taken place, my lord. Can you place this in front of?
We'll fully hear you after lunch.
Yes, much.
May I make a submission, my lord? Serial number 103, I
Madam,
pay for short
Karnataka.
accommodation. No, I'm not well.
Page wise adjournment, wait.
Page 8. 64 to 66. Page 9. 67 to 75. Page 10. 26 to 81. Page 11. 82 to 87. Page 12. 88 to 95. Page 13. 96 to 102. Page 14.
103, my lord.
3 to 100.
103 and madam?
I appear for the respondent. I have informed the senior counsel, have some health issues, short accommodation.
If he objects, then I will take it in your absence.
I've informed.
Gottilla. If he comes and objects, then I will take it in your absence. Yes, at the request of the learned counsel appearing for the respondent, list this matter exactly next week, Hakim. Yes. What are these for the hearing matters? Ashta sir.
My lord, submission.
490 settled between the parties.
Ah.
The respondent flying abroad may kindly have it.
ಯಾವಾಗ ಬೇಕು?
End of the list. You
Third. Yes.
My lord, one more submission, my lord. Serial number 52, my lord, which was posted tomorrow. There is another 2 more matters that have to be clubbed with it, my lord.
Settlement ಎಲ್ಲ.
Everything is settled.
Give that, yes.
Yes.
If everything is settlement, give it.
My lord, list 2 ನಲ್ಲಿ serial number 3 ಅದು ಸೋಮವಾರಕ್ಕೆ ಅರ್ಜನ್ ಆಗಿದೆ.
Serial number?
Serial number 39, list 2.
ಹಾ.
ಮಂಡೇಗೆ ಅರ್ಜನ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಆಗಿದೆ.
It may be taken on 27th.
It won't be taken. Monday ಇದ್ಮೇಲೆ Monday. If you want to come, come. I will dismiss it on that.
Your lordship's leave, my lord. Serial number 103. It appears that my counterpart is not
yes.
well. So, my lord, a date may be given.
Next week, next
A
Tuesday,
date-
next Tuesday.
Next Tuesday. Please, grateful.
Serial number 52.
On 2nd of July.
Ah.
I've already moved the court. This is the third time I'm moving the court, my lord. May it be had tomorrow.
It's tomorrow, why? First of
Nadiddu
July,
Swami.
Monday.
Nadiddu Swami.
Why?
Eh,
1st of July, second alva iradu.
Please.
Give it. But 10:30 move ಮಾಡ್ಬೇಕು. Why this practice 2:30?
Apologies, my lord.
ಸುಮ್ನೆ ತಗೊಂತೀವಿ ಅಂತ ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ತಗೊಳಲ್ಲ ಅಂತ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಬರ್ತೀರಾ.
There's an impediment, lordship.
I'll also stop taking.
Sorry, sir.
Yes.
Kind permission, my lord. Serial number 61, my lord. This honorable court is posted next week, my lord. He is a senior counsel. Petitioner was a senior counsel.
ಓ ನೆನ್ನೆ ಮೂವ್ ಮಾಡಿದ್ದ ಅದೇ.
Oh, sir. Senior.
ನೋಡ್.
ಅಲ್ಲ 61 ಗೆ ಇತ್ತು, ಅದು ಡೇಟ್ ಹೋಗಿದೆ. ನೆಕ್ಸ್ಟ್ ಡೇ ಆಫ್ಟರ್
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ತಗೊಳ್ಳಿ. ಯಾಕೆ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬಂದಿದೆ?
61 ಗೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಹೇಳಿ ಬಂದಿದೆ. 61 ಸೀರಿಯಲ್ ನಂಬರ್ 61 ಬಂದಿದೆ ಇವತ್ತು. ಆಫೀಸ್
ಓವರ್ ರೂಲ್ಡ್ ಅಂತ ಮಾಡಿದ್ದೀನಿ. ಇಲ್ಲ ಆಫೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
ಕಂಪ್ಲೇಂಟ್ ಇದು ಓನ್ಲಿ ಅಫಿಡವಿಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಫೈಲ್ಡ್, my lord, by ready, my lord. Tomorrow, my lord. Because
Day after tomorrow in the fresh matters list in the event office objections are complied with.
Please.
Yes. Second list ಯಾರು ಬಂದಿಲ್ಲ? Confirm. Those. Accounts.
List number 3, pronouncement of order.
List ಬೇಕು ಇಲ್ಲ. ಈ ಲಿಸ್ಟ್. ಕೊಡಿ.
Bill number 1.
Petitioner in this matter, please, madam.
Criminal petition is allowed. The order dated 2/12/2022 passed by so and so is set aside. The so and so is directed to permit playing the video footage for confrontation of the witness in accordance with law after all necessary parameters in law being followed. This by no means would be a ruse to the accused to drag on the proceedings. The examination and cross-examination on the basis of the video footage should be completed on a solitary day that would be fixed by the concerned court.
Grateful, madam. Grateful.
Number 2.
Them, no locus. I have followed my order.
In the other one, yes. Criminal petition is also.
ಅದೇನ ಅದು ಕ್ವಾಶ್ ಆಗಿದೆ. ಅಲ್ಲಿ ಸ್ಯಾಂಕ್ಷನ್ ಇಲ್ಲ ಅಂದ್ಮೇಲೆ
The consequential with a liberty that in case it comes up.
That is always open. I have observed in the order itself. Sanction ಬಂದ್ರೆ ನೀವು ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡಿ.
Yes. Great.
Number 3.
Counsel for petitions.
Writ petition is allowed. A mandamus issues to the respondent to release amount of 5.52 crores to the petitioner within a period of 4 weeks from the date of receipt of the copy of the order. In the event amount would not be released within 4 weeks as aforesaid, the petitioner would become entitled to interest at the rate of 6% per annum from the date it fell due till the date of payment.
4.
You should tell Madhukar. Let there be no confusion that there can always be a fusion between hearing and personal hearing. So don't get allowed. Allowed, remitted back. Writ petition allowed, orders impugned stand quashed. In the light of the quashment of the orders, the petitioner becomes entitled to all consequential benefits that flow, including restoration of status quo ante. Yes.
5.
Writ petition is allowed in part. The impugned communication dated so and so stands quashed only insofar as the impugned order enlists the petition schedule properties that are mortgaged to the petitioner qua the assignment. The petitioner would be entitled to consequential benefits that would flow from the quashment of the impugned communication. But the senior counsel has undertaken that they will not trouble the home buyers. I have recorded that.
In fact, we've also stated in our petition that as far as the units are concerned, they can be
only those properties enlisted in the notice.
Your Lordship.
I've got noted your submissions also. Yes.
Bill number 6.
It will be uploaded by this evening. Yes. All 6 will be uploaded.
Respondent, please.
This I have held those two judgments per in curiam. Of the coordinate benches, I have held them as per in curiam, and I have allowed the writ petition. Writ petition allowed, order dated so and so stands quashed. The learned magistrate is directed to resume the proceedings in CC 19781 and 782 of 2007. since the issue is more than a decade old, the learned magistrate shall conclude the proceedings within 3 months from the date of receipt of the copy of the order.
Deeply obliged.
For you, Kamalacharan, yes.
I'm appearing online, my lord.
Yes, yes.
Obliged, Your Lord.
So I had to hold them as per incurium.
I'm grateful.
I understand.
Yes, sir. Madam, ella members ಮಾಡ್ತಾರೆ. ಪಾಸ್ ಅವರಿಗೆ ಆಮೇಲೆ ಪಾರ್ಟಿ ಮಾಡಿ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
This continued 63.
You have not paid where is he? You have not paid process.
I paid today, Friday I paid, my
Today?
lord. Today I had to come to the court anyway. Just why I gave it today in the morning. Can I show it in my file?
The petitioner in person submits that he has done the needful today. Office to verify and post the matter on Monday in the fresh matters list.
My lord, I wanted to make a submission.
Tell me, sir.
My lord, the most of the case and counter cases what has come up for certiorari have not been allowed, my lord.
Certiorari, yeah.
I mean, quashing. So, but however, I found one of the judgments were in this honorable court, they had partially quashed it, my lord. So this judgment is similar facts what I have been facing. There was an altercation between neighbors and one of the cases was subjected to.
Madam Tole.
Apart from other accusations, my lord, there was a section 307 on the petitioner, my lord.
I don't know, we'll consider it, we'll post it on Tuesday. Complainant is not notified, Allah.
My lord, I have given it twice. I sent in speed post, my lord. It has been reached to him and I hand serve ಮಾಡಿದೀನಿ.
One ನಿಮಿಷ. ಆಯ್ತು. List the matter on Friday the next in the fresh matters list. ಅವತ್ತು ಕೊಡುವ. Yes.
Bring on 64.
Recalling the order.
By the petitioner, my lord. Filed by the petitioner.
Yes, Nehru sir, what is this?
Earlier, my lord, is deposited 2 lakhs rupees. Direct to the petitioner, deposited 2 lakhs rupees, my lord.
125
But is not paid that amount.
125 proceedings. There was a partition suit pending between daughters and father. It has been decreed. I have been given share. Let them take my share as well. Please refer this matter to mediation.
My lord,
That is the prayer.
2000 criminal misuse 2006, my lord. It's not a
Sir,
pay
there
that
should-
amount.
You should never lose hope for settlement.
I am prepared to give my share as well.
I detail memo calculation in the
Recall,
28.
ಆಮೇಲೆ ಮಾಡೋಣ. Sir, I have not passed an order. Pending recall, you appear before the mediation. Never lose hope for settling the matter, sir. It gives a quietus to all relationships. Dispute between all relationships.
Lies. Committed a second marriage illegally, my lord. Is staying the second wife.
Second marriage illegally ನೇ ಮತ್ತೆ legal ಆಗ. ಯಾವ್ದು?
Sorry.
ಸುಂದರೇಶ್ ಮತ್ತೆ illegal.
That reason, my lord, is recently is a second petition, second respondent is married 26/2003. It's not attend the second marriage also. Is
ಯಾರು ನಿಮ್ಮ ಮ್ಯಾರೇಜ್?
ಅಲ್ಲ ಅವ್ರದ್ದು petitioner respond number 2 though.
Respond number 2 ಯಾರು?
Daughter of the petitioner, my lord.
Why you have not attended?
I don't know. I have to ask my client. Maybe he was not
All that you
invited.
should, children ಏನ್ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ ಅದೆಲ್ಲ ಮಾಡಿ. Yes. ಈಗ ಸದ್ಯಕ್ಕೆ ಸೆಟಲ್ಮೆಂಟ್ಗೆ ಹೋಗಿ. List the matter. Sorry, the parties are directed to appear before the Karnataka Mediation Center. So and so on Friday kodi. On Friday at 3 PM.
Very well.
List this matter on Tuesday the next to report any settlement, if settlement, comma, if any.
Much obliged.
Yes. ಆಮೇಲೆ recalling ನೋಡೋಣ. Next Tuesday.
Interim order may please be.
Interim order subsisting shall continue till the next date.
Very well.
Subject to deposit of 2 lakhs ಅಂತ ಇರೋದು.
ಈಗ ಮಾಡಿಲ್ವಾ?
ಅದು ಮಾಡಿಲ್ಲ. ಅದರಿಂದ extension ಬರೋದಿಲ್ಲ.
I have no means at all In fact,
It's tailoring one house,
section
one property,
125.
one house is there, one shop is there, is ID
You have no means,
everything.
I have no means.
How did you marry for the second time?
That is false allegation.
Then-
Earlier, my lord, criminal petition dismissed by this honorable court in 2017, my lord. It challenged the original order.
He has
My lord,
undergone surgery.
Produce the document before.
He has undergone a surgery for spinal injury. He can't stand up.
Spinal injury.
Spinal injury. It is.
Spinal injury aage. Yes,
55.
Tuesday.
Okay.
Matter pertain 350.
Vacating stay. Who has filed? Stay.
354A. Lord, the
354 na?
internal local committee, my lord.
Internal?
Internal local, I was working as my lord, associate professor in my lord Shimonga University, my lord.
SIMs.
Yes,
Shivamogga Institute of Medical Science.
yes.
Sims.
Lord, 15/7/2022, my lord, second respondent gives a complaint. Lord, 18/7, internal local
Where
committee.
is, who appears for the complainant? Balan ಅಂತ ಇದಾರಲ್ಲ ಯಾರು?
Internal committee submits a report at page 37, my lord.
First respondent is the state, second respondent served. Yes sir, ಹೇಳಿ.
Lord, page 36, my lord, annexure G is the report submitted by internal local committee.
What do you mean internal local committee?
Lord, closing the complaint.
What is internal local committee?
Lord, is constituted under, my lord, section 4 of the act.
Wash Act.
Yes.
ಅದೇ ಹೇಳಿ.
Lord, the finding is at page 37.
30?
37, 37.
ಏನ್ sexual harassment ಆಗಿಲ್ಲ ಅಂತನಾ?
After long debate and inquiry, last, my lord, but
Page
paragraph
30?
37. Finding of the committee antide.
Apologize to the incident before the committee. It is further mutually agreed between committee. The matter will not be escalated in. Apology ಯಾಕೆ ಕೊಟ್ರಿ?
Lord, with mutual complaint, my lord,
What was the allegation?
of Lord, sexual harassment.
ಆಯ್ತು, what kind of?
Page number 45, lecture
45. ಇದಾದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರದ?
ಅದಾದ್ಮೇಲೆ Lord, on the impugned complaint is 12/8/2022. She refers the.
You are a doctor. Why do you want whether she has gone to the gym or not?
Lord, the very complaint refers the report submitted by internal committee, my lord, internal local committee. And after closure, my lord, she gives complaint.
This clearly amounts to 354. Yeah, look at the complaint. What doctors are indulging in all these things these days?
But it may not be, my lord.
May not be in.
But section 10(4) of the act says that, my lord,
Act says what?
once conciliation is arrived at, my lord, the matter is closed. Where settlement is arrived at, but it cannot be reopened.
What was the settlement? ಅವ್ರ ಮೇಲೆ ಏನಾದ್ರು ಆಕ್ಷನ್ ತಗೊಂತೀವಿ ಅಂತ ಹೇಳಿದ್ರ?
ಇಲ್ಲ. At page 37. Was only, my lord, compulsory rural service.
She was an intern with you, sir. Yes. What sort of inquiry is this?
Constituted under section 4 of the act, my lord. Section 10 mandates that, my lord, conciliation should take place at the initial stage. After long debate and inquiry, both complainant and respondent have agreed.
Vanil. After a long debate, the inquiry, both complainant and respondent have agreed mutual
Yes.
consent. And the complainant
Complainant
agreed to
agreed to
withdraw
withdraw.
application unconditionally
After
after
convinced
getting convinced that
so
the
and so.
touch was not intentional. Yes, but a bad touch. In interim order.
There is already, my lord, interim order.
Thereafter, my lord, I was kept under suspension. My lord, annexure K, this one court granted interim order on the ground that, my lord, there is a report of the committee, and ultimately, my lord, by order dated 19/6/2024, this one court quashed the order of suspension on the ground that, my lord, under section 10(4) of the act mandates that, my lord, conciliation is required.
Act could you?
May I request my lords to kindly turn to, my lord, page 60. The internal committee, page 60. Where a settlement is arrived.
Charge sheet hakidara.
There is an interim order. Where a settlement is arrived at under subsection 1, no further inquiry shall be conducted by the internal committee or local committee as the case may be.
No problem. They have not committed anything.
But based on the report of, my lord, local committee, my lord, no.
I will answer it. Let the local committees also conduct proper inquiry. Look at the allegations.
But allegation is.
They are unreadable.
But allegation may not be, my lord.
May not be. You have apologized that it was not.
It was not. Lord, she is.
Sir, should I read the complaint? Can that not be an intentional touch?
May not be an
May not be.
intentional.
I'll have to tell what. Yes. Bad ಅಲ್ಲ
ಓದೋದ್ ಕಷ್ಟ ಇದನ್ನ
ಮತ್ತೆ ಓದೋದ್ ಕಷ್ಟ ಇದ್ಮೇಲೆ ಅದು ಇಂಟೆನ್ಷನ್ ಅಲ್ವಾ?
At present, my lord, she is pursuing her MD elsewhere. And she may not be.
You pursue this case. Pursue your case.
At present, my lord, she may not be interested in prosecuting the petitioner also, my lord.
You leave it, sir. Whether she is interested or if she doesn't appear, you will get acquitted.
It may not be a case.
Investigation ಏನ್ ಮಾಡಿದೀರಾ? ಸ್ಟೇ ಆಗಿ ಒಂದ್ ವರ್ಷ ಆದ್ಮೇಲೆ ಸ್ಟೇ ಆಗಿರೋದು.
12/9/22, my lord, interim stay was.
12/9/22. Crime ಯಾವಾಗ? 15/7/22. Yes, sir. ಅದು 10(4) apply ಆಗೋದು for proceedings by the committee. It won't be applicable to criminal proceedings. 354A is clearly met here.
354A may not be a.
Sexual harassment is 354A. ಓದ್ಲಾ? 354A.
354A ನೇ ಓದ್.
354B is sexual harassment. Yes. ಹೇಳಿ.
Your lordship may.
Assault or criminal force to woman with intent to outrage the modesty. Outrage the modesty ಇದೆ, assault ಇರ್ಲಿಕ್ಕಿಲ್ಲ.
Assault in. Lordship may.
Anything? Yes. Investigation papers ಕೊಡಿ ಏನಿದೆ. Get list next.
My lord, only 1 month we were able to investigate. Thereafter.
What did you do in that month? You tell me.
I'll get the records, my lord.
I will answer that. ಯಾವುದು? 10(4). Such doctors should not be spared. There is a complaint. We don't know.
Lord, I'll produce the order passed by the coordinate bench, my lord, in petition 14846, my lord. That is
on the basis of 10(4).
Observation.
See, 10(4) says that it will not be escalated further by conducting an inquiry under the act. It does not stall setting the criminal law into motion.
The order is passed on 19/6 with an observation that
there is clear narration of the happening, minute details of the happening. ಕೊಡಿ ಪರ.
ಅಲ್ಲ ಆರ್ಡರ್ ರಿಲೀಸ್ ಆಗಿಲ್ಲ, my lord. It only shows allowed ಅಂತ ತೋರಿಸುತ್ತೆ. 19/6, my lord, this all court observed that, Lord, the language employed under section 10 read with 13 and 14 of the act. Once an order report is submitted and decision is arrived at, cannot be escalated. Escalation includes not the.
That is your interpretation. Escalation will be restricted only to the act.
Then the order produce Martin. If my lord.
ಮಾಡಿ. ನೀವು investigation papers produce ಮಾಡಿ. Next Tuesday, in the same stage. ಆಯ್ತು. ಸ್ವಲ್ಪ withdraw ಮಾಡ್ಬೋದು ಬೇಕು.
I will take an order.
Correct. Challenge ಮಾಡಕ್ ಬೇಕಾಗಿ.
Challenge. ಈ ಕ್ವಾಶ್.
ಆಯ್ತು. Yes. Quashment order. Yes, next.
But interim order may be.
Interim order subsisting shall continue till the next date of hearing. Learned HCGP to secure the investigation papers, whatever conducted till the date of grant of an interim order and place it before the court.
66.
Yes,
The
Sirajuddin.
petitioner lordship, extension of parole lordship.
Kare ಬರ್ತಾರಾ? Password. Rahul Karepal. Ask him to come fast.
Admission 67.
Appearing for the petitioner.
Yes, sir. 494.
Yes, ma'am.
Who are you? Accused number 1.
Accused number.
Madhu ಆಗಿಲ್ವಾ?
My lords?
Marriage ಆಗಿಲ್ವಾ second time?
No, my lords. Not
That's a matter of trial.
My lords, but the problem here is that they go to the magistrate. This is Nanjangud magistrate. What they do is.
Use the mic, sir.
Honorable additional JMFC of Nanjangud, my lords, they file one PCR. That becomes a CC, my lords. Subsequently, what they do is they file a withdraw memo there under section 257 of CRPC. Then they go to the Honorable Principal District Judge Mysore, my lords, and they file another case there. And subsequently, when that that case was filed here in the Nanjangud JMFC, they pass an order saying that the withdrawal memo is allowed. It is withdrawn. My lords, but the problem here is that when they filed the withdrawal memo, they have clearly stated that they want to present it in front of another court. Under section 257 of CRPC, what it says is that once it's withdrawn, he stands acquitted from the matter. But same set of allegations, same set of facts they've presented in front of the Honorable.
What was the memo? Where is the memo?
It's in page number 50, my lords. It's a withdrawal memo stating that they want to present.
1 minute. So it was withdrawn for want of jurisdiction, like return of a plaint.
My lords, but they only filed the case in the first place in JMFC.
Don't try to escape with all this.
My lords,
You should face trial. I will answer.
my lords, again, what happens is in the.
ಅವ್ರು ಹೇಳಿದ್ರ 257 ಅಲ್ಲಿ ಅಂತ.
My lord, that's magistrate only has power to.
Where is the order passed on this? It was want of jurisdiction that led to withdrawal. Wrong advice, sir.
My lords, then.
Yes, who appears to the complainant? ನೀವಾ?
I am appearing for.
ಯಾಕೆ withdraw ಮಾಡಿದ್ರಿ ಅಲ್ಲಿ?
For want of jurisdiction, my lord. It was happened in Mysore, second marriage. For that reason only.
Where is the order passed by the magistrate? Evidence commence ಆಗಿತ್ತಾ?
ಇಲ್ಲ
madam.
ಏನಾಗಿತ್ತು?
Notice take.
Notice stage.
Come to 257.
My lords, 257.
Come to that. if a complaint before any time the final order is passed in any case under this chapter, so trial should commence. During the trials,
My lords, that is before the final order is passed.
in any case,
Anytime,
under this chapter, what is that chapter?
my lords, but at any time.
What is
before
that
the final
chapter? ಈ ತರ accused na, if you allow to get them get away,
My lords, even in the
no
Mysore
justice
court,
to the victim.
my lords, in the Mysore court, what they have filed a criminal misdemeanor, that also came to be dismissed because they withdrew the thing. They withdrew
ಬರೀ
the
withdrawal
case.
ಅಲ್ಲಿ ನಡೆಸಿದಿರಾ ಎಲ್ಲ?
That is also
ಎಲ್ಲೆಲ್ಲಿ
dismissed.
withdraw ಮಾಡಿದ್ದೀರಾ?
Criminal misdemeanor is also dismissed.
Criminal miscellaneous.
Yes,
That
my
has
lords.
nothing to do with this.
My lords, they
This
asked
is
for
an offense
transfer.
of bigamy.
That is, they have
Allegation is second marriage.
asked- Yes, madam.
You are the husband
Yes.
who is alleged to have taken second marriage. Now you will have to defend your action there. You don't
My
get
lords,
away with all
They
all
have-
these things.
My lords, they have not produced any document which says I'm legally
That is a
married.
matter of trials.
My lords, for the.
You are
matter of
only
trial
on a
also-
simple ground that withdrawal of a complaint under section 257 would amount to acquittal.
Yes,
I
my
will
lords.
answer it to be no,
My lords,
because it is only after commencement of the trial.
my lords, the first line only, my lord, any time
any-
the final order is
In
passed.
under this chapter andre ಏನು sir? What chapter is that? That
My
is
lords.
not 202 or 204, sir.
Yes, my lords.
It
My
is
lord,
after the
this-
commencement of the trial, if they want to withdraw it, it is permitted, and that is why the effect is you will be acquitted because you are already tried or in the process of trial.
My lord, this will amount to me being accused twice for the same.
Where twice, sir? ಒಂದ್ಸರಿ ಆದ್ರೆ ಅದು final order ಆಗಿದೆಯಾ ಸರ್?
My lords, once
ಯಾವ್ದಾರು
already-
final order ಆಗಿದೆಯಾ?
Final order ಇಲ್ಲ, my lord.
ಮತ್ತೆ?
But I'm accused of this first time. They have filed a second criminal.
ಅಲ್ಲೇನ್
misdemeanor,
are
then
you
again-
tried, sir?
And again. in
Are you
2016.
tried? Are you tried by that court?
No, my lords.
ಮತ್ತೆ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ನಿಮ್ಗೆ ಟ್ವೈಸ್ ಓವರ್ ಅಂತ? ಯು ಆರ್ ಹಾರ್ಪಿಂಗ್ ಅಪಾನ್ ಸೆಕ್ಷನ್ 300 of CRPC.
Absolutely.
Ah, no.
Correct.
Section
My lords.
300 is a concluded trials.
Yes, my lords, but the matter of fact, it is already withdrawn. Then the matter of they presenting the case in front of another court
No,
is
no.
not maintainable at all, my lords.
Not at all.
My lords, even the fact, if you, for a moment, if you assume that it is maintainable, my lords, there is nothing to show that I'm
ಆಮೇಲೆ
legally married.
if you get over this ground,
My
then
lords,
I will answer it.
For 494, they'll have to prove legality of the marriage. My
That
lords,
is
they
there.
don't have any photos.
Before the
They have
consent.
they have showed nothing, my lords.
Before the
It's just a
consent.
mere allegation that I'm married to a second time. That's all. There's nothing to prove that I'm married twice.
ಈ ಗ್ರೌಂಡ್ ಮೇಲೆ ಆಗಿದ್ರೆ I will answer. If there is any other ground, tell me. Yes, what is the complaint?
Please, ma'am.
2005
My lord, they've been separated since 1992.
Page 13, my lord. This is the private complaint. The assertion is at paragraph 4 at page 15.
Ah, 1992 ಆದ್ಮೇಲೆ ಎಲ್ಲೋದ್ರಿ ನೀವು?
They were separated.
ಹಾ.
And
ಮತ್ತೆ ಅವ್ರೇನ್ ಸುಮ್ನೆ ಇರ್ಬೇಕಾ?
no, my lord, there are a number of cases regarding maintenance, regarding MC petition, divorce petition, and all.
ಎಲ್ಲಿ between 92 to 2005?
Please.
Yes,
Please.
my lord.
What prima facie evidence you have?
My lord, there is a assertion in paragraph 4 of the petition at page 15. That the accuser number 2 constitute as the second wife of the accuser number 1, and she was working as a nurse in the Sitarangan Hospital near Siddhapur Square, Mysore, till such time she left the said hospital for delivery of a child begotten by her out of the unlawful wedlock with the accuser number 1.
ಅದು ಕಂಪ್ಲೇಂಟ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸರ್ ಅವರು, ಅವ್ರ ಅಡ್ಮಿಷನ್ ಅಲ್ಲ.
I am
ದಟ್ ಈಸ್ ನರೇಷನ್ ಆಫ್ ದಿ ಕಂಪ್ಲೇಂಟ್, ನಿಮ್ ಕಂಪ್ಲೇಂಟ್. ಏನ್ ಎವಿಡೆನ್ಸ್ ಇದೆ?
birth certificate is there.
ಕೊಡಿ,
Passing over.
ಅದು ಕೊಡಿ ಮೇಡಮ್. ಬರ್ತ್
Father name is Mahesh,
Mahesha.
Please. Name of the father, Mahesh.
24/2/2003.
3.
Mother name?
Ghanavati. Accused number 2.
Nanavati.
Ghanavati. One more document.
Yes, sir.
Dridhikarana Patra from.
But divorce ಆಗಿದೆಯಾ?
Agila.
But proceedings pending ಇದೆಯಾ?
Please.
ಎಲ್ಲಿ?
Before the Mysore family.
ಆಗಿಲ್ವಾ ಅದು ಡಿವೋರ್ಸ್? ಆಯ್ತು, ಎಲ್ಲ ಒಟ್ಟಿಗೆ ನಡ್ಸ್ಕೊಳ್ಳಿ ಕೇಸ್ಗಳು. ಡಿವೋರ್ಸ್ ಕೇಸು, ಬೈಗಮಿ,
My lords.
ಎವ್ರಿಥಿಂಗ್.
And one more maintenance case.
ಅದು ಇದೆಯಾ?
We
have
filed for
not paid
divorce. my lords.
maintenance.
I have only
till
filed for
date.
divorce.
ನೀವು ಬೈಗಮಿ ಕೇಸ್ ಹಾಕಿದ್ರೆ ಮೇಂಟೆನೆನ್ಸ್ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ? ಎಸ್, ಎನಿಥಿಂಗ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳ್ಬೇಕಾ? ಅಷ್ಟೇ. ರಿಸರ್ವ್ will answer 257. That is why. Yes.
Petition. Lordship may kindly recollect, last occasion, my lord, Lordship has directed me to, my lord, verify whether the,
This way they could.
on the last occasion, my lord, Lordship has directed me to verify, my lord, whether the petitioner has assured to pay any money to the complaint. But our instruction, my lord, there was no such talk, my lord. It is accused number 2 has assured, my lord, not the, he's the landlord, my lord.
304A.
304A, my lord. I'm the landlord of the premises where, my lord, this incident took
Petitioner,
place.
who is the petitioner?
Accused number, my lord, 1, landlord, my lord, landowner, owner of the, that premises.
Accused number 2 ಯಾರು?
Is the, my lord, tenant, my lord,
Tenant.
tenant.
Who died?
Not the one electrician, my lord, the husband of the complaint.
Electric shock.
Yes, my lord,
Where?
electrician.
Why?
But due to, my lord, the high tension wire, he has come in contact with the high tension wire, my lord. He died. My lord.
High tension wire.
Yes, my lord.
Who are you?
I'm the landowner, my lord, owner of the premises. I have nothing to do with this incident, my lord. I have no role, my lord.
3
Please to
lakhs
say the negligence.
compensation would be paid ಅಂತ ಯಾರು ಹೇಳಿದ್ದು?
Lord, last date of occasion I have submitted.
No, you have submitted, I have recorded, but who has told that?
Lord, it is jointly accused number 192 has come forward to Lord the for settlement. Lord, given a promise that Lord they will settle and give. as
I have
the
insisted,
matter-
there was no such talk, my lord.
ಪರವಾಗಿಲ್ಲ, ಈಗ ಕೊಡಿ. Forget about the talk earlier, now you give.
That apart, my lord, my
No,
submission
apart
is, my lord,
business.
I will, my lord, speak to him, my lord, but he has no role, that is my.
That's so, that I will answer.
Your lordship, my lord, in similar matter, my
Many
lord,
matters I have said no rules, sir, but compensation ಕೊಡಿ.
I will, my lord.
If you don't pay compensation, trial.
15 days.
15 lakhs ಕೊಡ್ತೀರಾ?
No. ಅದೇ ದಿವಸ ಟೈಮ್ ಕೊಟ್ರೆ ಐ ವಿಲ್
15. 15 ದಿನ. We'll post it. Anyway, you want money.
Shall
my lord,
Lord,
even
Law
there are
is
judgments, my lord.
became a destitute there.
May I make one submission, my lord?
Two minor
There are
doubts.
judgments, my lord. In strict liability, my lord, the company has to, my lord, pay this compensation, my lord. ಸುನಿಲ್ ದತ್ ಯಾದವ್ ಸಾಹೇಬ್ರದಿದೆ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇದೆ.
ಇರ್ಲಿ.
ಸ್ಟ್ರಿಕ್ಟ್ ಲೈಬಿಲಿಟಿ, my
3
lord.
ಲಕ್ಷ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡಿ, ಆಮೇಲೆ ಸ್ಟ್ರಿಕ್ಟ್ ವೈಕೇರಿಯಸ್ ಎಲ್ಲ ಆಮೇಲೆ ನೋಡೋಣ.
I will, my lord, explain.
List on 15 days bit down there. Learned counsel for the petitioner submits that he would seek instructions if 2 weeks' time is granted to comply with the order dated 28/5/2024 or otherwise. Yes. ನಿಮ್ಮೇಲೂ ಬರತ್ ಬೇಡ. Yes, list on 18th July. Yes.
69.
Petitioner, madam. Mines Act, madam, this case.
Mines Act.
Mines.
ಏನ್ ಗ್ರೌಂಡ್ ಏನು?
My ground is that, my lord. Page number 20, my lord. The complaint, my lord, cognizance has taken, my lord.
ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ವಾ?
Private complaint.
ಕರೆಕ್ಟ್ ಆಗಿದೆ.
In there only, my lord, without, learn the magistrate has, my lord, observed in their complaint itself, my lord. Without following the due procedure of law, without applying the mind, my lord. Kindly see the page number 20, my lord. Complaint present and file the.
Cognizance taken.
Cognizance taken in their complaint only, my lord, in the complaint. Further, my lord.
That is fairness. Yes. ಇನ್ನು ಗಲಾಟೆ ಮಾಡೋಕೆ ಗಲಾಟೆ ಮಾಡೋದು ಉಪಯೋಗ ಇಲ್ಲ. Third, the learned counsel appearing for the petitioner is before this court calling in question the proceedings before the concerned court in special case number 10 of 2020 for offences punishable under, madam, page 10 ಅಲ್ಲಿ ಇದೆ. Heard so and so. On 27/3/2019, invoking section 200 of the CRPC, the respondent senior geologist registers a complaint before the concerned court for the aforequoted offences. On 27/3/2019, the learned magistrate takes cognizance of the offence and registers special case so and so, special case 10 of 2020. The registration of the special case and issuance of summons to the petitioner has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner at this juncture would restrict his submission to the manner in which the cognizance is taken and the summons is issued to the petitioner. Therefore, the examination of the case at hand is only qua the order of taking of cognizance by the learned magistrate. The complaint is presented by the senior geologist, the respondent, before the learned magistrate on date. On 27/3/2019, on the same day, on the same complaint, endorsement is issued, which reads as follows. Madam, page 20,
28, madam.
28 ಅಲ್ಲಿ ಇದೆಯಾ?
Paper copy, madam.
Ah, 28 ಅಲ್ಲಿ ಇದೆ. It reads as follows. The learned magistrate does not even, the order of the learned magistrate does not reflect even a semblance of application of mind for taking cognizance on the offences. It is not that the concerned court is taking cognizance on a final report or a charge sheet against the accused. It is taking of cognizance in terms of the MMDR Act upon a complaint being made by the senior geologist, a public servant. The learned magistrate ought to have applied his mind to the contents of the complaint, arrive at a conclusion as to whether there was a case made out for issuance of process, and then taken cognizance of the offense. The order does not reflect any application of mind, and the absence of application of mind in the order of taking of cognizance results in its obliteration. For the aforesaid reasons, the following order: allowed, quashed, the matter is remitted back to the hands of the learned magistrate to consider the matter from the stage of taking of cognizance, bearing in mind the observations made in the course of the order. Yes, sounds ordered accordingly.
70.
One minute, Rahul.
Opponent in this case.
1 minute, madam. ಅದೇನು ಕೊಡ್ಬೋದಾ?
Your lordship.
Huh?
He has surrendered.
He has surrendered.
Surrendered.
No adverse report?
No adverse.
ಎಷ್ಟು ದಿನ ಕೊಟ್ಟಿತ್ತು ಮುಂಚೆ?
30 days.
Madam, 30 days. Heard Rahul Karyappa and ಇರೋದು ಮಾಡಿ. Extension of parole 30 days. You can go.
Much.
Yes.
Much obliged.
Yes.
Short accommodation.
Short time. Why, sir?
Senior counsel Sushila madam is superior. Settlement ಹೇಳಿದೆ.
Settlement.
Last,
Domestic violence. Settlement talks are on.
no, my lords, last time it was posted for settlement. So there.
On the offer
Senate
code,
counsel for the petitioner seeks 10 more days time to report settlement, if any. List after 2 weeks. List on 19th.
Much obliged.
Interim order subsisting shall continue till the next day.
51.
the petition, my lords.
304A. Two individuals in an inebriated state, my lords, they fall from the second floor of the building.
This is last time your lordship asked if the compensation has been paid or not been paid. I've been told, my lord, that the complainant filed a petition before the trial court seeking compensation. I've informed him.
ನಿಮಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡಕ್ಕೆ ಏನ್ ತೊಂದರೆ ಇಲ್ಲ.
Nobody has approached us until now, nor my lords have we received any notice of the honorable court.
It's all right, you pay
Anything fine.
compensation, so what?
In fact, if they approach, we can consider.
20 crores, sir.
I do understand, my lords, but I also kindly appreciate this.
ಯಾವ್ದು?
Absolutely nothing from
I will
there.
answer all that. Pay compensation to them.
Let them approach, but I would perhaps advise my
observe.
client to consider
Yes.
that. In fact, they are also well-to-do individuals, understand the work in software, though we have no specific information. 2019 was the incident, my lords. June 2019, Nivaktanka, until now, no approach at all whatsoever. One was, my lords, there was 87.75 milligrams per 100 ml of blood in one individual. And the second individual.
ಏನೇನಿತ್ತು ಹೇಳಿ?
My lords, the two individuals are deceased, my lords. 87.75 milligram per 100 milliliter of blood in the male.
Alcohol.
Alcohol, my lords. Alcohol in the blood. And as for the female is concerned, 72.77 milligram per 100 milliliter.
Alcohol.
Alcohol, my lords.
ಈ ಪಬ್ಬಿಗೆ ಹೋಗಿರೋದು.
It's apart from that.
Which floor?
Second floor of the building.
Second floor.
Oh, the
Building was not yet constructed
it
completely.
was constructed in 2016, completed. It's a ventilator.
The window was open.
The window, there was a door, my lords. What's indicated is they were unable to close the door. Though they say that it was not as per particular standard, but there is no specific standard indicated either, my lords.
Who is the complainant?
This complainant is a friend of one of the individuals who expired. We have a synopsis note which is ready.
Kodi.
They can please. Including the judgments, my lords, primarily one of the Honorable Supreme Court and two of my lords.
The petition, you are the managing director, is it?
I'm the chairman and managing director, my lords. Second accused.
They let them make CW4 as a party, my lord. They may come before this court.
Complainant ಇಲ್ವಾ?
ಇಲ್ಲ ಅವ್ರನ್ನ ಮಾಡಿಲ್ಲ, ಇವ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟವ್ರನ್ನ ಮಾಡಿದ್ದಾರೆ, ವಿಕ್ಟಿಮ್ ನ
ಏನ್ ಮಾಡಕ್ಕಾಗ? Complaint ಯಾರು ಇರ್ತಾರೆ ಅವ್ರು ಮಾಡಿ, ಎಲ್ಲಾರು ಮಾಡಕ್ಕಾಗ?
There is also.
No, I will observe that this will not come in the way of any compensation.
They would see.
Instead of dragging it, they can probably settle this matter.
Not correct.
In fact, we also understand.
Compensation ಹಾಕಿದ್ರೆ ಅವರು.
That is what
They have
CW,
claimed
I've been
this will
told.
not come in the way.
Well, I've been,
It is only absolving criminal liability, not civil liability.
if they make CW4 as a party,
Like it's already there, let them pursue it. I will observe it will not come in the way, otherwise it. ಏನ್ rash and negligent ಇವ್ರು?
close ಆಗ್ಲಿ ಅಂತ. Let the
ಅಲ್ಲಿ
family
close ಆಗ್ಲಿ ಬಿಡಿ.
instead of going on for a long period.
Entry model ನಂದೇ ಅಲ್ವಾ?
Please.
My entry model. 2022. Yes. The petitioner, I will adequately protect their rights there. The petitioner is before this court calling in question an order of the learned magistrate dated 8/12/2020 by which cognizance of offence punishable under section 304A of the IPC is taken against the petitioner in crime number 112 of 2019. Heard learned counsel Amar Korea along with Sridevi Bhosle and the learned additional SPP representing the state. Your complainant served on.
ಅವರು CW1 ಮಾಡಿದ್ದಾರೆ. Ideally CW4 should have been there. Because he is the person.
Who was the complainant? ಅವ್ರನ್ನ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ ಅವರು.
Victim definition.
Father of one of the deceased.
No, I will.
Sorry, friend of the one of the deceased.
That's all right. Oh, victim ಅಲ್ಲಿ ಯಾರು claim ಮಾಡ್ತಿರೋದು?
CW4 has filed the petition.
PW4 ಯಾರು?
CW4.
CW4
Yogananda is the father of the deceased Attavara, Pavan Attavara.
All right, even if he is there, same order will be passed, but I will protect his rights there and observe that yes, compensation will have to be paid in case. But who are they went into second? They were not inmates of the apartment.
No. This is the people who went to have a drink in pub,
It's a pub, my lords. Beer
Pub.
pub on Church Street.
Church Street, what pub?
beer pub.
BEIR.
Beer pub.
South.
So
It's
after,
owned by you?
But I've given it, I've leased
Oh,
it
you are
out
the
to
Building
owner,
owned by-
owner of the building.
building.
owner of the building, that's all.
So after having a
Page 90.
call in the pub, they were coming down and then
And even the CCTV has captured the entire incident, my lords. It's indicated that the lady was walking in the man was walking in the front. She slips walking from behind. And then they take support of each other. But the ventilator is about it's about 2.5 feet by about 3.5 feet. So with that force, if they have to go down, my lords, its indication is that when one is falling, she takes the support of the other one and both get dragged. And Panchanama captures the incident very clearly.
The second respondent is the complainant. The petitioner, who is accused number 1,
He is the property manager.
then he will be responsible. Yes. I will observe that also. That will adequately protect the victim. The petitioner is accused number 2. Which building? What is that? ಏನಾದ್ರು ಹೇಳಿದಿರಾ? ಅದು ಏನು ಹೇಳಿಲ್ವಾ? As usual.
Now a
As
note,
usual
my
ಏನು
lords,
ಇರಲ್ಲ.
Prestige RR.
What?
Prestige RR on Church Street, my lords.
Prestige RR.
RR.
The petitioner is a builder who constructs a building by name Prestige RR and leases it out to various persons. One of whom is one of the lessee is a pub by name BIER.
BEIR.
BEIR pub. The friends of the complainant on the fateful night, i.e. on 22/6/2019,
21/6/2019,
appeared to have had consumed alcohol in the pub at Church Street and in an intoxicated state at 11:30 p.m. while they were walking down the second floor, have fallen down on the ventilator window attached to the stairs. And on the window frame, it is seen that the petition, that both of whom who were at the second floor fall down, sustain injuries and succumb to the injuries. Succumbing to the injuries gave a result to the impugned crime being registered by the friend of those who did succumb to the injuries. This becomes a crime in crime number 112 of 2019 for offense punishable under section 304A of the IPC. The learned IPC. The concerned court, the police, after conduct of investigation, filed a charge sheet against the accused in CC 20289 of 2020. The petitioner is arraigned as accused number 2 since he is the builder of the commercial complex. Issuing of summons to accused number 2 is what has driven the petitioner to this court in the subject petition. The learned counsel Amar Korea would submit that the petitioner is no way involved in the incident that has happened on the fateful night. While it is a tragedy that has happened, and the persons who have died were solely responsible for the incident as they were and as they had consumed alcohol to the tune of 80 to 90% each, and therefore they could not control they could not walk on the stairs which led to their fall. At best, it would be the owner of the beer pub or the controller of the beer pub would be responsible for the acts and not the petitioner who has let out the commercial complex long ago. The learned additional SPP would submit that the petitioners have not impleaded the victim, and it is the complainant who has been impleaded. He would further contend that the complainant the parents of the victims have preferred application seeking compensation before the appropriate forum. And this should not come in the way, any order that would be passed here should not come in the way of the claim of the parents of the victim before the concerned court. He would further contend that that accused number 1 is the manager of the pub who is held responsible for the act, and therefore the observation should not be made applicable to the said petitioner, said accused as well. He would further contend that the petitioner also be permitted to face trial and come out clean, as there is prima facie material against all the accused. I have given my so and so. Therefore, narrated facts are not in dispute. On the evening of 21st June 2019, two people at about 11:30 p.m. after consumption of alcohol in an inebriated state, and the inebriation being to the extent of 80 to 90% of alcohol being present in the body of the deceased, go up two floors and then slip down and holding on to the ventilator attached to the window, fall from the window. The allegation is that the window frame was very weak, unable to bear the body weight of the persons who wanted to catch hold of the window and save their lives. And therefore, save their lives who fall down from 25 to 30 feet of the commercial complex. Therefore, the complaint is registered and the complaint becomes a crime in crime number 112 of 2019. And the police, after investigation, file a charge sheet. The summary of the charge sheet as obtaining in column number 7 reads as follows. Madam, page 30. Though the accused are drawn into though the petitioner as accused number 2 is drawn into the web of crime, it is to be noticed that the petitioner is the owner of the commercial complex who had let it out on rent long ago. Therefore, the offense under section 304A cannot be laid against the petitioner in particular. Section 304A reads as follows. Section 304A would require 2 acts by the accused, one rash and the other negligent. The petitioner, being the owner of the commercial complex and having rented it out long ago, cannot be seen to have committed either a rash act or a negligent act as is defined under section 304A. It would become apposite to refer to the judgment of the Apex Court in the case of Ambalal D. Bhatt versus so-and-so, 1975, 2 SCC, page 525, extract para 10 and 11. The Apex Court holds that the owner of a premises in an accident that takes place there cannot be hauled into the web of crime under section 304A of the IPC, as he would not be doing any rash or negligent act. It is the person who is present at or wholly responsible for the event would and should be proceeded against. In the light of the judgment rendered by the Apex Court in the said case of Ambalal D. Bhatt, the proceedings against the petitioner cannot be permitted to continue. This, however, would not mean that the family of the victim would not be entitled to compensation for the loss of the precious life. The proceedings are annulled in the case of the petitioner only in an answer to a petition under section 482 of the CRPC, finding that it would not become the ingredients of section 304. This would not become applicable to even other accused who were responsible or alleged of responsibility of the incident.
One
The-
submission, I have to submit this, my lords. A1 is the property manager, also an employee of Excess Investment belonging to the petitioner. The owner or occupier has,
accused
they have
will
not
see.
been made accused, my lords.
Uh,
Earlier also, my lords has dictated that.
One, I'll correct it.
Please.
Anyway. Yes, so and so. Therefore, the hauling up of the owner of the commercial complex, particularly for offense under section 304A, would suffer from want of tenability. For the aforesaid reason, the following order. The learned additional SPP would further submit, the submission of the learned additional SPP that the victim, parents of the victim have instituted proceedings for seeking compensation against all these accused. You're
Not sure, my lord.
against the, on the incident, on the incident, should not, sorry, the submission of the learned additional SPP that merits acceptance, merits acceptance. Therefore, the concerned court, whoever, whichever is deciding the plea of compensation by the parents of the victim shall not be influenced, bound by the quashment of the proceedings against the present petitioner, which is peculiar to the facts of the case. It is, and even the observations that the that the couple who died on the incident were in an inebriated state would mean that they would lose compensation. Yes. For with the aforesaid observations, the following order. One, allowed, washed, it is made clear on that. Yes.
Alcohol contains 72 and 87.
172 and 87.
One is 72.
Alcohol
other one is
content
87.
70 to 80%. ಅದು ಸ್ವಲ್ಪ ಜಾಸ್ತಿನೇ ಆಯ್ತಲ್ಲ.
ತಕ್ಷಣ ಹೊರಗಡೆ ಬಂದಿದೆ.
ಅದು ತಕ್ಷಣ ಹೊರಗಡೆ ಬಂದು ಅಲ್ಲ ಅವ್ರು ಕುಡಿದು ಎಲ್ಲೋ ಹೋಗಿ ಬಿದ್ದು ಏನ್ ಮಾಡ. That's not the issue. 80% alcohol is too high.
No, they were drinking since, according to the paper, 9 o'clock they've entered. 11 o'clock, 11:30 they came
11:30
out.
vargu, then if they are there and too much of inebriation. Yes.
Please, blood.
Yes, next.
72.
Please go to petition, please. For the second respondent, my lord.
Objections are not filed.
Objections are ready, my lord. I may be permitted.
In the event no objections are filed, I will not take it until. Ready now?
Yes, my lord.
File it. Learned counsel for the respondent submits objections are ready to be filed. The same be filed before the registry after serving a copy upon the petitioner's counsel. List next Tuesday. Interim order subsisting shall continue till the next date.
Great.
73.
But this is a matter where sale by the bank, the branch manager is made an accused.
73, yeah.
72, please, 73. Page 40 may kindly be seen, please.
72, I thought, 73.
73.
Yeah, what's the matter?
I am the branch manager, my lord. I have sold the property under SURFACE. And when the matter went to DRT, there was a stay of issue of sale certificate. And then the second respondent enters into a compromise with the borrower. They file a memo in the DRT. Then I am permitted to sell the property. I sold the property and issued the sale deed.
Who is the complainant?
Complaint.
Auction purchaser.
Auction purchaser.
Hello, your
My lord, they have not delivered. They have not delivered the possession. And subsequently, my lord, complaint was raised, my lord, complaint was also lodged before the ombudsman.
GM court ಬರ್ಬೇಕಾಗಿತ್ತು ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ.
And my lord, they assure that the amount will be returned.
Amount return ಮಾಡಲಿಲ್ಲ.
Amount return ಮಾಡಿಲ್ಲ, alternative site ಕೊಟ್ಟಿಲ್ಲ.
Site
My lord,
alternative site ಕೊಡಕ್ಕಾಗಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ, what they have promised under the letter.
Where is the letter?
My lord, letter I'll place it on record, my lord, that I am not. Lord,
Oh, 1 minute. Tell me the dates, sir.
My lord, loan was taken on 27/2/2004.
27/2/2004. When did it become sticky?
It became sticky on 11/7/2011.
11/7/2011.
2011. SURFACE notice was issued on 10/2/2012. Then sale notice is dated 25/11/2012. Then SA number 794 of 2012 is filed before the DRT matter with the borrower. And its interim order was obtained saying that sale can go on, but sale
Confirmation should not be done.
should not be done.
ಆಮೇಲೆ
Then the second respondent implicated himself in the DRT.
No, 25% was paid by him.
Paid.
Yes.
On 20 February 2013, a joint memo is filed. Memo is at page 24, annexure B.
Yes.
One second.
Joint memo by borrower and
The
bank.
complainant. The
Borrower
second
and complainant.
and the second respondent, please.
Yura.
All right.
What did you settle with the borrower? ಏನ್ ಮಾಡಿ ಎಲ್ಲಿದೆ?
Page 40 notice.
Page 40.
40.
In
They have
State
no-
Bank of India na?
How this one? I am the branch manager of State Bank of India.
Branch manager.
Adರಲ್ಲಿ heard perused records, the memo, contents of the memo are read over and explained to applicant parties in the language known to them. They accept and admit the contents of memo and they have no objection to confirm the sale and issue sale certificate in favor of purchaser by name Sri Jayaprakash TS.
ಆಯ್ತು, ಇವ್ರ ಮೇಲೆ.
ಇವ್ರು.
ಸರಿ.
ನಾವು ಇಶ್ಯೂ ಮಾಡಿದೀವಿ.
ಆಯ್ತು.
ಈಗ ಅದ್ರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ದಾರೆ.
ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್.
Lord, sales.
ಚೀಟಿಂಗ್ ಆಗಿದೆ, ನಮ್ಗೆ
I'm
ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ.
ನಿಮಿಷ.
My lord, I am an auction purchaser. I have deposited the entire amount before the bank.
All right.
And my lord, they have executed, my lord, issued sales certificate.
In your
Possession-
favor.
In my favor. Possession is not delivered. And there is a litigation, my lord, there is a dispute with regard to the title. That's what they admit in a letter. And they also say that, my lord, inquiry is going on. And they require some time. And they say that, my lord, either a site will be given alternate site or amount will be refunded.
Alternate site
That they
also.
have not done, my lord.
They will have to demand return of the money if the property is not clear, please.
When do you return the money?
ಅಲ್ಲ, ಅದನ್ನ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗಿ ಅವರು
ಅದೆಲ್ಲ.
My lord, I was made to go to.
Don't make them run pillar to post for your act.
After 2013 ಅಲ್ಲಿ ಆಗಿರೋದು ಇದು. They have filed a complaint now. And I am not even the person who has issued the sale certificate.
No, this is the problem. ನೀವು ಅವಾಗ ಮಾಡದೆ ಹೋದ್ರೆ ಯಾರೋ ಬಂದು ಕೂತಿರ್ತಾರೆ ಆ ಜಾಗದಲ್ಲಿ. ಅವ್ರನ್ನ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಮಾಡೋದು.
ಇಲ್ಲ, I think he was the person who.
Morning also I stayed one matter.
And this is the letter, my lord, where they have said
Koಡಿ.
that, my lord, by.
ನನಗೊಂದು ಕಾಪಿ ಕೊಡಿ ಅದನ್ನ. ಫೈಲ್ ಇಲ್ಲಿ ಮಾಡಿಲ್ಲ ಇನ್ನು.
ಇದು ಯಾವಾಗ ಕೊಟ್ಟಿರೋದು ಕಲ್ಯಾಣ್ ಅವ್ರೆ?
My lord, that was given, my lord, the year 2014-15. And we have been.
ಅಲ್ಲ, ಅದು ಕಾಪಿ ಕೊಡ್ಲಿ ನನಗೆ. They are not
ನೋಡಿ. You are bound by this, sir. Deposited.
And they also
This
admit.
banks have been doing as is varies ಅಂತ ಪ್ರಿಂಟ್ ಮಾಡ್ಬಿಟ್ಟು ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ you hoodwink the purchasers. ಅವ್ರಿಗೇನ್ ಗೊತ್ತಿಲ್ಲ, ಬ್ಯಾಂಕ್ ಸೇಲ್ ಅಂದ ತಕ್ಷಣ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಪರ್ಫೆಕ್ಟ್ ಅಂತ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ. Banks are faltering these days in everything. You want to sell the property, whether it is free of encumbrance or not, you sell the property. In GM, I have seen so many cases.
I'll seek instructions, my lord.
If
Let
you
me
have,
give a
if you
copy
have
of
issued
this.
that letter, you are bound by it.
I agree, please, my lord.
If you want this to be closed, then you should be bound by it. The learned counsel for the petitioner seeks seeks time to secure instructions with regard to the communication dated Kalyan, dated so and so. Accordingly,
26/12/2013.
give that here. 26/12. The communication reads as follows.
Next page.
ಇಷ್ಟು ಮಾತ್ರ ಮಾಡಿ. State Bank of Mysore. The then, yes. ಇಷ್ಟು ಮಾತ್ರ ಮಾಡಿ. ಆಮೇಲೆ ಇಸ್ಕೊಳ್ಳಿ.
Please.
So and so. Instructions, the four quoted communication be secured and submitted on the next date. How much time? 2 weeks?
2 weeks.
Yes. List on 23rd July.
Please. ನನಗೊಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ.
ಅದು ಇಸ್ಕೊಳ್ಳಿ ಆಮೇಲೆ. KG ಅವರು ಬರ್ಕೊಂಡ್ ಕೊಟ್ಬಿಡಿ ಬೇಕಾದ್ರೆ.
For the petition.
ಹೌದಾ?
Last occasion.
Correct ಆಗಿ ಕರ್ದು.
Last occasion, this court directed to produce the WP copies. I'm producing it.
Yes, Latif.
Lord, the issue in the case, Lord, the property in question was acquired in the year 1984 and Mahazar was drawn in the year 1989. Subsequently, Lord, they filed this writ petition challenging the entire scheme under section 27. The scheme has been lapsed. On that writ petition, there is an order of status quo. In spite of the order, Lord, they put up, they further constructing the building. Therefore, we filed a complaint of violation and the trespass.
The 447,
Please.
Last occasion, whether who are in.
I have the photographs of construction is going on now.
ಈಗ ಸ್ಟಾಪ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ, constructions ಏನ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
Photographs, Lord.
May
Who
kindly
is
see,
in
my lord.
possession of the property?
We are in possession of the property, my lord.
ನೀವಾ?
Please.
ನೀವು BDA-ಗಲ್ವಾ?
Please.
Acquisition ಆದ್ಮೇಲೆ ಏನ್ possession of property?
Lord, the acquisition, even though acquisition happened during 80s.
I said what documents you have filed ಅಲ್ಲ ಕೇಳಿದ್ದು.
162 page number, Lord,
ನೀವು possession ತಗೊಂಡೇ ಇಲ್ವಾ?
physical, the paper possession was taken.
Position ತಗೊಂಡೇ ಇಲ್ಲ.
And
earlier.
page number 162 is the Mahazar.
Writ petition pending ಇದೆಯಾ?
Pending.
There is a status quo order. In spite of that, he is constructing the building.
No. May kindly see the.
Now you undertake that you will not construct, we will continue the interim order. That's the allegation.
Sir, we are not constructing. May kindly see, my lord, whether we are in possession, page
Possession ನೋಡೋಣ.
174, my lord.
Because there is already a writ petition pending, we will not answer.
Earlier that also, my lord, in 1992 writ petition, 170.
ಇವಾಗ present latest writ petition ಯಾವುದು sir?
59512/16. In that status order is still.
59512.
2016. Earlier order, my lord, may kindly see page 174.
The petitioner claims to be in possession of the property, being its owner. Counsel B. Latif, representing the BDA, submits that the BDA has taken physical possession of the property pursuant to the acquisition. All these matters are now pending consideration before the coordinate bench in writ petition 51512 of 2016. 59512 of 2016, where the coordinate bench has directed maintenance of status quo by the parties. The learned counsel Latif further submits that despite the grant of status, despite the order of status quo being in operation, the petitioners are undertaking construction. The learned counsel for the petitioner submits that they have not undertaken and undertake not to undertake any further constructions in future. The undertaking is placed on record. Therefore, the matter be adjourned by 8 weeks. Interim order subsisting shall continue till the next date of hearing. ಮತ್ತೆ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿದ್ರೆ
Constructions and ಮಾಡ್ತಾರೆ. There are nearly 190 houses are there, madam. None of them have been taken.
ಇವ್ರ ಪೊಸಿಷನ್ ತಗೊಂಡ್ರಲ್ಲ ನೀವೇ ಇರ್ತೀರಾ, ಸೊ ಅವರು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕ್ತಾರೆ.
ತಗೊಂಡೇ ಇಲ್ಲ.
Even
ಸ್ಕೀಮ್ ಲ್ಯಾಪ್ಸ್ ಆಗಿದೆಯಾ?
they claiming that the scheme has been lapsed.
Scheme. Notification.
Section 27 ಪ್ರಕಾರ ಸ್ಕೀಮ್ ಲ್ಯಾಪ್ಸ್ ಆದ್ರೂ it rests back to the
State
government or it rests back to the owner. What's that?
We are
Not
the
go
one.
back to the, rest with the government.
Yes.
25.
Please.
ಏನೇ ಅದು ಅಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡಿ.
Lords, I'm appearing for the petitioner in this matter.
Yes, sir.
My lords, I'd already heard this matter in.
Already heard.
Yes, my lords, and it was reserved for dictating of orders and the synopsis.
You
of-
dictating orders and the reserved for dictating orders.
Sorry, I mean, it was set down for dictating of orders. Synopsis is also filed and placed.
Oh, civil in nature da?
Yes, my lords, it's civil in nature and the.
Who's
civil
the
suit is-
complainant? Who appears for the complainant rather?
My lords, counsel by name Vineet Shambhat, I believe, appears for the complainant. And both the parties address the arguments in.
All right, he is not here today.
Yes, my lords. Civil suit is already pending.
What happened to the civil suit?
It's pending, my lords. Set down for evidence, my lords.
Yes. No representation on behalf of the respondent complainant. List this matter on Friday. We'll close it on Friday.
Yes, interim order.
Interim order subsisting shall continue till the disposal of the petition.
Obliged.
Both Allah.
All four. There are.
Yavudidu this court employee, is it?
Yes, my lords.
Yes. Idan purely civil Allah.
Yes.
There is fraud in this.
No, my lords, it is.
The employee of this court.
Yes, my lords.
Yes.
My lords, the documents clearly demonstrate.
We'll answer this.
Yes.
On Friday, yes.
Obliged. Interim order may continue.
That will continue. Till the disposal beda, till the next date of hearing.
26.
Yes. ಹೆಂಗೆ ಎಸ್ಕೇಪ್ ಆಯ್ತು ನನ್ನಿಂದ ಸಂತೋಷ ವಾಪಸ್ ಬಂದಿದೆಯಲ್ಲ ಈಗ ಮಾಡ್ತೀನಿ.
The first complaint is at page 138.
ಒಂದು ನಿಮಿಷ ಯಾವ್ದು ಮ್ಯಾಟ್ರ್ ಇದು?
76.
ಸಂದೇಶ್ ವಿಕೆಟಿಂಗ್ ಸ್ಟೇಟ್ ಹಾಕಿರೋದಾ?
ಇಲ್ಲ, complainant appears to have filed, but they are not appearing, not.
HC ಶಿವರಾಮ್ ಅಪೇರ್ ಆಗಲ್ಲ, ಇದ್ದೇ ಇರ್ತಾರೆ.
3 ಸಲ ನಮ್ಗೆ ಹೇಳಿದ ಟೈಮ್ ತಗೊಂಡು ಹೋಗಿದ್ರು.
ಅರ್ಜೆಂಟ್ ಬೈಟ್ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ. Promise to marry,
She's already married with 2 children.
Allah, at the time when
Please.
she was having relationship with you, she was already married.
She was already married, and not she files complaint at 138, which not results in an FIR.
Page 138.
Page 138. 132 is the FIR. Not which results not in a B report. At
B report.
B report agata first. Then not her 164 statement. The first case is at page 147. Not.
One ನಿಮಿಷ. 164 statement.
Also, your lordship may kindly come to page 148. ನನ್ನ ಮೇಲೆ ಯಾವುದೇ ದೌರ್ಜನ್ಯ ಆಗಿರುವುದಿಲ್ಲ. After about 4 or 5 lines from the top. ನಾವು ಚೆನ್ನಾಗಿ ಇರುತ್ತೇವೆ.
ಇನ್ಮೇಲೆ ಮುಂಚೆನಾ?
ಮುಂಚೆ ಇನ್ಮೇಲೆ ಚೆನ್ನಾಗಿರ್ತೇವೆ ಅಂತ ಹೇಳ್ತಾರೆ. Then not she also writes a letter to DYSP at page 149, saying that not she is not willing to continue the
relationship with you.
Continue the case, not relationship.
Yes, sir. Not relationship with you.
And not relationship continues.
Yes.
Not the allegation is both of them may not go to a hotel.
ಆಯ್ತು ಬಿಡಿ.
Other things not.
To be continued. Our Barley. Yes. Yes, madam.
Yes, your lordships, allegations are there, your lordships.
What allegations? ಎಷ್ಟು ವರ್ಷ relationship?
This is about 4 years now.
But she was already married.
She already married. See in the complaint she says married with 2
Where is the
children.
complaint? Page
38.
Typed copy. ಅದೇನಾ?
ನನಗೆ 2 ಮಕ್ಕಳಿದ್ದು.
ನೀವು ಸರ್ಕಲ್ ಇನ್ಸ್ಪೆಕ್ಟರಾ? And she's married and he's police constable.
That's what she says. This is
ಒಂದೇ ಸ್ಟೇಷನ್.
ಬೇರೆ ಸ್ಟೇಷನ್.
ಶಿವರಾಮ್ ಬಂದು ಕತೆ ಮುಂದುವರಿಸಲಿ. Yes. Now heard the learned counsel appearing for the petitioner and the learned additional SPP. The learned counsel for the second respondent is not present. Awaiting his appearance as a last chance, list this matter on Friday. In the event the respondent would not be present, the matter would be taken in his absence and answered. Yes.
Please.
Listing shall continue till the disposal of the petition.
Please.
You appear to have shown your superiority on that fellow now.
ಇಲ್ಲ, ಆ ಥರ ಏನಿಲ್ಲ ಇದು.
Yes. Yes, sir. ಯಾರು ಇಲ್ಲ.
I am for petitioner. I am for petitioner.
Your Lordship, for respondent number 2 in serial number 77.
Press
Yes,
3
sir.
weeks times.
Huh?
Press 3 weeks time for addressing the arguments.
Press time? No grants time. Yes, what's the matter?
Lordship, seniors wedding on the coming Saturday is engaged with preparation.
Seniors coming second Saturday. What?
Senior wedding on 29th is coming Saturday.
Senior wedding?
Yes.
Oh. Point
Engaged
to be
with
noted.
preparation.
Yes. Learned counsel for the petitioner, counsel representing the counsel on record submits that the counsel on record is ಎಷ್ಟು ವಯಸ್ಸು ಸರ್ ಏನೇನು ಹೇಳ್ಬಿಡ್ಬೇಡಿ.
30.
Counsel on record is getting married on Saturday. Therefore seeks time, grants time. Yes. ಯಾವಾಗ ಬೇಕು?
3 weeks time.
ಮದುವೆ Saturday 3 weeks ಯಾಕೆ ಬೇಕು?
Reception ಎಲ್ಲ ಇದೆ. Next
ಸರಿ,
week.
ಆಯ್ತು. List the matter on 19th July. ಸಾಕಾ?
Great.
ಆಯ್ತು.
78.
Lord, I appeal for petitioner.
70?
78.
The earlier order, Your Lordship may kindly see to produce records as per para 5 of the interim order dated 1/3/2024. I request.
Para 5 of the considering the, yes. Produce record of mining activities of the petitioner and surrender. Has he surrendered the license?
Yes.
Matten bar.
Allah, surrendered after the offense is complete. That is why I am producing it. My Lord's permission, I will produce. Giving it to my friend also. Lordship may have it next week, but I will submit.
ಅವ್ರಿಗೊಂದು copy ಕೊಟ್ಟು.
Please,
Just
I have
now.
received now.
Yes. Heard the learned counsel appearing with the petitioner and counsel Venkatesh Arbatti. In furtherance of the direction on dated 28/5/2024, the counsel has produced the memo along with documents. The same is taken on record. List the matter next Tuesday.
Third or fourth, next one, first and second or some matters.
ಆಯ್ತು, second ಬೇಡವಾ?
ಅಲ್ಲ,
ಮೂರನೇ
third
ತಾರೀಕು.
and third or
ಒಂಬತ್ತು.
third or fourth.
9th.
9th.
List the matter on 9th. Yes.
29.
What is the allegation? That he has
Not without
mining
license.
activities without license.
Without license. Not he has
He is
license.
not without license.
For some portion, Lord, for some portion with license, Lord, ore has been extracted, transported. But for further portion, Lord, without license, it has.
Yes.
29.
List on ಯಾವತ್ತು ಹೇಳಿದೆ ಅದು? 9th ಅಲ್ಲ? 9th, yes.
Appeal for the petitioners, Your Lordship. Interim order, my lord.
Interim order subsisting shall continue till the next day.
Appearing for the petitioners, I pray short accommodation, Your Lordship. Next
Serial
week, any
number?
date. 79.
Why short accommodation?
Seniors held up in other court, Your Lordship.
Then is getting
And the
married.
respondent had to file objections the last date.
Bangalore, sir.
Argue without filing any statement of objection.
You have filed?
I have not filed.
Not
I'll argue
necessary?
Without filing any objection.
What's the matter? You forget the objections. Now come on merits.
Now,
Kindly be taken up in the next week, Your Lordship.
The ground urged by petitioner is that, number one, he is covered by 9th exception. This is an offense under section 500.
Defamation.
Defamation.
9th exception.
Is good faith. That is a matter of trial.
Who is he?
They are trustees of a particular trust. And I am a journalist.
You are a journalist. You are a journalist.
I am a journalist.
You are the complainant.
Complainant is a journalist.
All right, yes.
I published a piece of investigative journalism where they have, it was revealed that they have misappropriated about 3 crores of rupees belonging to the government.
Who?
The
Where
trustees
did,
of
where
the
did you
trust.
get that information?
By RTI records.
RTI records.
Records.
Have you produced those RTI records?
I have not produced.
then that may be required without, because if you have sprung some allegation in
It's
thin
not the
air.
allegation, that is not the allegation. My allegation is, my allegation against them is what they uttered against me at page number 24.
24,
24,
page.
page number 24. I
Page
conducted investigative journalism.
Complainant is a, ಇದಾ ಓದ್ಬೇಡಿ ನಾನೇ ನೋಡ್ತೀನಿ. ಇಟಾಲಿಕ್ಸ್ ಅಲ್ಲಿ ಇರೋದಾ?
Para 10, it is submitted that SHRI.
ಅಲ್ಲ ಇಟಾಲಿಕ್ಸ್ ಅಲ್ಲಿ ಇರೋದು ನೀವು ಬೈದಿರೋದಾ?
ಹೌದು. ಅವ್ರು ಬೈದಿದ್ದಾರೆ ನಮಗೆ. ಇದನ್ನ ನನಗೆ ಬೇರೆ ಇನ್ನೊಬ್ರು ಹೇಳಿದ್ರು, that has been recorded. Section 65B certificate is not produced ಅಂತ ಹೇಳ್ತಾರೆ. He says that two certificates are required. But then Supreme Court has said that a certificate is required at the time of trial.
Yes, mister. ಎಲ್ಲ okay.
Next week,
Good faith ಅಲ್ಲಿ ಇದೆಲ್ಲ ಬೈಯೋದು ಎಲ್ಲಿಂದ ಬಂತು?
Oh, on the
This
next
is
date,
good faith.
senior will address the arguments, Your Lordship. Next week, any date. may be
Who
given.
senior?
Ismail, sir.
faith.
Ismail, sir.
Good faith is a matter of trial. Whether he entertained that
No,
faith.
this is on the face of it bad faith. ಎಲ್ಲಿಂದ ಬರೋದು good faith ಇದಕ್ಕೆ?
Kindly have it in the
How
next week.
can you say all
Any
this
date on the
against
next week.
whoever it is?
Senior will address the arguments. He's ready with the arguments. He's just held up in court till 20.
Heard the learned counsel appearing for the respondent, Arvind Neglur, who takes this court through the complaint to demonstrate that the utterances against the petitioner, against the complainant can never be said to be in good faith. List this, the counsel for the petitioner prays time. List this matter on next Tuesday at 4 PM for further hearing.
Very well.
Yes.
80.
Your Lordship, I appeared for a petition.
Vacating stay, who has filed?
Hello, I filed.
This is the matter.
That will be accepted. Don't worry about that.
Your Lordship, this is the matter arised out of a civil dispute. What had happened is in the year 2018, Your Lordship, the second respondent, who is the complainant before Your Lordship.
Last date and order
Last-
passed, my
yeah.
lord. 28/5/24.
Because their allegation in the complaint is that because I have lodged a complaint stating that Your Lordship, some persons have illegally carrying out.
Now,
this
what
stolen-
happened before the concerned court?
Yes, ma'am.
report.
I may be permitted.
That is what I had asked. Yes.
Yes.
Closed or cognizance
Hello?
taken?
No,
There was no
complaint-
FIR registered.
That's-
Police took it on record and they found that it was not a genuine complaint.
Where is this?
Yes, ma'am. And the complaint is that in
You are the
case-
complainant,
No, Your Lordship, here I am the accused, my lord.
accused, correct?
Because their
Complaint
allegation
by
is,
the
the
accused at
allegation
page
is Your Lordship
16.
120. Please, Your Lordship.
complaint by the complainant is at page 16, my lord. By the petitioner before my lord is at page 16.
That is by you,
By
them.
the petitioner.
Iದೇನ್ school da ಇದು? ಇಲ್ಲ.
No, the
Howದು,
school, my lord, that is the
Different.
other matter. which-
Okay, please.
Here on a plot of land which is owned by me,
Yes.
they make a false statement.
Stone quarrying.
Stone quarrying at Hoskeri village, Madikeri Taluk.
Hmm.
Reference to subject we like to bring to your notice to stop quarrying underway in Hoskeri village.
So this was investigated?
It was investigated. They took the Mahazar the statements and then they gave an endorsement, which is at ink page 23, saying that there is no illegal mining and by Ratna Commercial, that is by me, and the petition is closed.
That has become final?
Yes. And the next page is
After that, you have registered a crime against
Yes.
them, saying that it was
a false.
that has become the subject crime.
Yes.
ಅದ್ರಲ್ಲಿ B report ಹಾಕಿದ್ದಾರೆ police.
No, there's no B report. This is all.
No.
No FIR is
Then-
registered.
No, ನಿಮ್ದಲ್ಲ. In the crime registered by you against them.
Yes, that cognizance is taken.
That is what.
Summons is issued to them.
Ah.
And they were appearing till the, on this. honorable
Interim
court.
order was granted.
Yes.
Yes, my lord.
In page 31 to the petition is the summons issued to them.
No. Now the complaint, the petitioner has produced concocted, created photographs
Yes,
and files a false and frivolous complaint before Madikeri police.
yes,
The police, after investigating, file a B report. That is B report or closure report, whatever. Complaint is registered on the basis of the report filed by the police. If the court is accepted, B report. There was no acceptance of B report at all.
No,
There's no B report.
no. May
My
I
complaint, my
submit,
lord,
my lord?
is
May I
that,
submit?
ಈಗ ಆಯ್ತು ಹೇಳಿ ಮೇಡಮ್.
My lord, what have happened is on 23rd March 2021, your lordship, villages, your lordship, some of them have signed the complaint. They lodged complaint before the deputy commissioner as well as to the superintendent of police. Thereafter, what happened is that very same complaint is forwarded to the senior geologist, wherein they have come to the spot and spot mahazar is done. Then the report is submitted, your lordship. Thereafter, the endorsement, whatever my
No illegal mining.
yes, there is no illegal mining. Even otherwise also there is one order passed by the senior geologist. I may be permitted to file along with the memo.
What order is?
That is what it says, that your lordship, they have permitted them to remove the illegal mining.
So there was illegal mining?
Yes, your lordship.
That is
order
before your
26
complaint or after your complaint?
My lord, that's my after my complaint.
Before the closure or after the closure?
It's in fact after the closure. What is happened?
After the closure, how can they say that one authority is saying there is no illegal mining?
My lord, the moment when they purchased the land, your lordship, we have started objecting it before the Grama Panchayat as well as before the deputy commissioner, because for the purpose they did. Then I approached this honorable court. This honorable court directed us to appear before the deputy commissioner and file objection. Immediately after that, this incident taken place, my lord. The moment, your lordship, may kindly see the order passed by division bench of this honorable court at annexure E, page number 56. Pushpa Kuttanna is the petitioner before your lordship, and the other. So wherein direction is issued. Immediately after that, your lordship, they filed PCR. Their only allegation is that, your lordship, because I have submitted false information. It is not so. Because the villagers, they submitted complaint before the authority saying that there is a illegal mining. Thereafter, the proceeding is commenced, your lordship. And the order is also passed.
Where is that? A memo kodi?
Please, your lordship. That is, I produced at page number 7, my lord.
20.
The first, yes, your lordship. First page number 2 is the complaint.
Page number 2 is the complaint.
Yes, your lordship. Because I have Department of Mines and Geology also I have submitted as well.
All
as to
right.
the- Then thereafter, your lordship, they files application seeking permission.
No, who are you?
I am the villager,
One of the village.
one of the villager.
Ah, yes.
Thereafter, spot mahazar is conducted at page number 5, my lord.
And it is found that there is illegality?
Yes, your lordship, may kindly see second paragraph. ದಿನಾಂಕ 24-21ರಂದು ಈ ಮೇಲ್ಕಂಡ ಅಧಿಕಾರಿಗಳ ಸಮಕ್ಷಮದಲ್ಲಿ ಸಮಸ್ಥಳಕ್ಕೆ 12 ಗಂಟೆಗೆ ಬಂದು ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ಸ್ಥಳವು ರತ್ನ ಕಮರ್ಷಿಯಲ್ ಎಂಟರ್ಪ್ರೈಸಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ರವರಿಗೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸು ಜಾಗದಲ್ಲಿ ಮನೆಯನ್ನು ನಿರ್ಮಾಣ ಮಾಡುತ್ತಿದ್ದು, ನಿರ್ಮಾಣದ ಸಂಬಂಧ ಅಡಿಪಾಯ ತೆಗೆಯಲು ಅಡ್ಡಿಯಾಗಿರುವ ಬಂಡೆಗಂಡುಗಳನ್ನು ಯಂತ್ರವಾದ ಜಾಕ್ ಹಾಮರ್ ಮೂಲಕ ಕೊರೆಯುತ್ತಾರೆ. ಸದರಿ ಜಾಕ್ ಹಾಮರ್ ಗಳಿಗೆ ಕಂಪ್ರೆಸರ್ ವಾಹನಗಳಾದ 4 ಟ್ರಾಕ್ಟರ್ಗಳನ್ನು ಬಳಸಿರುತ್ತಾರೆ. 29 ಗುಂಡಿಗಳನ್ನು 1 ಮೀಟರ್ ಆಳದ ಗುಂಡಿ ಹಾಗೂ ಸೋನ್ಸು ಗುಳಗಳು.
This is by whom?
This is by the senior geologist.
right?
Yes, sir.
Thereafter order is passed.
You have produced it? ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ, ಇವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದ್ರಲ್ಲೇನೆ also says that ಬಂಡೆಗಳನ್ನ ತೆಗೆದಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. Permission
ಮತ್ತೆ 177 ಹೆಂಗ್ ಬರುತ್ತೆ?
My lord, please see ink page 13, my lord. The report.
What report?
This is by the police inspector, rural police, to the police commissioner. Ink page 13. I just filed it now, my lord.
Well, I think it's 24, my lord.
13, yes.
Yes. Starts page, sorry, page 24. No, page 13. Page 13. If my lord is pleased to turn the page over at page, page 25. My lord permits, my lord, my learned friend will read out the unnumbered paragraph 4.
ಯಾವ್ದ್ರಲ್ಲಿ? page 13 ಅಲ್ಲ?
25.
25. One moment. ದಿನಾಂಕ 25/3 ಅದ?
Yes.
ರತ್ನ ಕಮರ್ಷಿಯಲ್ ತಾವು ಹೊಸಕೇರಿ ಗ್ರಾಮದಲ್ಲಿ
ದಿನಾಂಕ 25/3/2021 ರತ್ನ ಕಮರ್ಷಿಯಲ್ ಅವರು ತಾವು ಹೊಸಕೇರಿ ಗ್ರಾಮದಲ್ಲಿ ಮನೆ ನಿರ್ಮಿಸುವ ಸಮಯದಲ್ಲಿ ದೊರೆತಿರುವ ಉಪಕಣಜಗಳನ್ನು ತೆರವುಗೊಳಿಸಲು ಗಣಿ ಮತ್ತು ಭೂ ವಿಜ್ಞಾನ
ಷರತ್ತನ್ನು ನೀಡಿ ಆದೇಶಿಸಿರುತ್ತಾರೆ.
That order I have produced along.
The
with
next
you.
page 26.
ಆಯ್ತು, what is
Again,
this?
after.
My lord, this is a false complaint.
Now,
They are
1
not
minute, sir.
farmers.
That has touched your ego now?
Not ego, my
Then
lord.
what, sir? What has happened because of the
False
complaint?
complaint.
Where is it false? There, it is the information given by the geologist. They have said
Please see, my lord.
they are
this is-
villagers protesting against something that is
My
happening.
lord, their complaint is filed on 23/3/21. 23/3/21. This permission of 6/4/21, which is referred to in the.
Now, what
complaint.
became of that?
Please, my lord.
What became of that?
My
That
lord,
is, that is not an information that they have generated by themselves. There are supportive documents to show that on the basis of that, they have registered the
They
crime.
have produced,
Not the crime, a complaint rather.
no, they have produced photographs
Ah.
which have been marked with the trial court, which shows that they are false photographs. Our complaint is restricted to para 7. That's the 177 allegation. The accused persons have created 4 photos and filed a false and frivolous complaint to the Madikeri Rural Police, stating that some miscreants in the village are carrying out stone quarrying and also disturbance to the villagers. Accordingly, actually, in order to mislead the police department, the
Yes.
complaint dated so and so was lodged by the accused persons against some miscreants in the village for illegally carrying out stone quarry. But on the other hand, the complaint dated 23/3/21 was indirectly had a reference to the complainant. That ultimately led to the police to the property of the complainant on the behest of the.
Where is
accused
the FIR, crime, private complaint?
It's PCR. ma'am.
Yes, cognizance is taken as ink page 27 to the petition for offense under 177.
120B and 127.
Yes,
My lord, initially it was for 120B and 177. Subsequently, it is, Your Lordship, kindly see page number 27.
yes.
7. Order cognizance is taken for the offense punishable under 120B and section
177.
177 CR, please.
Yes.
Then thereafter next order, Your Lordship, kindly see. Page number 31,
Only 177.
177.
Summons is only under 170.
Yes, summons is only under 177.
I read with 34. 177, my lord, reads,
Read with 34. Even otherwise,
furnishing
What
false
is this
information.
pursuing these frivolous cases?
My lord, they have, my lord, continued because they are not farmers, like my learned friend would like to make out. They are all estate owners, large estate owners. I have purchased an estate, and pursuant to my lord's earlier direction, respondent deputy commissioner was pleased to conduct proceedings. Thereafter passed an order
So
upholding.
they were, see, they are agitating their rights. They were before the division bench in a PIL also.
My lord,
That is
May I
annexure E
submit
page
this, my lord?
63.
the entire case which they made out in the petition is to try and project that they have been acting on behalf of public rights. Now, when they filed the case, my lord had earlier passed an order directing the deputy commissioner to redo the procedure for conversion after hearing everybody. Thereafter, my lord, the deputy commissioner had passed an order granting conversion of the land to me, which was again challenged by them before the learned single judge of this honorable court. This honorable court was pleased to uphold that.
The school, the World Environment School.
ಹೌದು ಹೌದು ಅದೇ
Hello?
ಅದೇ ಸ್ವಾಮಿ
World Environment School case ತಾನೇ ಇದು?
ಹೌದು
Yes, it's an.
You said no, it's not the school case.
ಸ್ಕೂಲ್ ಕೇಸ್
No, that is their case in the.
The case is a
petition.
different thing.
In their
They
petition.
have been agitating this cause right from the beginning. I am asking you, where is the false information in all
The
this?
false information. The false information to say, please see, my lord, 25(3), my lord, the permission of the geology, etc., which is caught putting me to terms for blasting for between 6 to 6. Their complaint is on the 25th of March. The geology department is the 6th of April. It is not before, it's after. My lord, it cannot be that somebody who is there in court is unhappy with what I'm going to do and continues to harass me by filing false complaints. The complaint, my lord, is limited to that particular paragraph of paragraph number 7 in the complaint, nothing more. And the trial court has taken cognizance, issued summons.
Now you have established the school?
Not yet, my lord, because we have to get all the sanctions and permissions because of their continued pursuing. of the-
ಅದೆಲ್ಲ ಮಾಡಿ, you are intimidating them by registering
I'm not intimidating them,
177.
my lord. because of the project, my lord is pleased to see, project cost was $1 so many years back. Now because of, they are continued pursuing based on false allegations, cost of construction has gone up. Instead of promoting and accepting, they are happy with resorts coming there. And environment school, they are unhappy. My lord, a false complaint under 177, my lord. They cannot misuse that.
We'll answer it.
Please.
Heard the learned counsel for the petitioner and the respondent list on Friday, the next for dictating orders. You look into that. If there's anything to be said on that, tell me.
Please, my lord.
Any documents? Yes. List on next Friday, 5th July. Huh? Settlement 230, ಎರಡು ತಗೊಂಬಿಡಿ.
Reporting settlement. Bill number 105.
One mentioned to me, serial number 94.
Huh?
Serial number 94, much I have mentioned.
Huh?
I have applied for passport renewal, please.
Wait, take it.
105.
ಇಲ್ದೇ next week ಹಾಕ್ಬಿಡಿ.
106. 106. 107. 107.
The parties are also present.
Both side parties are present with me.
Huh?
Is the
Offense.
498.
487 and DP Act.
Okay, 498. First separate order sheet, so and so appears for so and so. ಎಲ್ಲಿ settlement ಆಗಿರೋದು?
Yes, my lord. In the family
Also
court.
filed.
Family
yeah.
court.
For the respondent, I'm filing my wakalat along with the.
Where is the settlement before the family court? Annexure?
Annexure E, my lord, page 87.
Ah. Clause 789 at page 81, quote that test. Yes,
Both side parties.
next.
130. Reporting settlement. 113.
Dhananjay Kumar.
Apply for the respondent.
ಏನು
What
offense?
is-
Offense ಏನು?
ಇದರಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ.
Offense ಏನು?
ಕಾಲ್ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
Pass over, yes. ಎರಡು ಅದೇನಾ?
498 ಇದು.
498 ಏನ? ಕೊಡಿ.
ಇದಾರೆ ಪಾರ್ಟೀಸ್ ಇದೆ. ಪ್ರೆಸೆಂಟ್
Parties are there?
ಇದಾರೆ ಪಾರ್ಟೀಸ್ ಇದಾರೆ.
ಕೊಡಿ.
ಎರಡು ಇದೆ.
Joint family.
ಇದೆ.
ಕೊಡಿ ಪೆಟಿಷನ್ ಅವ್ರು ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡಿ ಪರವಾಗಿಲ್ಲ. ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ ನೋಡ.
As per mediation agreement. Matter.
Where is the mediation agreement?
Produced.
ಈಗ ಮಾಡಿದ್ದೀರಾ?
ಅದ್ರಲ್ಲಿ ಇದೆ.
ಮುಂಚೆನೇ ಐತಾ ಈಗ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಮುಂಚೆ ಮಾಡಿದೆ.
ಧನಂಜಯ್, where is the mediation agreement? The KG filed an application under section 320 of the CRPC. Mediation agreement ಕೊಡಿ.
Counter file ಮಾಡಿದ್ದೇವೆ. Another copy.
ಕೊಡಿ ಕಾಪಿ ಕೊಡಿ. ಇದೊಂದು ಕೋಟ್ ಮಾಡಿ.
That my lord, they have in the paragraph number 9, my lord, they have admitted to withdraw this criminal case, my lords.
Page?
ನಾನು ಅದು ಆಫೀಸ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದು ಸರ್.
ಇಲ್ಲಿ ಅಗ್ರಿಮೆಂಟ್ ಇದೆಯಾ?
ಹೌದು ಸರ್.
ಎಲ್ಲಿ ಉಂಟು ಇಲ್ಲಿ?
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಆಗಿದೆ sir.
Order sheet
And
record
my lord, houds, and the complainant has admitted that, my lord, she is ready to, my lord, withdraw the criminal petition before this honorable court.
Anyway, ಇಬ್ರು ಸೈನ್ ಮಾಡಿ ಅದೇ ಸಾಕ್ಬಿಡಿ. Sounds 498A.
Yes, both the matters, same matter.
Same. ಎರಡು ಕೇಸ್ ಯಾಕೆ 498?
ಅದು ಫಸ್ಟ್ ಗೆ ಅವರು ಬಾಕಿ ಅವರು ಬಂದಿರ್ಲಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಮತ್ತೆ ಕ್ಲಬ್ ಮಾಡಿ ಒಟ್ಟಿಗೆ. All the accused.
Yes.
Please.
Order sheet.
Party.
115.
For the petition. Both parties are present before the court.
ಎಲ್ಲಿದ್ದಾರೆ? Offense ಏನು?
420 million.
Only 420?
Please, my lord.
Where is
420.
application
They-
compounding?
They have handed over the possession of the D property.
Respondent ಯಾರು?
Respondent complainant.
Counsel ಎಲ್ಲಿ?
Counsel ಬಂದಿಲ್ಲ.
How do I?
Previous case ಮತ್ತೊಂದು connected matter ಅಲ್ಲಿ ಬಂದು appear ಆಗಿದ್ದಾರೆ ಇದ್ರಲ್ಲಿ counsel ಬಂದಿದೆ.
ಆಯ್ತು, but how do I know who is the complainant? Somebody should recognize.
ವಕಾಲತಲ್ಲೆಲ್ಲ ಸೈನ್ ಹಾಕಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
Connected matter ನಲ್ಲಿ ಇದೆ. ಈ ಕೇಸಲ್ಲಿ ಇಲ್ಲ, connected matter ಅಲ್ಲಿ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
Which is that connected matter?
That is disposed of, my lord. 3009 ಅಂತ ಹೇಳಿ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
ಅದ್ರಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು?
ನಿಮ್ಗೆ ಯಾರು ಹೆಸರು? ಸೋಮನಾಥ್ HS ಅಂತ.
ಸರಿ, ಯಾರಾದ್ರೂ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು ತಾನೆ?
ಹೊಸ ಅಡ್ವೊಕೇಟ್ ವಕಾಲತ್ ಅವ್ರ ಕಲಿಗೆ ಹಾಕ್ಬೋದು.
ಆಯ್ತು, ಯಾರಾದ್ರೂ ಸರಿ, ನಾಳೆ ತಗೊಳ್ಳ. ಎಲ್ಲಿ, ವೇರ್ ಆರ್ ದೇ ಫ್ರಮ್ ಬ್ಯಾಂಗ್ಳೂರ್?
ಬ್ಯಾಂಗ್ಳೂರ್ಲಿ.
Then ನಾಳೆ get the advocate.
ಟೈಮ್
4 PM.
4 PM.
Tomorrow 4 PM you come.
Please.
Yes. All conditions fulfilled, huh? Yes, next.
30 more matters. Bill number 1, Adi Narayan.
Both parties are present.
Settlement. Settlement.
Settlement.
Offense.
498.
Yes.
Complaint and respondent.
Complainant first time idara complainant.
ಇದಾರೆ.
Okay. So and so enters appearance. ಆಯ್ತು, ಸೈನ್ ಮಾಡಿಸ್ಬಿಡಿ. ಎಲ್ಲಿದೆ ಸೆಟಲ್ಮೆಂಟ್? ಎಲ್ಲಾಗಿದೆ?
Both are decided together.
ಮೀಡಿಯೇಷನ್ ಆಗಿದೆಯಾ? ಎಲ್ಲಿ?
ಇಲ್ಲ ಇವರೇ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡು.
ಎಲ್ಲಿದೆ?
Affidavit she had filed the affidavit. ಅದರಲ್ಲ ಕೇಸ್
ಏನಾಗಿದೆ? both of you are staying together now?
staying together.
Reunion.
Reunion.
KG reunion ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡಿ. ಇಲ್ಲಿದೆ ಅಫಿಡವಿಟ್, ಇದು ಕೋಟ್ ಮಾಡಿ. Yes, so and so appears for the second respondent ಅಂತ ಮಾಡಿ ಕ್ಲೋಸ್. Yes.
Parties present.
Next.
Order seal number 2, Srimati Hemavati HS.
ಓ ಮೇಡಮ್, ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಟ್ಟೆ ಅಲ್ಲೇ. ಮೇಡಮ್ ಲಿಸ್ಟ್ ಕೊಡಿ. ಅಲ್ಲೇ ಇದೆ.
230 more matters.
The petitioners, my lord, are the officers of the SBI.
Respondent ಈಗ.
ನಾವೆಲ್ಲ ಒಂದೇ. Petitioners, my lord, are the officers of SBI. Respond number 2, my lord.
Officers of SBI.
Yes, please, madam.
ಮತ್ತೇನ್ ಪ್ರಾಬ್ಲಮ್ ಈಗ?
Yes, madam. The respond number 2, my lord, is the borrower. And my lord, he borrowed, my lord, about 113 crores in the year 2009. Thereafter, my lord, he committed default. As a result, my lord, the bank was forced to initiate my lord, recovery proceedings, DRT, my lord, SHRI, thereafter, my lord, CBI complaint, etc. But in ED also. But being aggrieved by that, my lord, the complainant herein, but has filed the present instant, my lord, the false case. But alleging that, my lord, the officers, they took possession of certain building, my lord, which was given as surety. And my lord, certain movables were there and they have committed theft. And my lord, committed offences punishable under sections 380, 420, 468, 409, 465, etc. Now, my lord, he filed the present
384 ಇಲ್ವೇ ಇಲ್ಲ?
380,
380 ಎಲ್ಲಿದೆ? ಓ ಇದೆ. Yes, yes.
380. Not he filed a private complaint, not referred for investigation under section 156(3). But the police now not registered the case and not summoning the officers every day. Not every day he is issuing notice to appear, and it is not practically harassment. Having taken loan, of 113 crores. Now it is 300, nearly 300 crores. But and in fact, he also not approached the Honorable Supreme Court. Even in the Supreme Court, the Honorable Court was pleased to observe that we first pay and then come. That is the observation of the Honorable Supreme Court.
Again, problem ಏನಾಗಿದೆ?
Now, case is registered and every day, the officers are made to appear before the investigating agency.
Yes, sir.
21ಕ್ಕೆ FIR ಆಗಿರೋದು.
ಅದೇ ಪೊಲೀಸ್ನವರು ಮುಂದೆ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಕೂತಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೆ ತಗೊಂಡೆ. ನೀವು ಸ್ಟೇಷನ್ ಇರಿ, ಬ್ಯಾಂಕ್ ಯಾಕೆ ಹೋಗ್ತೀರಿ? ನಿಮಗೆ ಲೋನ್ ಬೇಕಾ?
PCR ರೆಫರ್ ಮಾಡಿರೋದು.
ಗೊತ್ತಾಯ್ತು, ರೆಫರ್ ಆಗಿರೋದು.
ಹೌದು.
ನಿಮಗೆ ಲೋನ್ ಬೇಕಾ?
ಅಲ್ಲ, ಬಟ್ ವಿ ಹ್ಯಾವ್ ಟು.
ಅವ್ರು ಕರೆದ್ರು ಬರ್ತಾರೆ, ನೀವು ಎಲ್ಲಿರ್ತೀರ ಅಲ್ಲಿಗೆ. ನೀವ್ ಯಾಕೆ ಬ್ಯಾಂಕ್ ಹೋಗ್ಬೋದು?
ಇಲ್ಲ, ನಾವು ಬ್ಯಾಂಕ್.
ಅದೇ ಅದನ್ನ ಹೇಳಿ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ದವ್ರು. ವಿ ವಾಂಟ್ ಲೋನ್, ಯು ಗೋ.
ಇಲ್ಲ, ನಮ್ಮವರು.
Or else where you sit, you call them, they will come.
ಇಲ್ಲ, he is saying that we are calling him every day.
Yes, but I have the police notices under section 41A. But yesterday.
You have to cooperate with the investigation.
There is absolutely no issue. But we apprehend that there is, because of the high influence of the respond number 2, who was also MLC, and he having muscle.
MLC?
Yes, former MLC.
Complainant.
Yes. He is having all powers, muscle, political, financial. Yes. But in fact, when the court commissioner went to take possession of the property, they were manhandled. In fact, the court commissioner filed complaint against the respond number 2 herein.
21ಕ್ಕೆ FIR ಆಗಿದೆ. Not
ಎರಡು ದಿನ ಆಗಿಲ್ಲ FIR.
Will cooperate with the investigation. Yes.
Cooperate with the investigation. They will not arrest you.
Please, but let there be an order.
The petitioners, officials of the State Bank of India, are knocking at the doors of this court, calling in question registration of a crime in crime number 410 of 2024 for it for it having been registered on 21/6/2024. 21/6/2024, after the learned magistrate referring the matter for investigation. Even before the ink on the complaint or on the registration of the crime could dry, the petitioners are before this court, contending that they are being repeatedly called to the police station or the police have been to the bank repeatedly. Therefore, the petitioners shall cooperate with the investigation, but in the garb of investigation, no coercive action shall be taken against these petitioners, nor harassed, as they are officials of the bank. The investigation, after the conduct of investigation, the papers of such investigation be placed before this court on the next date of hearing.
But may I request to grant an interim order so that.
For what, sir? Crime ಎರಡೇ ದಿನ ಆಗಿದೆ. ಎರಡೇ ದಿನ.
That is true, 2 days.
ನಿಮಗೆ ಗೊತ್ತು, 2 days ಅಲ್ಲಿ FIR.
I understand, but not because of the harassment.
I have told no harassment.
In fact, he has no competence to file the complaint at all.
Who?
The complainant.
Why?
Because he has already lost possession of the
what
property.
Competence you want? Criminal law can be set into motion by anybody.
But I'm not.
Then where is the competence?
But his grievance is possession of the building is taken and keys are handed with the jurisdictional.
That's on the merit of the matter.
I understand.
He has no locus to file the complaint. Question. Issue of locus is unknown to criminal law. Yes.
Notice.
Learned additional SPP is directed to accept notice for the first respondent. Emergent notice to the second respondent returnable by 24th July.
Yes.
ಅಷ್ಟೊತ್ತಿಗೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನ್ ಮಾಡಿದ್ದೀರಾ? ಪ್ಲೇಸ್ ಇಟ್. ಎಸ್.
Admission seal number 3.
ಇದು ಥರ್ಡ್ ವಿಡ್ರಾಲ್ ಇನ್ ಟರ್ಮ್ಸ್ ಹಾಕಿಲ್ವಾ? ಸಬ್ಮಿಷನ್, ವಿಡ್ರಾಲ್ ಸಬ್ಮಿಷನ್ ಗೊತ್ತಾಗುತ್ತೆ. ಚೆಕ್ 40th ಅದು 40th. ನೀವ್ ಯಾಕೆ 230 ಮೂವ್ ಮಾಡಿದ್ರಿ?
ಕೇಳಿದ್ರೆ
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಕೊಡಿ
ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಬಿಡಿ ಸ್ವಾಮಿ. 2019 ಕಂಪ್ಲೀಟ್ ದ ಟ್ರಯಲ್ 6 months.
ವಿಡ್ರಾ ಮಾಡ್ತಿರೋದು ಪೆಟಿಷನ್, ಅದರಲ್ಲೊಂದು ಡೈರೆಕ್ಷನ್. ಮೆಮೋ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಮತ್ತೆ ಲಿಬರ್ಟಿ ಕೇಳಿದ್ದೀರಾ?
ಲಿಬರ್ಟಿ ಏನಿಲ್ಲ, ವಿತೌಟ್ ಕಂಪ್ಲೀಟ್ ದ ಟ್ರಯಲ್ ಕೇಳಿದ್ವಿ ಅಷ್ಟೇ ಸರ್. ಟ್ರಯಲ್ ಮುಗಿಸ್ಕೊಡಿ.
ಅದಕ್ಕೆ ವಿಡ್ರಾ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಮ್ಯಾಂಡಮಸ್ ಕೊಡ್ಬೋದು ಅಷ್ಟೇ.
ಡೈರೆಕ್ಷನ್ಸ್
ಏನ್ ಬೇಕಾದ್ರೆ ಕೊಡಿ.
ಲೆಫ್ಟ್ ಟು ದ ಕೋರ್ಸ್.
You withdraw the petition. The petitioner has moved this matter seeking its withdrawal, and in the memo for withdrawal seeks a direction for the concerned court to conclude the proceedings within a time frame. In a petition that is sought to be withdrawn, no directions extra can be granted. Therefore, the memo for withdrawal stands rejected. ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
6 months.
6 months.
2019 ಮ್ಯಾಟರ್. ಫಾರೆಸ್ಟ್ ಅಫೆನ್ಸ್
2019. 6 months.
ವಿಟ್ನೆಸ್ ಎಷ್ಟು ಜನ ಇದ್ರೆ ಗೊತ್ತಿಲ್ಲ. ಪೇಪರ್
ಎಷ್ಟು ಜನ ವಿಟ್ನೆಸ್ ಇದ್ದಾರೆ?
28 witnesses.
ಇಲ್ಲ, ವಿಡ್ರಾ ಮಾಡಿ ಸುಮ್ನೆ ಆಮೇಲೆ ಮತ್ತೆ ಹಾಕಿಬೇಕು. I will not direct in a withdrawal. I will not direct you. So
ಡೈರೆಕ್ಟ್ ಫೈಲ್ ಫ್ರೆಶ್ ಪಿಟಿಷನ್ ಲಿಬರ್ಟೀಸ್.
file a fresh petition.
ಇನ್ನೇನ್ ಮಾಡುತ್ತೆ, ಅದಕ್ಕೆ ವೇಸ್ಟ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ತಿರ್ಗಾ ಒಂದ್ ಬರ್ಬಾರ್ದು.
ಆಯ್ತು ಸರಿ.
ತಿರ್ಗಾ
fresh petition ನಿಮ್ಗೆ ಒಳ್ಳೇದು ಬಿಡಿ. Counsel for the petitioner seeks leave of this court to withdraw the petition and file a fresh petition on the same cause of action. Liberty so sought is granted. ಅದ್ ಹಾಕಿ ಅಲ್ಲೊಂದು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು ಮುಗಿಸ್ಬಾರ್ದು. ಎಸ್, ಅದು ಎಲ್ಲ ಟೈಪ್ ಮಾಡಿ at this juncture ಅಂತ ಮಾಡಿ ಇದನ್ನ ಮಾಡಿ. Why is the learned advocate general waiting?
Directed regarding the construction worker.
Yes. Wait. Yes. ಇನ್ಯಾವ್ದು ಮೂಡ್ ಇದೆಯಾ ಮೇಡಮ್? ಅದೇನ್ ಕಮ್ಸ್.
Complied with your lordship's order, my lord.
30,000.
No, 50 and 40, but the issue is this, my lord. 50.
Construction workers says.
Serial 112.
The Prashant ಇದ್ರಲ್ಲ ಅದ?
ಹೌದು. Please.
Prashant BR. He is here. ಅದೇ 30,000.
50,000.
50,000.
50, and the issue is not regarding 50. The problem is this, my lords. Is your lordship's court officer. Yeah.
Request for a copy.
What has happened, my lord?
So, Advocate General, last time I asked him, 6,700 crores is in your coffers. 30,000 ಈ poor people ಕೊಡಕ್ಕೆ you are struggling?
No, it's not the question of not giving.
This is what he said. We are unable to pay 30,000 fees to the children of these construction workers who want to pursue LLB and MBA.
No, man, I mean, as a one-time measure, my lord, what has happened?
One-time measure.
There are 29 schemes which has been provided for all construction workers
Yes.
on year-on-year basis, my lord. Depending upon what is the cess collected in that year, my lord. There are totally 29 schemes. Totally 400 crores is earmarked for education purpose.
1 minute. 400 crores out of 6,700 crores.
Not 600,
Then-
it's around 1,000 crores, my lord.
Out of 1,000 crores, 400 crores.
To be
is-
exact, my lord, the total amount is 1,000, what is it? Page 11, my lords, 1,500 crores, my lords.
1,500 crores.
Is the total cess which we have collected, my lords.
Total cess.
Please, my lords.
Out of that 400 crores is earmarked for
For education purpose, my lords.
education of whom?
All the
Children of construction workers.
Correct.
Correct?
Correct.
Yes.
So there are 11,000 applicants, my lord. 11 lakhs 11.13 lakh applications.
11.13 lakh applications.
Eligible is 9.61 applicants, my lord.
How do you draw eligibility?
For the, depending upon the.
All right, 9.13 lakhs are
9.61 lakhs, my lord.
eligible for.
Eligible, my lord. So what we do is, my lord, out of the total, there are totally 29 schemes, my lord. Your lordship that is, your lordship will get it at page 13, my lord, 13.
29 schemes for
For example, marriage, funeral, alignment, medical, accident.
No, that apart.
Apart from 400.
I am only talking of education.
400.
Education 400 is fixed.
Correct, my lord.
All right.
Now, what has happened?
Out of 400 crores, I asked 0.0001%. That is 40,000 to be paid to these children.
That is not an issue, my lord.
That was an issue. I have passed detailed order.
I've gone through it.
Yes.
I'll just make two submissions. No, I'm not, not adversarial, ma.
Yes.
To find this, What has happened, my lord, is out of the total, we have already paid for nearly 6 lakhs applications, my lord. We have paid 125 crores and another thing comes up to another 125 crores, my lord. What will remain with us is, my lord, is another out of the 400 crores after giving to 9 lakh 61 applicants, another 151 crores will be remaining with us.
157 crores?
151 crores will be remaining with us after giving 9.61 applications. Again, what we are, so after your lordship's direction, my lord, that will be the surplus, but which you have to use for, again, we'll be distributing that 151 crores among the 9.61 applicants. What has happened, my lord? If you give large extent to one person, we will not be able to keep.
No, I'm not telling.
I understand,
Treat
my lord.
everybody equal. There is nobody
That's
special
the
here.
only thing I want.
Just because they have come to court and others cannot come to court, they should not be denied.
That is the point, my lord.
That's all. They should not be denied. Now 6,700 crores ke interest just barutte.
We have included all that. What we are doing is giving
included interest.
No, my lord, this, no, what we are doing that with that, my lord.
6,700 crores is invested in banks.
Adhik ಏನ್ ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತಂದ್ರೆ, we are going to give a pension scheme for all construction workers. We are to them, my lord. We are coming work. It's not going to be kept with us. For other schemes which are lifelong schemes, my lord, we'll place before your lordship. It's not that what we are going to do with the 6,700 crores. My lord. It is not for the purpose of. So therefore, my lord, what we have to do is, my lord, year on year, that interest, what tax is being collected, is being distributed for 29 schemes. And maximum number of applicants are being given on without discrimination basis, my lord.
Now, the main matter is that you have reduced the percentage. What is that percentage?
My lord, it's come down by over 66%. So earlier, what used to be 35,000 and 30,000.
Naturally, my lord, number of applicants have increased. Earlier, that is my.
One minute. Now this 30/10/2023 notification
Please, my lord.
reduces the fee for education in various sectors, various disciplines by 50%.
Over 60%, 66%.
By 60%. 30,000 has become 10,000.
Answer is this, my lord. As against 9,61,000, previous years it was 1,15,000, 1,25,000 and 4 lakhs. So
Applicants.
Eligible applicants.
Now eligibility has gone up to 9 lakhs.
9,61,000. The funds are the same, my lord.
No. Earlier, what was the collection?
Please, my lord. Earlier also what was given is, my lord, in fact, my lord, 22-23 is there here, my lord. What was earmarked was 400 crores. Now we have increased for 23-24, 500 crores. And earlier, the funds were, my lord, around 100 crores, 47 crores.
No, I just want to know, in your coffers, 6,700 ಕೋಟಿ.
My lord, that cannot.
ಇಲ್ಲ, ಒಂದು ನಿಮಿಷ. ಎಜುಕೇಶನ್ಗೆ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. 6,700 crores is there. Out of the 6,700, this is entirely meant for construction workers. Various life happenings of a construction worker, whether it is food, shelter, clothing, medical, all education, marriage, whatever it is. Funeral. So from birth to funeral, everything is covered in that.
Correct.
So now 6,700 crores ಅಲ್ಲಿ interest ಎಷ್ಟು ಬರುತ್ತೆ ಅಂತ ಕೇಳಿ.
I'll have to place.
Because banks ಅಲ್ಲಿ ನೀವೇನು ಫ್ರೀ ಇಟ್ಟಿರಲ್ವಲ್ಲ.
500 crores.
500 crores per annum.
Per annum.
ಈಗ 2023 ಇಂದ ಇಟ್ಟಿದ್ದೀರಾ, 500 crores already ಬಂದಿದೆ.
Please.
So if 500 crores every year you are getting interest of the 6,700 crores you have invested.
Please.
Why not give the same amount? Why do you want to reduce the amount?
Not reduce the number of
number of applicants alla. You number of applicants you divide. If you are giving education purposes, you should give priority that these poor people, children of poor people are getting education and they are growing up.
Your lordship may kindly see the number from previous 1,25,000, 1,15,000. It is increased to 9,61,000, my lords. And we have increased every year. Initially, it was 47 lakhs, 100 crores, 400 crores. We have kept on increasing to 500 crores this year. It is, my lords, it's not in 1 rupee is being given.
1 minute. How do you get this money?
It's cess
collection of cess, right? You are not giving it from the consolidated fund of the state, removing it and giving it to them. It is from the cess collected towards their development.
Only thing they
you
should be
generate this money.
Financial discipline in dispersing the amount.
Financial discipline, yes, you follow, no problem. I am not saying you pick and choose in grant of money, but you have reduced it by 60%.
Not 60, my lord. Your worship, you kindly look at it. Is analogy 60% is not correct. Number of applicants has to be done. If you see the number of applicants, in fact, it is equal, my lord. For example, the number of applicants and the amount, if your lordship sees, it can't be looked at it in isolation. It's like this, my lord. If 100 people, amount is X. If there are 100 people, it is divided. If there are 1,000 people, the amount will naturally come down, my lord. It cannot be said that reduce the number of eligible applicants.
Sir, these are people who can't afford education by themselves. Their children can't afford education by themselves. It is for that purpose, development cess of these construction workers is collected by everybody. We also pay. What is the mode of payment? And what is the method of collection? From all of us, right?
Only on construction, whoever does construction activity.
Does construction activity.
Construction activity, basically builders, irrigation department, only the construction.
All construction activity is imposed assess.
They work in the construction, the ideology is, the principle is, people work in the construction site, the cess is levied, so that the benefit comes back to them.
Now annual collection ಎಷ್ಟಾಗುತ್ತೆ SSL?
That is why, last year it was 1,030 crores, my lord, out of which
1030 crores.
1030, out of which 400 crores is earmarked. Nearly 40% is earmarked for education, my lord.
But where are you paying?
We're dispersing the full 400 crores. Now, each and every pie, my lord.
May I
If
point
you
out-
Now, 1 minute.
These are all.
ಇದು ಹೇಳಾಯ್ತಲ್ಲ, now listen to him.
I'll just, my lord, I was concerned about these numbers that are there in the review application. It is for these very reasons that a CAG audit was ordered through an process of the Supreme Court's judgments. My lords, may please for a moment have page 445. I'm reading from the CAG report of Karnataka's accounts.
Yes.
Education, my lord, of all the things, because the impression being created is that there are so many schemes and that is why there is a shortfall. The CAG reports lists out all the schemes and shows that from the fund on page 445, 90% of applications are only for education.
90%.
90.67% of beneficiaries only for education.
Yes.
Now, as the learned Advocate General has pointed out, all the candidates were also considered. E 90% yes jana idaro, everyone has been considered, and the CAG has noted that the average expenditure per student across any degree is 5,261.
That's all the applicants.
5,261 average cost per student who applies.
Just intervene here. The Supreme Court, as per it, should be given 10,000 rupees is what the Supreme Court has said.
That is
Supreme Court did not say 10,000.
The affidavit is filed by all the states throughout India.
I will come to that. I think what the learned senior is pointing out to is the model code. The model code says this should be the minimum. It does not say this is what it should be. So if 5,261, my lord, this is a 2019 figure. So even if I double it, for 11 lakh students or 9 lakh students, as was pointed out, the expenditure comes to about 570 crores. So the argument to say that we have earmarked only so much under annual collection, even if I assume annual collection to be 1,000 crores and not 1,030 as was pointed out, 1,000 crores, 93.6% applicants are only for education. Expenditure will come.
900 crores only for education.
That's all. 570 crores, even these increased applicants will be covered. The issue that arises, my lord, I will, and the Supreme Court has also pointed out, and the CAG report is replete with these observations specific to Karnataka. It's for all states, that maximum expenses is happening for subjects that are not covered under the Act. Maximum expense is happening for administrative purposes that are not even contemplated within the scheme. I will give one example, my lord. Please have.
Then TADN, huh?
My lords will see, my lord. Please have page number 387.
Madam, which volume?
This will be in volume number, just tell me. Volume 2, page 387. Annexure AJ. Not much turns on this. I'm only citing it as an example as to why this is happening. Please
387.
See, 387, my lord.
Yes.
Please see Karya Suchi 22 V. ಮಂಡಳಿ ಅಧ್ಯಕ್ಷರ ಉಪಯೋಗಕ್ಕಾಗಿ ಇನೋವಾ ಕ್ರಿಸ್ಟಾ ವಾಹನವನ್ನು ಖರೀದಿಸುವ ಬಗ್ಗೆ ಘಟನೋತ್ತರ ಅನುಮೋದನೆ ಪಡೆಯುವ ಕುರಿತು. Yes, they have bought for immediately. They have spent 30 lakh rupees, bought an Innova. They have not taken sanction. After, post facto, they come saying that we are now approving it. This is the kind of pilferage that is happening from the fund.
ಘಟನೋತ್ತರ ಅನುಮೋದನೆ ಅದೇ post facto approval. Yes.
And now, my lords,
Next.
please see also how quickly this post facto permission comes. ದಿನಾಂಕ 12/2/2020 ರಂದು ಮಾನ್ಯ ಕಾರ್ಮಿಕರ ಸಚಿವರ ಕಚೇರಿಯಲ್ಲಿ ಮಂಡಳಿ ಅಧ್ಯಕ್ಷರ ಉಪಯೋಗಕ್ಕಾಗಿ ಒಂದು ಹೊಸ ಇನೋವಾ ಕ್ರಿಸ್ಟಾ ವಾಹನವನ್ನು ಒದಗಿಸುವಂತೆ ಸೂಚಿಸುತ್ತಾರೆ. ಅದರಂತೆ ದಿನಾಂಕ 18/2/2020 ರಂದು ನಂದಿ ಟೊಯೋಟಾ ಮೋಟಾರ್ ವರ್ಲ್ಡ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಬೆಂಗಳೂರು
ಅಲ್ಲಿ 29,29,000
6 days post facto they've approved it. This is not one of the reasons for which the fund is being collected.
Next.
And the students suffering, my lord, my
Yes,
lord,
next. Wait. I'll get back to this.
For it, man.
What, sir? I'll get back. 1 minute.
Because my lord, the reason is this. It's not, again, I'm not saying it's adversary. The question is, my lord, okay, just.
Sir, these poor construction workers for whom no Advocate General, these poor construction workers, children who want to study, you should not stifle it or smother it in this way by getting expenditure elsewhere, doing expenditure elsewhere, or giving them short paying them.
Have 5% of the expenditure as per the statute.
5% of the expenditure. So Innova car. Amele.
Now, my lords,
No, that, my lord, let's not make it so trivial.
No, that's
My learned
not-
friend
sir, that is not
They
the-
are working towards
minute.
saying, my lord.
Why is it projected? Tell me.
My lord.
Why is it
No,
projected?
Your Worship,
Because you are projecting something saying 9 lakh applications are there and it cannot be granted.
not that.
Out of the 9 lakh applicants, it is only for education purposes, what the report says.
That is not correct, my lord. Your Worship may kindly see, my lord, Your Worship may kindly see, I've given, there are 20, Your Worship may kindly turn to page 9 of my affidavit, my lord. I think the copy.
I have it.
Kindly,
ಮುಗಿಸ್ಬಿಡ್ಲಿ ತಾಳಿ. Yes,
ಯಾಕಂದ್ರೆ that's the answer to everything what he's saying, my lord.
you have given him a copy now.
I've given a copy, my lord. I think the reason is.
What else? Expenditure ಹೆಂಗ್ ಮಾಡ್ತೀರಾ? That's what last time also I asked.
Page 9 ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ, my lord.
How do you spend these crores, 6,700 crores that has come to you? On what all heads you spend in the offices?
Page 9, my lord. That is what I'm saying.
9 of today's.
Of today's affidavit, my lord. Each and every paise spent is mentioned, my lord. And in fact, my lord, I don't think I mentioned the expenses. I'll list what the actual expenses per year also. It's not that we want to hide, my lord. Para 15, I state the details.
ಯಾಕೆ this cess welfare fund ಅಂತ ಕ್ರಿಯೇಟ್ ಮಾಡಿದಿರಲ್ಲ, ವೆಲ್ಫೇರ್ ಫಂಡ್ ಗೆ ಒಂದು ಸಪರೇಟ್ ಅಥಾರಿಟಿ ಇದೆ.
Correct.
ಆ ಸಪರೇಟ್ ಅಥಾರಿಟಿಗೆ how do the salary and other things be
Your
paid?
Worship may kindly see, my lord.
Is it from out of the cess or they have something else?
No board, which is your lordship was saying, shall in any financial year incur expenses towards salary, allowance, and other remuneration to its members, officers, other than employees for meeting other administrative expenses exceeding 5% in the total expense during the financial year.
So within the 5%, you should salary, all other expenditure should be there.
Everything under the sun.
Please see page 284.
No, no, because the amount is 1,000 crores, what is showing you the one Innova car, my lord.
I will show
No,
on
that's
this.
all right. No, it is only, no, he says it is only a tip of the iceberg.
My lord, I have a full note on the misuse of funds. Page 298, I'll only.
Government offices and officials not misusing the fund.
Misuse of-
Unknown, sir.
My lord, if
Yes.
there is misuse, we'll curtail it, your lordship, we are bound out, we'll comply with. The
Yes.
question is, before your lordship now is, my lords, out of the funds allocated here, out of the funds for 400 crores allocated, if there are 961 applicants, how should that funds be given, my lord?
If 961, 960. 961,000 applicants are there. And of those applicants, it is 80 or 85% for education purposes.
No, my lord, that's not, your lordship.
No,
may kindly-
90.63%.
No, your lordship may kind of list, my lord.
I'm
I've got
quoting from
practice,
the-
you know, with disbursement of funds, my lord.
I'm quoting from the CAG report, my lord.
CAG report.
PAG report date year ಯಾವ್ದು?
2019.
We are.
After that,
Now, my lords, in this, the biggest finding of the CAG report was that there has been no audit ever. And that is why the CAG audit was conducted. And my lord, on this statistics that was
Every year it's
cited.
been audited.
and where is the every year audit
We'll
of
place it before your lordship.
the place every year's audit here?
My lord, on the specific figure saying that 5% is the maximum administrative expenses possible, the CAG audit finds, which is at page 284, that it has gone up to 9% to 72% of all expenses. Page number 284, annexure AB,
284.
volume 2, my lord.
Is it Karnataka or? which
Yes,
one?
Karnataka. I will actually, I'm grateful for that.
Functioning of building, it is Karnataka chapter.
Please, my lords, may have first page 283. It says compliance order, Department of Labor, functioning of Karnataka. Building and
Karnataka,
Other
it's
Construction.
exclusively Karnataka, sir.
Yes. Now, my lords may see on page 284, there's a table. Right below the table.
Yes.
From the table above, it is distinctly evident that the board did not comply with the provisions of the act, as the administrative expenses ranged between 9 to 72% of the total expenses for the period 2014 to 15 and 18 to 19.
As against
As admissible expenditure of 26.
See, 5% is 26, then avattu 26.95 crores. You have spent 386 crores on miscellaneous expenditure.
Your Lordship, may kindly ask the directors, will place it before your Lordship. Last 3 years, what is the audit, what is the expenses, my Lord? So if that is the, no, we'll place it, my Lord. The question now.
That is why I tell you, this money is meant for poor construction workers, and your white collared officers shall not use it for any other purpose. You are stifling the fate of these people by doing these things.
My learned friend has not produced material past 2 years.
EAG report, sir.
That is of the year 2019.
19, maybe it has gone worse now.
It might have
Produce
improved also. So
Improved to
kindly-
what extent? You come down to 5%.
We'll place it before your Lordship. Based on that, your Lordship may take a call, my Lord, because I'm not defending, I'm being transparent. If it is there, it is
No,
there.
no, it is, if it has gone, if it has gone beyond this 5% on whatever ground, Innova, AC, your lavish tea and coffee, high teas and everything, all that will be cut by this.
File an affidavit to that extent. No. So, and
Definitely.
with the audit report.
I warned Prashant that day. 30,000 ಕೊಟ್ಟಿದ್ದಿದ್ರೆ ಇದು ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ ಅಂತ ಅನ್ಕೊಂತೀರಾ next ಅಂತ.
ಇಲ್ಲ, my Lord,
Yes.
irrespective of that, we have paid 55 through all this. And one more thing, my Lord.
The Lord's order has not been complied with.
It's been complied, my Lord.
When-
Produce the document.
Complied?
Lord, no, it's not complied today. I've still not received anything.
Where is the evidence of payment of fees?
Demand draft is given, my Lord.
Where?
Your Lordship, it's at page number. Where is it? First page, man, of the affidavit. Where's the copy of the DD?
ಎಲ್ಲಿ ಡಿಡಿ ಅವ್ರಿಗೆ ಕೊಡಿ.
Oh, Xerox copy is there.
ಹೋಗಿದೆಯಾ ಅಕೌಂಟ್ಗೆ ಹೋಗಿ ಕಾಲೇಜ್ಗೆ ಹೋಗಿದ್ಯಾ?
ಕಾಲೇಜ್ಗೆಲ್ಲ ಅವ್ರ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಡಿ ಅವ್ರಿಗೆ.
ಅಡ್ರೆಸ್.
I will take instruction. I've not
Yeah,
received.
seek instructions.
In fact, my Lord, we have.
How much have you paid?
50,000, my Lord, each, and two of them, 45,000 to one of them.
Including the cost.
Including
the-
costs.
And
Ah,
interest.
yes. Because the imposed costs.
I mean, I'm not on that, my Lord. There are
No,
two
no,
aspects.
it's all right.
Yeah.
No, I know when you are there, things will definitely steer clear. Because it is not adversarial, it is meant for them.
Absolutely.
The cess is meant for them and not for your white collared officers, no doubt about it.
Like, my Lord, when Justice Vagela was there, my Lord, he had initiated a public interest litigation. He had conducted various with CREDI and various departments, my Lord. In that, in fact, I was appointed as amicus curiae. We did a lot of work on that area, my Lord, throughout various
So you
districts.
should be knowing it through and through. Yes.
Therefore, I'll place before the material before your Lordships, my Lords, insofar as why.
See, the whole problem is the bureaucrats have the habit of taking away funds of poor people and using it for daily expenditure, not for
That
them.
should not be done.
Daily
At
expenditure.
least we'll
It is
stop-
meant for them.
We'll stop.
See, that habit should stop. The buck should stop here now.
Absolutely. ma'am.
It can't go on and on like this. How long do you put these poor people into distress?
In fact, my Lord, whatever.
Money is collected for them.
My only request is whatever material he has note, let him give it to us, my Lord. Your Lordship may have it 2 weeks. I'll look into it and I'll reply to that so that your Lordship, instead of pointing out this.
No,
whatever-
2019, I'm going to record all this audit and other things.
Well, instead of that, my Lord, your Lordship say kindly direct us to give the audit of this year so that.
The
If you-
Barkoli. Heard the learned counsel for the petitioner and the learned advocate general appearing for the state and counsel MRC Ravi appearing for the board. Board so and so. No, senior counsel. No? Sorry. MRC Ravi appearing for the petition. So and so. This court on earlier had order quote madi. The learned advocate general submits that the order is complied with even payment of costs. Appeal ಹಾಕ್ತೀನಿ ಅಂದ್ರೆ ಏನ್ ಮಾಡಿದ್ರಿ?
ಇಲ್ಲ,
ಹಾಕ್ಲಿಲ್ವಾ? ಹಾ ಸರಿ.
Lord, I received one DD. It seems orders were.
I think both are there.
ಕೊಟ್ಟಿರ್ತಾರೆ.
I will take instruction.
So the learned advocate general submits that the order dated first order, Kavya, order is complied with. the learned counsel for the petitioner to seek instructions on such compliance. Since the fees is now paid, the issue now swings back to the main matter. The petition calls in question a notification dated 31/10/2023 by which the amounts that the petitioners and the like were entitled to have been grossly reduced. The learned counsel for this court on the last occasion, on a last occasion in the order dated so and so, had directed the board to place on record by way of an affidavit the amount that is in the coffers of the fund and the expenditure that takes place of the said fund. An affidavit is placed by the secretary and CEO of the board of the fund, or the board rather, board. The affidavit reads that 6,700 crores is deposited in various banks, which undoubtedly would earn interest. And several kinds of expenditure that is made, numbering from 1 to 19, are depicted in the affidavit. The learned advocate general would seek to impress upon that there are about 29 schemes which are to be used for the benefit of the construction workers. If construction workers, as the cess every year is collected from the people undertaking construction for the purpose of the betterment of the construction workers and their families. The expenditure that is indicated is subject to verification and other information by the petitioner. The learned counsel appearing for the petitioner would take this court through a CAG report of the year 2019, which with a specially dedicated chapter to the state of Karnataka. The Auditor General has indicated
284,
at page 284. The Auditor General indicates that the expenditure under the act permitted to the miscellaneous administrative expenditure permitted under the act is to the tune of 5%. And the indication in the report of the CAG is that the expenditure has gone from 5%, which had to be at 26.95 crores, to 386.54 crores, which is to 72%. Therefore, according to the
mention the year, can you mention the year, Manoj?
Though the report is for the year 2019 and 5 years have passed by, the objection was that there was no audit conducted of the funds that come into the fund and its expenditure. The learned advocate general submits that every year audit is conducted, and the yearly audit with regard to the amount that has come in and the expenditure that they have incurred in every head of expenditure will be placed before the court.
Not only head of expenditure and other expenses, Manoj, administrative expenses.
Every head of expenditure, including every head of administrative expenditure, will be placed before the court, threadbare. The submission of the learned advocate general is placed on record. The learned counsel for the petitioner further submits that the cess fund that is received into the cess fund that is received is spent elsewhere. To quote an illustration which the learned counsel for the petitioner submits is a tip of the iceberg. A purchase of the car to the secretary of the board, which is given a post facto approval within 6 days. Be that as it may, complete audit reports of the board be placed before the court by the next date of hearing. 2 weeks.
One submission being. Can you take the affidavit? Para 18, page 11, para 18.
Page
11, para 18. Can you see, my lord?
Amount of cess, sir.
Amount of cess collected, 2018-19.
No problems. I am not on that. 6,000 permanent crores idiyala ಈಗ?
No, no, please go to page, paragraph 19. Kindly see, my lord, para 19. See the application, this number of application received. 2019-20, 1,37,000. 2020, 1,85,000. 21-22, 6,42. Now 2023, 11,13. Now my lord, earmark budget is 400 last year, now 500 crores. If it is for 9,61,000 applicants, it comes to about 1,600 crores.
That was my submission that it doesn't, my lord, because the average cost.
You clarify all that, yes.
1,600 crores.
Now you have given him a copy of the affidavit, he will clarify. Yes.
Only 1,000 crores. May I submit this? It is nothing but an estimate gone wrong. Well, bona fide estimate gone wrong. Because 500 crores estimate has now gone to 1,600. If I may not spend all this money.
No, that's why your expenditure from 5% has grown to 72%. Same way it grows.
That may not be for all the year, maybe.
Whatever, sir.
For those years, what happened is my learned advocate general said, the court was insisting us to go for membership drive. So we were going for marketing, advertisement, all. Another thing, when I did that thing, in Mangalore, fishermen were registered as construction workers. In one
No,
day,
that is why there may be frivolous cases.
In one day, agriculturists were registered as construction workers. Therefore, Manoj, we took a Herculean task to remove them as construction workers. And during that period of time, there was drive to see that the money is released also, Manoj, irrespective of who it was.
No, I am
So therefore,
not. Yes, the state will definitely take care of these people. It's a different thing. But the money that comes into the coffer should be spent on them. That's all.
We'll see that at least henceforth, Manoj, from.
And if applications for education are there, you're uplifting a family by giving education to the child. So that definitely it's not.
No, there's no quarrel.
That is why I passed that order in anger that 30,000 is not ready to pay.
In fact,
6,700 ಕೋಟಿ ಇದೆ 30,000 ಇಬ್ರು ಸ್ಟೂಡೆಂಟ್ಸ್ ಕೊಡಕ್ಕೆ ಹೊಡೆದಾಡ್ತಾ ಇದ್ದಾರೆ.
No.
Yes. No, that's why I see the order, the tenor of the impose costs also. Because of the submissions that it cannot be paid. I told him, seek instructions and come. If they are releasing the payment by 4 o'clock, definitely I will not pass any order. He came with instructions with the officers that they are unable to pay 30,000 because 6,700 crores was in the coffers.
After what I found out, Manoj, after giving for 9,61,000, Manoj, nearly another 151 crores is remaining for education purpose because they have gone on a principle. What I have suggested also, Manoj, in fact, they have agreed also that 151 crores again will be distributed among 161.
We'll see.
9,61.
We'll see the distribution and we'll solve this problem once for all.
And the future also.
By taking undertakings from you and recording everything. Henceforth, this problem of construction workers not getting money should not crop up again. Yes, we'll see what is to be done with the notification.
And we'll file an additional affidavit,
whatever additional affidavit you want. The affidavit be filed by the next date of hearing. I'll grant you time up to 26th July.
Please.
Left on 26th July at 3:30 PM for further hearing.
Deeply obliged.
Grateful to.
Yes. Madam, other matters agenda. ಆಗ್ಬೋಣ ಆಯ್ತು ಸೆಕೆಂಡ್ ಖಾಲಿ ಇದೆಯಾ ಫಿಫ್ತ್ ಹಾಕೋಣ ಎಸ್ ಕಾಲ್ ಪೇಜ್ ವೈಸ್ ಕರೆದ್ಬಿಡಿ matters where interim order is there from admission only will be listed after 2 weeks. Where interim orders are not there will be listed on 2nd. Yes. Wherever interim orders are there, they will be continued.
Passover matter.
Passover and that passport matter I'll take. Others need not wait.
But serial number 99.
ನಿಮ್ ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ ನಾನು ಎಲ್ಲ ಸರಿ ಗಲಾಟೆ ಮಾಡ್ತೀರಾ ಹೋಗಿ ಬ್ರಾಂಚಿಗೆ ವೈ
No, just today is
ಎವ್ರಿ ಟೈಮ್ ಗಲಾಟೆ ಮಾಡ್ತೀರಾ ನಿಮ್ದೇ ಮೇಮ್ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಬರೋದು ವೈ
22nd post ಆಗಿದೆ ಇವತ್ತೇ post ಆಗಿದೆ
ಆಯ್ತು ಪೋಸ್ಟ್ ಆಗ್ತೀನಿ ಪೋಸ್ಟ್ ಆಗುತ್ತೆ ತೊಂದರೆ ಇಲ್ಲ
ಸೆಕೆಂಡ್
ವೈ ಇಂಟರ್ ಮಾಡರ್ ಇಲ್ವಾ ಇದೆಯಾ ಮತ್ತೆ ಹಾಕ್ಬೇಕು
ಅದೇನಾಗಿದೆ ಅಂದ್ರೆ ಕ್ಯಾಪ್ಟನ್ ಆಫ್ ಡೆಲ್ಲಿ ಏರ್ ಫೋರ್ಸ್ ಜನರಲ್ ಕ್ಯಾಪ್ಟನ್ ಸೊ ದೇ ಹ್ಯಾವ್ ಸೆಟಲ್ಡ್ ಇನ್ ಡೆಲ್ಲಿ ಸೊ ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಟು ಹ್ಯಾರಾಸಿಂಗ್
ಏನ್ ಹ್ಯಾರಾಸಿಂಗ್ ಇಂಟ್ರಿ ಮಾಡರ್ ಇದ್ಮೇಲೆ ಹ್ಯಾರಾಸ್ಮೆಂಟ್
ಅಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ಟು ಸೆಟಲ್ ಆಲ್ ದ ಇಶ್ಯೂಸ್ ಫ್ರಮ್
ವಿಲ್ ಸೆಟಲ್ ಆಲ್ ಯರ್ ಇಶ್ಯೂಸ್ ಇಂಟ್ರಿ ಮಾಡರ್ ಇಲ್ದೇ ಇರೋದೆಲ್ಲ ಸೆಕೆಂಡ್ ಹಾಕಿ ಮಿಕ್ಕಿದ್ದು ಲಿಸ್ಟ್ ಆನ್ 23rd ಡೇಟೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
One submission, serial number 99.
23rd
has been uploaded in the stating that.
ಸ್ಪ್ಲಿಟ್ ಚಾರ್ಜ್
Yes, split charge.
ಆ ಸ್ಪ್ಲಿಟ್ ಚಾರ್ಜ್ ಒಂದು ಫ್ರೈಡೆ ಹಾಕಿ ಮಾಡಿ.
Next matter.
Split charge ಮಾತ್ರ ಹಾಕಿ Friday. 99.
23rd of July.
All others, yes.
Serial number 109. 2000.
Second and 23rd, wherever interim order is there, 23rd, where there is no interim order, 2nd July, that's all.
Second.
No other submission. Our split charge to be disposed. Yes, madam.
I'm appearing party in person. The
Which
matter
serial
is
number, madam?
97, my lordship. Yes,
97. ಯಾವ್ದಿದು?
97. I'm appearing in person.
This is the deposit into the account.
No, my lordship, the checks which were encashed by the bank.
Ah, that's what, check and cashed.
Checks and.
Freezing of account. I don't know, anyway. When do you want, madam?
Can you give me tomorrow or day after?
Tomorrow ಆಗಲ್ಲ.
The day after?
No, interim order ಇದೆ, that is what is causing problem.
Second?
Not second, ಆಯ್ತು, ಇವ್ರದ್ದು second ತಗೊಳ್ಳಿ, party in person. Second, madam.
Your lordship. Serial number 109.
Ah.
My lords, it's slum clearance matter, my lords.
Further hearing will come on 5th, sir. Don't mention further hearing.
Certainly, my lords.
Apart from further hearing, I'm talking of other matters.
Certainly,
Yes.
my lords. Grateful.
Much obliged.
Your lordship, I have a humble submission. The memo was filed on 30th May.
ಏನ್ matter, sir?
20, it is a, this one multiple petitions filed. Your lordship said
sir.
pending interim order ಇಲ್ಲ ಸ್ವಾಮಿ.
ಕೊಡಿ, ಯಾವತ್ತಿಂದ ಕೊಡಿ?
ಅದು ನಾಳೆಗೆ
ಯಾವ
slate
ವರ್ಷದ sir?
23 ಸ್ವಾಮಿ, ನಾಳೆಗೆ ಸ್ಲೇಟ್ ಆಗಿದೆ. ಅದು ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ಸ್ ಕನೆಕ್ಟೆಡ್.
ಈಗ ಮೂವ್ ಮಾಡಿದ್ರೆ ಆಗುತ್ತಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಮೊನ್ನೆನೂ ಬಂದಿದ್ದೆ ಅಲ್ಲ, ಅದು ಜೊತೆ ಕೊಡೆ ಕೇಳಿ.
Day after tomorrow ಬರ್ಲಿ. ಅದು ಕೊಡಿ, day after tomorrow ಹಾಕಿ.
ಮಚ್ ಒಬ್ರಿ.
ಬೇರೆ interim orders ಯಾವ್ದಿಲ್ಲ, ಅದನ್ನೆಲ್ಲ no disposal. 23rd.
Directed me to give back guarantee so that they can release the money.
ಓ, ಏನಾಯ್ತು ಅದು?
While now bank is asking for fresh guarantees, that's for 60 days have expired. They say unless.
Government ಎಲ್ಲಿ?
Okay, my lord, proposal, one level for the BDF over here.
You are for the respondent.
I will, yes,
Why you have not released?
we had on Monday, my lord. So Vikram Ongole is appearing in this.
Where
matter.
is he?
The fracture is, put my.
Fractured is? ಹೌದಾ? ಯಾವಾಗ ಮಾಡ್ಲಿ? ಯಾವಾಗ?
Next week, I have to furnish fresh bank guarantee and they say without direction.
We'll list it on Friday then.
Very good.
Further hearing ತಾನೇ ಅದು? Further hearing ಎಲ್ಲ Friday ಬರುತ್ತೆ, don't ask anything. Yes. Friday, sir. Why? Why?
Means it fully been advanced.
108, who are you, respondent or petitioner?
Respondent number 2.
It is on Friday, sir. Yes.
Lords, upon the interim order may be extended, my
It will be extended in any case, yes.
my lords. Serial number 109, my lords. The interim order needs to be extended, my lords.
Please don't make, if you mention, I will not extend it. Otherwise, it will get extended.
Yes, my lords.
Settlement today, ಯಾವ್ದು ಮೇಡಮ್ ಅದು?
Speak on.
106, sir. Yes, parties are present. The court is unable to record the settlement. Yes. No, yes. Next week, it's adjourned to next week. Ask the parties to come.
That's one submission with respect to serial number 95 minutes.
90?
95.
Ah.
That's petitioner wife works at abroad. She became a 4 years old pregnant minutes. Now in view of the pendency of this case minutes, visa is denied.
95.
Please minutes.
Day after tomorrow, Hakim.
Obliged.
100 ಏನು madam?
For the respondent to ಅದರಲ್ಲಿ ನಾನು 2 weeks ಟೈಮ್ ತಗೊಂಡಿದ್ದೆ ಲಾಸ್ಟ್ ವೆಕೇಶನ್ ಅಪಿಯರ್ ಆದಾಗ ಮತ್ತೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು ಎರಡರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದೆ ಒಂದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ ಅದಕ್ಕೆ ಮತ್ತೆ again
ಈಗ ಏನ್ ಬೇಕು? ನೀವು ಪೆಟಿಷನರ್ ಈಗ? ಹಾ ಸರಿ, ಏನ್ ಹೇಳಿ? ಈಗ ಏನ್ ಬೇಕು? ಸೆಕೆಂಡ್ ಜುಲೈ ಎಂಟ್ರಿ ಮಾಡ್ರಿ, ಯಾವ್ದಿಲ್ಲ ಅದ್ರಲ್ಲಿ ಸೆಕೆಂಡ್ ಜುಲೈ.
Three FIRs have been registered.
Refer ಮಾಡ್ಬಿಟ್ಟು.
ಅಲ್ಲ,
ಪರವಾಗಿಲ್ಲ, ನಾನು ಸೆಕೆಂಡ್ ಜುಲೈ ಹಾಕಿ.
ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, ಎರಡರಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ, ಒಂದರಲ್ಲಿ ಇರ್ಲಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಅದಕ್ಕೆ ಕ್ಲಬ್ ಆಗಿಲ್ಲ ಜೊತೆಯಲ್ಲಿ ಅಂತೇಳಿ. ಕಂಪ್ಲೇಂಟ್ ಇದು ಸೆಟಪ್ ಸೇಮ್. ಈಗ ಅದನ್ನೇ CID
ಇವಾಗ ನಾನು ಕೊಡಲ್ಲ ಅಷ್ಟೇ, ಸೆಕೆಂಡ್ ತಗೊಂತೀನಿ ಅಷ್ಟೇ. ಎಸ್. Yes, ಆಯ್ತಲ್ಲ ಎಲ್ಲ?
Lords kindly. Yes, serial
ಹಾ,
number
ತಗೊಳ್ಳಿ, ಅದೇನ್
94.
ಪಾಸ್ಪೋರ್ಟ್
94, my lords.
2 minutes you should finish.
Justice, I filed an application, lords, the interim order is granted in this petition, it is a civil dispute. Lords, I am not at all concerned with this case.
Civil dispute ಅದೆಲ್ಲ ಬಿಡಿ. What
please.
is the problem?
Lords, now I have to travel abroad, my lords, to Australia, please, my lords, on the 2nd, my date is fixed. I've gone to.
Date is fixed, for what?
To fly, please, my lords, my
Aye.
passport book, my lords, got closed, I mean, the pages have run out.
Or renew ಮಾಡ್ತಾ ಇಲ್ವಾ?
ಮಾಡ್ತಾ ಇಲ್ಲ, the police have kept it, please, my lords. Though
Police
there is an
ಅಲ್ಲ.
interim order.
Where is the, you made the passport office?
Yes, my lord, not the passport office, my lords. I am-
Implete the passport, get Shanti Bhushan.
Please, I'll do that tomorrow.
ಈಗಲೇ ಮಾಡಿ.
We'll-
Learned Council to implete the regional passport office as a party respondent to these proceedings. ಈಗಲೇ ಮಾಡಿ. Council Shanti Bhushan is directed to accept notice list day after tomorrow in the fresh matters list.
Right.
Copy ಕೊಡಿ ಅವ್ರಿಗೆ ಈಗಲೇ. ಎಸ್ ಲತೀಫ್, ನಿಮ್ದೇನ್ ಪಾಸ್ವರ್ಡ್?
Closure of sawmill by virtue of registration. of
sawmill,
affairs. Lord, I am not seeking the stay of the proceedings to permit them to run the sawmill. Lord, incriminating materials already seized by separate measure. And the wooden logs of 9 pieces are already seized by the forest department. Further, after 5 days, they again comes and closing the sawmill.
After cutting the trees, all the trees which are cut have been stored in his sawmill.
After cutting this trees, he's cutting a sorry figure here.
But those wooden logs were already seized by separate measure. That is on 4/9/24.
ಆಯ್ತು, ಈಗ sawmill ಬಿಡಕ್ಕೆ ಏನ್ ತೊಂದ್ರೆ?
Lord,
ನೀವ್ ಯಾರು ಸರ್?
based on my.
ನಿಮ್ಮ ಹತ್ರ ಒಂದು sawmill ಇದೆಯಾ?
Based on
ಅಲ್ಲ,
my
you are a
complaint-
you are a rival sawmill owner, is it?
No,
One-
it is not my contention. There are 2 contents. I am the.
ಆಯ್ತು, day after tomorrow fresh matters list.
Lord, it's the 5th time the sawmill has been closed, the workers are not to attend the work. And heavy rain area, I am not seeking for the stay, the further proceedings.
Now, the sawmill will be opened on an undertaking that he will not cut anything of.
Without license, I will not take any.
ಈಗ license ತಗೊಂಡ್ ಮಾಡ್ಲಿ.
That is the old debate.
My lord, lot of logs are stored in the sawmill, my lord, and
Thus,
there are four rosewood trees are, they are not my.
ಆಯ್ತು, Tuesday, Thursday. fresh matters.
Till then, Lord, I'll undertakes that, Lord, I will not take without license.
ಈಗ ಯಾರು ಒಬ್ರು ಚೇರ್ ಹಾಕೊಂಡು ಕೂರ್ಸಕ್ಕಾಗತ್ತಾ? ನೋಡ್ತಾ ಇರಿ ಏನ್ ಕಟ್ ಮಾಡ್ತಾರೆ ಅಂತ.
But the person who are
Sir.
selling, transporting the wooden logs, we are buying that.
Not my misleading application.
ಇರಿ ಸರ್, ಯಾಕೆ?
Not the.
Lord, it's a
My
4th
own
time,
services, my lord.
my,
ಇನ್ನೊಂದ್ 4 ಸರಿ ಆದ್ಮೇಲೆ ಕೊಡೋಣ.
Lord,
My lord,
my
in
sawmill has
Karnataka,
closed
going
from
down.
9/5/2024, Lord. And the huge quantity of wooden logs were lying on the outside of the sawmill. Lord, it's a rainy season, Lord.
ಈಗ ಹೆಂಗೂ ಕಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಸುಮ್ಮನೆ.
We are, sawmill is not cutting, Lord. We are using the machineries. Entire machinery has been closed.
Some police stop has to be. That is the reason.
Some full stop we will make.
Some sort of order has to be.
ಸದ್ಯಕ್ಕೆ ನಾಡಿದ್ದವರೆಗೂ ಕಾಮ. Full stop day after tomorrow.
In the fresh matters.
Yes, sir.